Good morning, good morning. How are you guys? It is a bright, sunshiny day, and I have coffee. I have a stream that should be starting soon. Good morning, everyone. Good morning, good morning. Hi, today is Tuesday. It is rebuttal day and closing arguments day in the Hannah Payne case. And guess what? Tomorrow, they have a jury picked for that Bryce Rhodes case that I was telling y'all about. And that one will be starting probably tomorrow. So, what do y'all think about that one? Should we do it? I'm kind of excited about that one. That one should be pretty interesting. I was really intrigued by the whole Daryl Brooks case. I know it's a totally different situation, right? But very similar kind of character. But I think that this Bryce Rhodes guy is probably going to be a little harder to handle than Daryl Brooks. So, we have in the chat Mickey, who is early. She says, I'm early. Good morning, Mick. Yeah, okay, I put this in here earlier. So, heads up, please subscribe to the brand new crime channel for future live trial commentary and trending true crime stories. The link is in the pinned comment in the chat. So, that is a brand spanking new channel that I made late last night, early this morning. So, my plan is once this finishes, as long as I'm able to go live on that brand new channel, then I will probably start the next one there. Just makes sense to do that. And I will probably download this trial coverage that we've done here and eventually move it over to that channel too. I just have to find out how to do that, like figure out the ins and outs of that. So, but I'm excited. Excuse me. Good morning, JC. Good morning. Good morning. Dale said, I heard Dale cough, and I was reading Mickey's chat, and I said, Dale said my prayers. Mickey said her prayers. Her coffee is done, taking her old peeps medicine, crocheting rabbit ears and legs. Fun, fun, fun. JC's already took her old peeps meds. She got a new diamond paint, or got a diamond paint kit with a sloth. Showed it to her husband, and he said, is it like that glitter stuff that's going to be all over the house? No. No. I mean, it could possibly be, but that's not the intention, right? No. You got to get the little pots and the little containers to put all your little diamonds in so you can keep it all organized. Mickey said, JC, yay, I'm excited you got a DP. Yes, you may have drills all over the house. Not really, but it could happen. Yeah. Could potentially. Good morning, down south Stitcher. How are you? Good morning. I See that, Mickey? Isn't that exciting? That's so exciting. The glitter is only in your craft room. He's doing the most. Well, yeah, I know, Mickey, right? You wake up with them stuck to you. Yep, I do that too. Yep, I found them on the dog's nose, in the baby's diaper. Just, you never know where they're going to end up. Little ones everywhere. Mm. Mm-mm-mm. So, interested to see how this is going to go this morning. Um, Interested to see if Hannah has like her game face on. My biggest thought, the biggest thing for me right now is I'm wondering how long it's going to take the jury to decide. You know? Yeah. I'm sure that they'll be deliberating, I don't know, maybe possibly this afternoon or this evening. I don't know. It really depends on how long their rebuttals are going to be, right? Good morning, Karen. Good morning. Good morning. Good morning. What's the weather like where you guys are at? It is chilly here today. Everything's a little frosted out. Uh, it is 9:01. Hopefully, this feed will start soon. I get so impatient. I get so impatient. Oh, is it cold? Cold for you, Karen? Mm. How about you, JC? I know what Mickey's weather's like. Mickey's weather is the same as mine. New Jersey. Yep, it's pretty chilly there. Yep, yep, yep. Hmm. Oklahoma? Okay. Nice. Karen says, I keep thinking about this trial. Yeah, Karen, I think you and I both just got talked about that, mentioned that yesterday about how we thought about it a lot over the weekend. Yeah. So there's this case that's going to be coming up. Um, I need to double check and see if it's changed or anything because they do keep delaying things. But the case is about this mom, if that's what you want to call her. She doesn't deserve that title to me, but anyway. Her name is Lisa Snyder. She's from Berks County, Pennsylvania. And I don't remember the year. I want to say 2019, maybe 18. Um, I'd have to look and see. I'd have to Google it. But she had um, killed her kiddos and blamed it on her little boy. So But I followed that case pretty heavily when it first happened, and I am eager for her to go to trial. I'm eager for that. Been waiting and waiting and waiting for that one. Good morning, Freeze. You're back. Good morning. Good morning. Karen said, I feel so bad about the choices that were made. I know. I know. It's like just one bad choice after the next. One bad choice after the next. You guys were talking about your old person your old peeps medicine and stuff a while ago. I took my old person medicine a while ago too. Took my thyroid medicine. Gotta love that thyroid medicine. And I'm sitting on a heating pad. My lower back is about to yeah, I don't know. Break me in half. I've been walking around like a hunched over old woman all morning. I tried doing the whole, stretching over and touch your toes, see if I could stretch it out, but nah. Um, hey, good morning, Gail. Good morning, all caught up. All caught up. Good deal. Good deal, Gail. Karen says I'll have to watch about that case, Jenny. I wasn't familiar. Yeah. Yeah, it was a bad one. Bad one, bad one, bad one. I might do like put together some information and do like a recap of that one before the trial actually happens. That would be pretty cool. I might do that so I can like fill you guys in on that case. You know how you have those cases that just really get to you, right? That's one of them for me. So, yeah. JC says blood pressure and medicine or multivitamins. Sorry, misread that. You guys are uh, sharing your old folks' medicines. hmm. Free says, I'm a proud Clayton County representative. Oh, well, there you go. There you go. You live in the area? JC says blood pressure and multivitamins. Ooh, 30 degrees, Gail. Sounds about the same as here. Which case? I missed that. They arrested someone else the other day in the Crystal Rogers case. Yeah, I heard that, Mickey. I think it was the guy's dad, the Hawks guy's dad, or something like that. The case I was talking about was the Lisa Snyder case, the one that I've kept going on and on and on and on and on about forever and ever. Um, Karen says I'm not going to list my medicine. Too long of a list, huh? Um, Keeps waiting for them to arrest Brooke Houck's brother. Yeah. Mm. Is Clayton County a small place? I like Mary Ruth's Organics. I bought some of that for my kids, JC. They have pretty good stuff. You can buy it on, I think you can get it at Walmart, but you can also find it on Amazon, Nikki, if that's, but it is a good brand. Mm. Oh, co-workers, or they worked for him. Both guys arrested. Okay. Um, yeah, and they have all different kinds too, Mickey. Like they've got that Mary Ruth's brand, they've got a lot of different ones. And you can also like the ones that I got for the kids or the dropper kind, the liquid dropper ones. Because neither one of my kiddos want to eat the like gummy vitamins or the like chewable like Flintstone. Um, so it's easy to just drop the liquid vitamins in their juice. You know, easy for me to do that. And the juice kind of hides any flavor. Ay, ay, ay. New folks that are coming in, I would love for you to, if you're here for the crime stuff, I started a brand new channel, um, and it is scrolling across the screen, and the link is also pinned in the chat at the very top that you can click on and go over there and give me a subscribe. As soon as I get the green light to go live on that channel, because you have to wait for so long before they'll let you go live on a new channel. So as soon as that goes, as soon as they give me the green light, I'll start doing um, the true crime and trial coverage over there. Um, that's the plan. You need this canary, Jenny. Jolie would love him. No, no, nope. My dog would eat him. Yeah, my dog would eat him. That's a no. Big no. Let me just check and make sure that we are okay. We're still live over here. Um, but that would be fun. I mean, they're pretty to listen to, but no, thank you. No, thank you, Mickey. No, thank you. Hmm. I'm bringing the canary and turning him loose in your house. No, he won't. You do that, Poppy will definitely have a heyday. Green light, who they think they are. Being all bossy, they ain't the boss of everything. I know it, right? They think they are. I like the name of the new channel. Thank you, JC. I'm not 100% stuck on it, but I thank you guys. I appreciate that. I'm not 100% glued to the name. Luckily, you can change your names on YouTube, like your channel names, as many times as you like. Um, so, we'll see. I just really made it a placeholder for just a place to start putting, a new channel. So I just needed a placeholder to start putting actual um, crimey things over there. So, yeah. Mickey, I literally, uh, yeah, no, I literally just last night or early this morning, I don't remember which, just plopped that name out and and was like, okay, this is what we're going with for now. For now, for now. So we'll see. Nice try, Mickey. Yeah, nice try. Nice try, babe. I'm Mickey's older sister, so she says, according to her. Ay, ay, ay. I want to get that game, Mickey. Do you remember at the retreat when we were playing that game that my friend Randy had brought? It was that old game that she said she'd had forever and ever in her family, where you all have to like hold and don't be the last one to let go or you get shocked. I want to get one of those. I think that would be so fun. I think that would be super fun. Uh, oh, you have an older sister, Karen? Is that what you're saying? Or you mean the game? You should have been the older one because you have to keep me straight. Oh, you think we would break it? Nah, I don't know that we would break it. The kids might break it. I can just see us playing it at Christmas time, though. What? That would be a lot of fun. I do have to keep you straight, Mickey. That's true. Oh, okay. Gotcha, Karen. You have an older sister. I have two older sisters and an older brother. I'm the baby of the family. I'm the baby. Baby, baby. I keep thinking about this Bryce Rhodes story. Hey, Joanna. Good morning. Good morning, Jay. Oh, JC says I'm the baby out of 10. Wow. Wow. That's cool, JC. Gosh, what was it like having that many? What's it like having that many siblings? I mean, I'm sure by the time you came along, half of your siblings were already like grown and out of the house, right? Hey, Joanna. Yes, baby. We are waiting on this feed to start. They're taking their time this morning, but it's supposed to be rebuttal and closing argument day. Karen is the baby out of 3. Wow. Mm. They're jealous of you. I'm more mature than they are. mm. 10 kids. Wow. Oh, wow. Cannot imagine having that many kids. I can't imagine having more than the 2 I've got. Honestly. 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 You were all in the house together, JC, at the same time. Oh my God. I bet your folks wanted to like pull their hair out. I know, Joanna, right? They had their own little city, their own little baseball team, their own basketball team. their own bowling league. I mean, they had everything. Crazy. Every day is a party. Mm, I would imagine so. I bet your mama stayed busy, said Mickey. Yeah. You guys, I'm going to be right back. I'm going to go grab a couple things before this party gets started. Um, mm, I say that jokingly, by the way. I know this is a big day for both these families, so. Ay, ay, ay. Thoughts and prayers go out to both of them, honestly. Honestly. I've got my coffee, Joanna, but I need to grab an ink pen and a notebook and uh, probably take another wee break, might as well, and let Poppy out to use the potty. So, so yeah, I will be right back. You guys just talk amongst yourselves in the chat, and I will see you back in just a second. I'm back. I'm back. Everybody behaving. Everybody behaving. Everybody was kung fu fighting. Da-da, da-da, da-da. Sorry, I'm a singer. Can't help it. Can't help it. Let's see. Oh, Corky Beans. Court delay due to a juror being stuck in traffic. Okay, okay, okay. Good to know. Good to know. Thank you for that. Oh, I see Lee's here. Yay. Ah, Joanna says, take your time. We will talk about you. Yeah. You crack me up. I love you, Joanna. Irish mom, we were free range. I love that. Jenny lives just around the corner. I'd never make it if she didn't live close by. I love you, Mickey. Lisa's walks in and sets up breakfast. Oh my goodness. Plenty of coffee, scrambled eggs, waffles, pancakes with a wide assortment of syrups and various fruits and juices. You, Lee, I cannot stand you. You are the cutest. I love it. Thank you. Everybody eat up. Eat up, eat up, eat up. All you can eat. Ooh, Mickey said scrambled eggs. Thanks so much. I was craving them. That sounds good, actually. Yeah. Karen says perfect timing, Lee. Perfect timing. Uh, oh, Mickey's love bombing me over here. She is the older sister. She admits it, and she admitted that she loves me and that I'm sweet. JC says we're blessed here. You are blessed, Mickey. My dad retired at the AFB in Texas, and I live in Oklahoma, but the other siblings are not close by at all. Joanna said, "Thanks, Lee. I won't be here long." You only slept 2 hours. Goodness gracious. Buffet style. Help yourselves. Yes, yes, yes. Daddy used to call us Lucy and Ethel. I was Lucy because I have harebrained schemes. That's the truth. Thanks again, Corky Beans, for the update. Thank you, thank you. Oh, I see a judge.
So I apologize for the delay in commencing. We were waiting for one juror to get here, but they're here and we're ready to go. Is there anything that the court needs to address before we begin?
Yes, can we refresh for this?
Yes, yeah.
She has a cute top on today. Cute top. Oh, here Freeze says Clayton County is not a small place. It's 10 to 15 minutes outside of the city of Atlanta. Oh, okay, wow. So, yeah, it's a nice big spot then. Um, she looks very, very nervous. Yep, starting with a sidebar already, Lee. I know, I've had a few harebrained ideas myself. Wonder if Grinch is going to be in the courtroom today or if he's going to be in our chat today. He may be there with the family. That little old lady is right there again today. I wonder if she is like a relative of Mr. Herring, Kenneth Herring. I wonder if she's a relative. Sister, mom, would she be too young to be his mom? Maybe too young to be his mom. He was, what, 62? When he died, and this happened 4 or 5 years ago. So it'd be about 66, 67. So his mother would have to be about at least 85, 87. So I'm just guessing, sorry. I'm just sitting here in my head thinking if that could potentially be his mama.
Good morning, ladies and gentlemen of the jury. Trust you had a good night. Just a reminder, I know it's been a long, arduous week, but when the court says 9 o'clock, we intend to begin at 9, and so just encouraging compliance with our time frames. Thank you. When we broke yesterday evening, the state was about to present rebuttal testimony, and so we're going to give the state an opportunity to do so and call its witness.
Thank you, Judge. The state calls Keon Hayward.
Who is this guy?
And if you would please remain standing and raise your right hand. Do you swear or affirm the testimony you'll give before the court in this matter will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
You can take your hand down and have a seat. If you would please make sure you're moved up and speaking into the microphone. If you would introduce yourself to the jurors, please.
Hi, good morning. My name is Keon Hayward.
And could you spell your name for the court report?
Keon, Keon, Hayward, Hayward.
And how are you currently employed?
I'm currently employed with Quick Trip Corporate in their division of protective services.
So working security at Quick Trip.
Correct.
And where are they based?
I'm based in Charlotte, North Carolina.
Okay. And did you travel back here for this case?
Correct.
Back in May of 2019, how were you employed?
With the Clayton County Police Department.
And describe your experience in law enforcement, your experience in training that qualified you to work for the Clayton County Police Department.
I was certified through the basic law enforcement here in the state of Georgia, and I worked there as a uniformed police officer for 3 years, and then I worked in the criminal investigations division and major felonies for 3 years.
So back in May of 2019, were you a detective assigned to work the case involving the defendant, Hannah Payne?
Correct.
And just to kind of go a little bit about through some of the things that you did for this case, did you respond to the actual scene where the shooting took place?
Correct.
And is that scene located in Clayton County?
Yes.
And did you also gather evidence?
Correct.
In this case, did you instruct certain witnesses to be interviewed?
Correct.
And photographs to be taken?
Yes.
Was one of the things that you did in this particular case was to conduct an interview of the defendant, Hannah Payne, at the Clayton County Police Department?
Yes.
And were you aware that she had been transported to the Clayton County Police Department in the back of a patrol vehicle and in handcuffs?
Yes.
Therefore, did you advise the defendant of her Miranda warnings?
Yes.
And did you do that using a written document?
Correct.
I approach the witness with what's been pre-marked State's Exhibit number 38.
You may.
Showing you what's been marked as State's Exhibit number 38, do you recognize this document?
Yes, I do.
And how do you recognize it?
with my name and signature, and the list of the Miranda rights also signed by Ms. Payne.
And that's a copy of the original. Is the original of these documents, is it always kept in records at the police department?
Yes.
And is there anything that about State's Exhibit number 38 that has been altered or deleted in any way?
No.
State Tender, State's Exhibit number 38.
Any objection?
No objection, Your Honor.
Admitted without objection.
And when you have a person that you're interviewing go through these rights, is it often that you have them put a time on what time they have signed this waiver?
Yes.
What time did the defendant sign her waiver, and what time did she begin speaking to you in this case?
At 8:47 p.m.
On the day that the incident occurred, May 7th?
Correct.
And if you would, please indicate the first right that you advised the defendant that she had.
She was advised that she had the right to remain silent.
And did she initial next to that indicating her understanding?
Yes.
The second one?
Anything she said can and will be used against her in the court of law.
And did she initial that?
Correct.
Indicating her understanding? Yes?
Yes. Yes, I'm sorry.
And right number 3?
You have the right to remain, you have the right to talk to a lawyer and have him present with you while you're being questioned.
Number 4?
And if you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish.
And number 5?
And if you decide at any time to exercise these rights, not answer any questions or make any statements.
And did she initial all 5 of those indicating her understanding of what she was being advised?
She did.
And the statement indicating I have been advised of my rights and I understand each of those rights, did she also provide her signature acknowledging that as well?
Yes.
There isn't any.
In order to get the defendant to sign that Miranda waiver, was she threatened in any way?
No.
Was she promised anything?
No.
Was she offered any hope of benefit whatsoever?
No.
And based on your observations of the defendant on scene, did she appear to be signing that Miranda waiver freely and voluntarily?
Correct.
Did she appear, based on your observations, to understand the questions that were being asked and the things that were being discussed?
Yes.
And also, based on your observations of the defendant, did she appear to understand why she was being interviewed?
Yes.
And once you advised the defendant of her rights, did she indicate to you that she would speak to you?
Correct.
During the course of that interview, did the defendant ever invoke her right to remain silent?
No.
Did the defendant ever invoke her right to counsel during the portion of your interview?
No.
And again, in order to speak to you, was the defendant threatened in any way?
Not at all. No.
And have you had an opportunity to rewatch the defendant's interview?
Yes.
And based on your observation of that, did the interview contain exactly your conversation with the defendant on May the 7th of 2019?
Yes.
Can you talk to the jury a little bit about how the interview room worked at the Clayton County Police Department back in May of 2019?
Yes. Typically, the interview will be comprised of the individual being questioned and 2 detectives will sit in and ask the questioning at a table. It is recorded, audio and visually recorded, and we have conversation and we ask questions in regards to the matters of the case, and that person respond.
And the things that are being recorded, would you then have any ability to go in and change anything or anything like that?
No, I don't have any ability to alter that.
And have you watched various interviews that have taken place in those interview rooms?
Yes.
And are you aware that even though you can't alter it, sometimes the audio and the video are like a second off from each other
Yes.
when you watch it?
Yes.
And you this week had an opportunity to rewatch the interview, is that correct?
Correct.
Your Honor, at this time, the state is going to tender State's Exhibit number 39 with the exceptions of the things that we have discussed at the bench that we will place on the record.
Any objection?
The same objection we had at the bench when we talked about it, about things that would be in the minute, and I think we agreed that certain things would not be discussed, and as long as everybody follows the guidelines, I would have no objection.
Okay, admitted without objection.
Permission to publish, Judge? as we discussed, there are some times when the defendant is alone in the room that we're not just going to watch her sit there for 45 minutes.
Correct.
So we have, both sides have agreed to move it forward. And there are a couple of other sections that have been, by agreement, that aren't going to be admitted that we will move forward as well.
Correct.
One moment to get it. Just, this is one of the moments where we're forwarding where she's alone.
Okay.
And just make sure that when there's a big gap that you describe how long the gap is.
I think she just placed it on the record, but you can again.
I just moved the times. I can't tell you exactly where I stopped, but we're moving forward. She came into the room at 7:37:56. We watched 15 or 20 seconds, and we're moving forward to 7:53:40. Ish. It's actually 7:53:33, which is the closest I can get.
Thank you, Brenda. Hey, beautiful Tia. Hey, girl. So she's like, this is, I guess, where she takes her fake nails off. So she broke a couple during the incident, and now she's taking them all off. Wonder if some of it's partially just nerves, like, you know. I'm a nail biter. I mean, so if I were sitting there in her shoes, I would probably be chewing my nails off too.
Judge, I'm going to pause it at 7:57. Detective Hayward, for the record, the minutes that we've just watched, were you able to observe the defendant removing her own fingernails and putting fake fingernails and putting them in her pocket?
Correct.
And does she continue to do that until they're all gone?
Correct.
Judge, at this time, we're going to move forward until 8:40, 8:30. The defendant is alone in the room until that time.
Okay.
Closest I got, it was 8:40, 8:16.
Okay.
And you're okay? I'm sure you're not. More. This is Detective Hayward. You met him, have you met him yet? Have you ever watched, like, TV or anything like that? So you know, before we talk to you, we're going to read you a statement, okay? So if you understand what I say, I just want you to initial the fact when I read you, okay? How old are you, ma'am? 22. Okay. You have the right to remain silent. Anything you say can will be used against you in court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statement. Read the next line for me, please. And if you understand what we just talked about up here, what you just read, sign right there, and then the date and time. It is 5/7/19. It is 8:47. Before we get into anything, I just want to ask some background. I know they probably already have your information, but I don't. I'm just now meeting you for the first time. What's your name, ma'am?
Hannah, H-A-N-N-A-H. Payne, P-A-Y-N-E.
What's your date of birth, ma'am?
0515-1997.
And your address?
315 Claire, C-L-A-I-R-E, Avenue, Fayetteville,
1514.
14.
And a phone number, please.
470-512. It's a management company called Triship, T-R-I-S-H-I-P Partners, LLC.
And where is that at?
The home office is in Hayesville.
Okay.
Awesome.
So So you're in not work today? Okay. How long ago, what hours work you on that?
I had gotten off of work, I was going home, and I was coming down Clark
Okay.
turning left onto Fourth Parkway. There was a semi that was in the lane to the right of me, and he was a little bit further in the intersection than I was, like the light was green for us. And out of nowhere, this guy came down through the intersection, and luckily I stopped barely in time, but he ran into the semi.
Then y'all were on Park Howell and you're trying to come out on the Fourth Parkway. And
He came straight through.
so we kind of take questions like from 85 in Riverdale or from Riverdale?
From 85 and
Okay, I got you. Okay, go ahead.
And so after I realized what had happened, I was able to go around him, and I pulled up on the sidewalk and I parked. So I called the police. I got out and I walked over to see if everyone was okay. I was talking to the truck driver and another witness who was also a police officer who saw everything happen. And the guy who was driving the truck ended up getting out and was just kind of like looking around like, well, what happened? And he said, someone hit me. And we're like, no, you just ran the red light. And he was kind of stumbling and walking out in the middle of traffic. And after about 20 minutes had gone by, I went back across the street and I was calling my parents. I kind of had a realization that I decided to take a chance at life that I felt I was scared. So I called my parents and I told them what happened. And while I was standing over there, when I called back, I realized it had been over 20 minutes. And I told the dispatch that he was sitting in his truck and he was revving the engine. And it looked like he was going to pull away. And at that time, he did. He took off.
Okay.
So I got in my Jeep and I followed him. And I told the dispatch that I was following him. And she told me that she didn't advise it. And I told her that I was just getting his tag number. I got the tag number by the time we got to the end of, right when I got to Riverdale Road. And we came around that curve, and I had an opportunity to get in front of him.
Okay.
I got in front of him, and I stopped in front of him. I got out, and I was on the phone. I told him, I was like, you need to stop, you need to pull over. And he's like, who are you, and who are you? And I'm like, I'm just no one, but I'm on the phone with the police. And that's when I was like right there behind him, like, you know, who are you, who are you? I got something for you. I'm like, okay. And I said, I'm just telling you, you need to stop, and you need to pull over. And that's when I had my phone in my hand, and I told him, I was like, you need to stop, and I'm right there by his door at this point. He reaches out and kind of like hit my phone out and grabbed my wrist.
Okay.
He grabbed my wrist. We kind of started going back and forth, fighting, and that's when he punched the gas and he ran into my tire. And he's telling me the whole time, you know, oh, well, I don't know who you are, blah, blah, blah. And he was leaning back, when he pulled me, I got something for you, reaching. And I don't know if he's reaching, I wasn't watching him, I was trying to pull away from him. And I had gotten him off of me, but he had my shirt, and that's when he ripped my shirt. He was pulling it. I have it underneath.
Okay, all right.
Because it was all a little bit.
Okay. I just want to see that, and I'll go out if we can have somebody. Yes.
He's pulling at it, and that's when I told him, after he's reaching, I told him, I said, I have a gun, I said, and I will shoot you. And that's when I reached for it. And because I hadn't reached for it and I touched for it the entire time, I reached for it, I pulled it out, and that's when he pulled, when I pulled away from him is when, because my shirt ripped. It's not that he let go. I had it out at that point. He was still coming at me, still yelling at me, I got something for you, you know, you want to shoot me, then shoot me, do it, do it, do it. And he went forward on the door, and I pushed it forward with my knee, went back forward, pushed it forward, thinking he was trying to get out. When I told him no.
Did the door open at all, or did it not open?
He was pushing at it. Like he reached down, he went like this.
Okay.
So from the angle that I was at, I don't know if it opened or not, but I could hear him grabbing the door handle. I could hear it, you know, like just pulling at it. And so that's when I pushed the door forward, and he grabbed my hands, and we were going back and forth. I didn't have my hand on the trigger, So we were going back and forth, and he was holding it, and he was twisting it, and then that's when I actually got my grip on it. And he was turning it, and then he got faced almost all the way around when I pulled it back, and he lunged again, like with one hand on me, and he lunged and he swung, and he grabbed, like right here on the back of my shirt. And when he grabbed is when I don't know. I don't remember telling myself to pull the trigger. It just.
So did you have your finger on the trigger?
Yeah.
So when you're holding the gun,
Yeah,
you
so I had it,
it's inside the trigger part.
how it's like this, I had it like, originally I was holding it like this.
Okay.
I didn't have it inside, and he's reaching and turning and twisting, and as he's turning it, he's, pulling, and we're going back and forth. So of course, I bought it for protection.
Mm-hmm.
Not that I have any intentions on ever trying to use it, but I was trying to get prepared for whatever I need to be prepared for, thinking I'd be able to pull away and then just go, get away from him, and that's not how it happened. So when he was pulling at me, and that's when my finger, I put it on the trigger, and he's pulling and pulling, and
Before this day, have you ever seen that man before in your life that you know of?
no, I haven't ever.
I know it's probably hard for me to talk about, but we just have to like slow it down a lot. And you told us what happened, but I just want to like things by things by things. So you pull around and you stop in front of him, and what happens is he stops behind you.
Yeah.
How far between cars would you say? Like close, like far, like?
Maybe almost the length of this table.
Okay. And then what happens then?
Then that's when I was on the phone with dispatch, and he was asking me, he's like, who are you, and I told him.
Wait, so you're out of the car at this time?
Yeah, I had walked around and told him, you need to stop.
Okay, so
You need to pull over.
which side of the car were you on?
I was on his driver's side, and I was at the back of my car.
So y'all on the right side of the road. I'm just trying to, because I know that intersection lot. So it's like when you come around and you get onto 85. So before the ramp.
Yeah.
Okay. So you're right in front of him.
That's kind of a crosswalk.
Mhm, gotcha.
Right there.
Okay.
And he was right here, and I had come around, and I was right here.
Okay.
And when I stopped, I got out and I walked around,
Okay.
telling dispatch, I'm on the phone. I was on the phone with her, and I told her, I said, I'm here. I said, and he stopped. And that's when I told him, you need to stop. You need to stop.
Okay.
And he's like, who are you? I said, I'm no one, but I'm on the phone with dispatch. I'm on the phone with the police. You need to stop. You just caused that accident. And he's like, yeah, okay, I got something for you. And that's when he pulled forward.
So he, at this time, it was just words being exchanged. There was no contact at all yet.
Right.
Okay. So he pulled forward how? Like his car went how far forward?
All the way forward to my Jeep.
So it struck your Jeep?
It did, yeah,
Okay.
it did.
You said it struck the wheel. It struck the wheel, or that wheel on the back, like
No, the wheel on the side of the Jeep.
the actual.
The actual
Okay.
side.
I got you.
And that's when I was telling him, I'm like, you need to stop. And that's when he was reaching.
Okay.
He hit my hand. I don't know if he did it intentionally trying to throw my phone.
So you're standing. So these are the two cars, this is the car,
Mhm.
and he's inside the car here. You're standing right at his passenger.
Right here, so this is where my car was, right
So
here.
you're so it's like an angle in front of him. Okay. So you're angled in, he's here. Yeah. Okay. So you're standing right.
Where the volume went, Judge.
Are we gonna need some assistance from IT?
Try it again. I don't know why it just went suddenly silent.
I believe they had the transcripts yesterday. And I think for some reason they come back and just think you use that with the technique.
really would think that with them
I
having
called for some assistance.
Yes,
but
okay. So
it's
you're
not-
standing right here.
I came around, I was standing right here,
Okay.
and that's when he went forward and he hit it, and I told him, whoa, I said, because you need to stop. I'm like, the police are right here, I said, you just need to stop. Okay, I got something for you, and I'm telling him, and of course, I'm telling him, from a distance, but I'm telling him, just stop,
So at this point, you're saying stop. No gun in hand, no nothing.
No, nothing, yeah.
Stop. Okay.
And that's when, because I had my phone in my hand, with
Okay.
dispatch. And so that's when, of course, I'm closer to the car now, partially because he's more forward and partially because I went forward.
Okay.
And he's telling me, he's like, yeah, okay, yeah, I got something for you, which is when he hit it. When I got closer, I was telling him, you need to stop. I'm telling the lady on the phone, of course, I can't hear her because I have her on speaker and all this is going on around me. And that's when me and him, he swung at my hand and he grabbed me by my wrist and he pulled me in.
So at that time, still no gun out. Nothing.
No.
So phone in hand.
Right. He swung it.
So hit me how he hit you. You're holding like the phone like this.
That's what it was, I had it in my right hand.
Okay.
Yeah, and he's right here.
Okay. Don't hit me, but
Right. Well, with this hand, I'm telling you, you
Stop.
need to stop.
Okay.
And he just like, he went like this, and then he grabbed me, and
He grabbed which hand?
my right hand. I'm sorry, my left hand.
The phone, not the phone.
Not the phone,
Okay.
right.
I got you.
But when he did, which honestly, I don't know what hand, how he lunged it first, but when
Okay.
he lunged, it hit my phone, but
Okay.
knocked it out of my hand, and he grabbed
Knocked
me.
it out to the ground.
Yeah.
Okay.
And it shattered the screen.
Okay.
And then he grabbed me.
How?
He was like this.
Okay.
And that's when me and him were going back and forth.
Okay.
But it was more me in the vehicle than it was him out because he's pulling at me, he's tugging.
Okay.
So he's pulling, we're going back and forth, he's hitting, he's swinging. I'm trying to hit, but I'm also trying to pull away because the only thing that I know for protecting me and this man is what I have on me.
Mm-hmm.
Now, by this point, I'm telling him, that's what I'm telling him, I have a gun. I said, and I will shoot you. And I'm pulling. This hand was free. I'm trying to just get away to get my phone.
Mm-hmm.
I couldn't. So then, that's when he's saying, yeah, okay, I got something for you. Something about, I don't even know who the F you are, you're nobody or whatever. And that's when I pulled it out because he's leaning, saying, I got something for you. This is him, he still had my hand.
Okay.
He's saying, I got something for you.
And you're leaning back away from the car?
Yeah, well, I'm being pulled in, but I'm trying to pull away, and that's when I pulled it out.
Okay.
And I told him, I said, I told him, I said, you need to stop, that I had a gun and I was shooting. And he's like, yeah, okay, shoot me. And that's when he lunged, he let me go, but he lunged, pushes the door open.
Okay.
Which is when I thought he was pushing the door open. He leans forward, and he's reaching again, that's when he grabbed my shirt, and it ripped it.
Okay.
So then when he's reaching I already had it forward, reaching and it ripped, and I'm thinking here is when I'm trying to say I'm going to get away with the door thing.
Mm-hmm.
He grabs my hand with the gun.
Okay.
We're wrestling with it inside, and that's when he's turning it, and I managed to get it back towards him, and that's when it went off.
Okay. So you pull up the gun. You're right hand or left?
I'm right, and
So you
I
had
have
it
it sealed
on your right
on
side.
my right side.
Okay. So you pull up the gun and what happens? So he still got a hold of you or he does not have a hold of you?
He got a hold of my hand when I pulled it out.
Okay.
But then that's when he lunges, he didn't lunge, but he grabbed the door.
Okay.
So he grabbed the door.
Is he still holding you or is he let go now?
He still holding me in the beginning.
Okay.
In the very beginning, which is when he grabbed the door.
Okay.
He goes to push the door open, and when I got away, but he had my shirt,
Okay.
and that's when my shirt was ripped.
What kind of shirt do you have on?
It's a
like buttons or no buttons or just okay?
But it has like a hole type thing in the middle that he was able to grab onto.
Okay.
Which, it's just,
I know it's hard. Take your time if you need to.
I never thought I would
Nobody ever does. Okay.
And, okay, so I had it in my hand at this point.
Okay. Are you pointing it yet, or are you, where is it? Is it pointed at him?
It's up, like this is the window, and I pulled it out like this, trying to get him away from me, trying to get off. He still has a hole in my shirt. When he pulled away from the shirt is when the door happened.
Okay.
I pushed the door with my knee, and
Do you think the door opened at all?
I went forward when I pushed it, which is
So
why
the door was open, it had to have been open. Okay.
I mean, and that's where all the marks came from on my jeans with the outside of his car.
Did the photographer take pictures of you? No.
No one did talk to
Okay,
me.
we're gonna need to have it, take pictures.
Okay, so he was, when he still had me when I pulled it out, and I'm telling him, he's like, yeah, shoot me, I got something for you, And then I was up, I had pulled it up, and that's when he had a hold of my shirt ripped, he grabbed the gun.
Okay, hold the gun, grab the gun, you ready? Yeah. Grab the gun.
So he's trying to turn like this, and I'm trying to push up against the door. After my shirt was ripped, he went like this.
Okay.
And he was pulling at it, but my hands were just on
Okay,
the side, and yeah,
okay.
so he's pulling at it, and he's pulling at the trigger area, in the trigger.
His hand is in the trigger guard?
His hand is in the trigger guard, yeah.
Okay.
And that, I mean, the specific reason why I bought the one that I bought was because it had the double
Gotcha.
safety mechanism.
Right.
So I wasn't too worried, I guess, because I didn't have my hand all the way on that. On the
Okay.
back, I could tell.
Okay.
So he's pulling at it, and that's when he's going like this, and he's turning it.
Turn it away from himself.
Yeah, and he's trying to, and that's when he grabs it. My fingers and his fingers were both in it, and he's trying to pull it, and that's when I'm trying to pull my hand out, but I'm not trying to leave the gun there, obviously.
Right.
So he was pulling it and turning it, and that's when I was able to kind of just like yank it back towards him, and he had it like this. And he's like, yeah, just shoot me. And that's when he lunged. He still had a hold of my hand right here.
With the gun?
Yeah, so
Okay.
my hand, and he lunged, and that's when,
Okay.
yeah.
Now, do you think that he pulled the trigger, or do you think that you pulled the trigger?
What I told them originally was that I felt like he did.
You
Because
think
I
he-
did
okay.
not have my finger. I know about the double safety mechanism, so that's why I specifically did not have my finger on the trigger.
Okay.
Now, when I pulled it back around, after he was, tugging at me and he lunged, he still had his hand on it, and I had my hand in on it.
Okay.
But it was more so of a matter of force instead of me saying, okay, I'm going to pull the trigger.
Okay.
Does that
Yeah,
make
when
sense?
and you're talking about the double safety, I'm not familiar with what kind of thing you're talking
Springfield, an SD 9mm.
about. Okay. When you're talking about it, is it like a double trigger? It's like a trigger and then another trigger, and you have to pull them both back in order to. Okay.
And then also on the back of the handle, there's also like a
Switch, like safety switch.
it's like a almost like a I don't know how to yeah, there's a button.
Oh, if you're not pressing that, it's not Right.
This part, if you're not actually holding it properly, it's not going to.
Okay.
Which, when he first had it turned, I heard it click, like the trigger was pulled, and that's before I had it pulled down. Before I had my finger pulled down, but because I didn't have my finger on that back part, it didn't do anything.
Gotcha.
So he's pulling and he's fighting, and that's when I put my finger on the trigger, and he still had his hands on my hand, so that way both of our hands was in the, I don't know, the trigger.
The trigger guard?
Trigger, yeah,
Like a little circle thing?
inside.
Yeah, okay.
His hand. And I'm pulling, and that's when it went off.
Okay. Never seen this man before.
No.
Will you write me a statement saying what you just told me?
I have 3 questions.
Oh, okay.
grab all three at one time. So make that more clear to me.
So the first thing that he grabbed was my hand with his right hand.
Okay, at this point, there's no gun on you.
There's no,
Not
it's not out.
Right. All right,
But
first
he
thing you
grabbed-
grab is your shirt. Where at on your shirt?
No, not my shirt. He grabbed my hand.
Okay, grab your wrist.
Yeah. With
All right.
his right, he grabbed my left wrist with his right hand.
Okay.
And that's when me and him were fighting, going back and forth, hitting. And that's when he's telling me, he's like, okay, well, I got something for you. I got something for you. He's twisted and turning and he's leaning back. So then, after that is when I told him that I had a gun.
All right, let me go back to where the wrist is grabbing. At what point were you inside? Were your arms inside of the vehicle? Or did he have to lean out of the side of the window to grab you?
He had to lean out. Because I was right at the window, so it wasn't.
Were your arms right from the window when you was talking to him?
No.
What was your hands doing besides the cell phone? What was his hand doing?
So if this is the window
Mhm.
and this is inside the car,
Mhm.
I'm telling him you need to stop. Because my hand's right here and I'm on the phone with the police.
Mhm.
Now, I wasn't,
Was he stopping at that point, the vehicle?
yes.
So why didn't you say I tell him to stop if he stopped?
He wasn't in park.
Mhm.
And he never turned off the vehicle. And it wasn't a matter of like he was, I guess, not complying, but he was just saying, and it wasn't necessarily that he was inching, but like he just was saying, no, I'm not, I got something, I don't even know who are you? And I told him,
Okay.
I was no one.
So what was your response to that?
When he, to what?
I don't know who you are.
That's when I told him, I said, I'm no one. I said, but I'm on the phone with the police.
Okay.
I said, and they're telling you to stop.
And when you responded to that, what are you doing? Are you still moving? Are you talking with your hands? Are you still moving with your hands? Are you
Yeah, I'm
still
telling you.
standing, like holding the stop? Are you pointing? I'm trying to understand. Somebody's sitting in the truck.
Right.
You're standing outside.
Right.
How can their right hand reach across to grab your gun? So I'm trying to figure out you being partially inside of that vehicle already.
I was close.
Okay.
I wasn't leaning forward. You know what I mean? Like I wasn't.
So you just,
Right. And that's when he said, I don't know who you are. And that's when he reached forward, like he was swinging almost.
like trying to swing and hit you?
Mhm.
Okay.
And that's when he grabbed me. And that's what I thought he was going to do. I thought he was going to hit me. So I was just willing to just trying to take the hit and thinking it was going to go past that. And I was still on the phone with the police. And I could see the police cars.
Mm-hmm.
But instead of swinging, when he swung with that hand,
His right hand?
I'm sorry, yes, when he swung with his right, when I was thinking he was swinging with his right hand, is when he grabbed my wrist.
Okay.
But before he grabbed my wrist, there was a motion with his, I think it was his left hand. There's no way that he could have motioned it over here with his right hand. Did I see it with two different hands? No, but I'm looking at him.
What kind of motion?
Like he was like telling me like to
Get away.
basically, yeah, like no, I'm not stopping, I'm not. He's like, no, I don't know who you are, you're not no one, you're no one.
So he's like motionless and like get away from me. Like kind of like get away, I don't know who you are.
But that's what I'm saying, I don't know if it was a getaway or if it was a trying to hit the phone out of my hand. Because
Okay.
I'm going like this to him, I'm on the phone with them right now.
So you like explain the screen to him?
Yeah,
How you looking at him?
Mm-hmm.
So at that point you stick is your hand more so inside the truck or is it
It's
still outside?
closer.
Okay. Closer to his wrist.
Yeah, I don't
Okay.
think I was in the truck too.
I got you. I think you're in the truck like this.
No,
But like, it's a lower truck. I saw the vehicle. I saw everything was parked at the end. So before how close your vehicles were, you were saying there was a little bit more distance.
Right.
All right. So prior to that distance, all this is when this all happens, right? You grab your hand before pulling off, or did you grab your hand after?
He grabbed my hand before.
All right, so this is grabbing your hand before.
Mm-hmm. And while he has my hand, and we're going back and forth and we're fighting and whatever.
All right.
My phone had already fallen out the sheet.
Okay.
Fallen out my hand.
Mm-hmm.
And that's when he's saying, I got something for you. And that's when he went forward.
Okay, I got something for you. Go forward.
Mhm.
While still holding on to you.
Right. But,
All right.
yes. And then that's when I rushed back.
Mm-hmm.
Because with one hand, he has me and he has me pulled, and we're going back and forth, and his hand, eventually my shirt got ripped somehow. But it wasn't when he had grabbed it, it was where he was just like hitting and we were scuffling basically, if that makes sense.
Okay, so your shirt got ripped from scuffling, not from him grabbing.
It got, you could hear like stitch pulls.
Okay, so
but at the end, what caused it to rip, actually ripped like fully, was from him grabbing it and him pulling it.
Alright, from him pulling it. Alright, so let me understand. So we got the grabbing of the wrist.
Right.
Then I got something for you where the bid was moved forward.
Right.
While I'm still holding you. Alright. Yeah. At what point does the door open?
I went with the vehicle and then it moved forward.
How did the vehicle stop? Did he just stop or did you?
No, it didn't stop. He didn't stop. It went into the car.
Was he driving it forward, or was he, did he have to, what was his hand doing when the vehicle went forward?
One hand was with me.
On your shirt or on your arm?
That was with my wrist.
Okay.
Yeah. And then
Did he move, like, did he turn to, like, drive the vehicle away, or did he, did his foot slip off the brake and it moved?
no, because you can hear it red.
Yeah,
Okay.
right.
Okay.
So he's holding you with his right hand and he moved forward. I guess it's might move driving forward.
He
to the left.
didn't reach forward for the
Steering wheel?
No, he didn't.
Okay.
That's what I'm saying. I mean, you just heard the engine rev.
Okay. Did at any point did he shut off his vehicle?
No.
So the car should have still been in drive by the time police got there?
To be honest, I don't know.
Do you remember him reaching for his gear shift to park it or to do anything? Or did he have to reach in and turn his car off or something like that?
The only time that he reached was when he's saying, I got something for you, after he had let
Yeah,
go.
when he was he reaching the back, side, front, where was he reaching at?
I saw his arm go this way.
So it's like towards the back?
Yeah.
Okay.
Toward, almost turned diagonal.
Okay,
But
I got you, like kind of,
it could have been to the back, it could have been behind, underneath, to the side.
I got you.
It could have been to the gear shift, with you saying it now, but he's saying, after I had said, I have a gun, he said, oh, and he's saying still, I got something for you, and he reaches.
But the first time you said I got something for you, he just moved the vehicle.
Right.
There was no reaching for no weapon or anything at that time, just moving up the vehicle. All right, so at this point, after he grabs your arm, I have something for you, strikes your vehicle, what happens next?
Then my wrist, I pulled my wrist away.
So you have to get away from him?
Yeah, I already had my gun pulled out.
All right, so where did you remove your gun from?
A concealed holster.
So you have a concealed holster on your right hip? Okay.
So I pulled it out.
And when you pulled it out, what did you do with that gun?
I loaded it.
All right, so you racked the chamber?
I did, yes.
Okay.
Which is when he had my shirt.
So at this time, he's now grabbing your shirt. So you was able to get away, snatch away from him, which was up first. And immediately, did he grab your shirt, or was there some separation at some point?
There was a minimal amount of separation. From the wrist, I had the gun out. When I pulled it away, it was a one movement. I was still within a couple inches of his, even if that, of his door. And that's when he's pushing open the door.
All right, why did you didn't have enough time to retreat, to run away to your vehicle?
That's what I had intended on doing after I took out my gun.
Okay.
But that's what I'm saying, that's when he pulled out, that was where the lean happened, the reach, I got something for you, he's pushing open the door, and that's when I pushed up against the door. I had it in my hand, I wasn't holding it back, but I had it in my hand, and I'm at the window with my gun in my hand.
So we got to reach back, also open the door, which you got to lean kind of forward, but you close that, all right?
After the reach, it wasn't a matter of him just like staying over here. He was reaching, and then it was
So reaching means like he's like looking for something. Is he still over at the
from how I was pulled back and the angle that I'm sitting at, and I'm focusing on nothing, truthfully. So, you know what I mean? Like there was no assuming that there was, assuming that there wasn't. It was just me just trying to make sure that I was prepared for whatever it may have been.
I got you. So at that time, he opens the door, you closes it back, right?
That's when I pushed up against it with my knee.
What made you do that? Why would you
Because
open the door?
I'm yelling at him, telling him to stay in the car. I told him you need to stay in the car. The police are on their way.
Okay.
And that's when he lunges.
When you say lunges, that means he like actually trying to like reach out the window? Like at this point, he's past the barrier from inside the vehicle to outside?
Right, yeah.
Okay.
And he got him with both hands or how
He's just coming with his right hand.
Okay.
So,
Because he's turned sideways, like if this is the window, he's turned sideways as he has his hand up against, almost like he had it on the armrest. He had his hand up against the door. That's when I pushed it, and I told him, you need to stay in the car.
okay.
And I had it in my hand.
Are you pointing at him at this time?
I'm not pointing it at him, but I'm not pointing it.
So where are you pointing at? Where is
It
he
was
pointing?
at rest with my hands, right here.
So your hand is actually on the car?
No, I'm just saying, like at the window.
Okay.
And I was actually further away because I had my knee on the door when I told him that. So I had my knee on the door, and I'm telling him, you need to stay in. I'm not reaching in, I'm not moving, I'm not
Do
touching.
you remember which knee that is?
Remember which side?
Which knee? The right or left?
My right knee.
So your right knee, so the same side as where you're holding the gun?
Yeah.
Okay.
So I had it face this way, and I pushed the door forward.
All right, tell me how your hands are. Is she holding the gun sideways, holding the point? Like, where's your hand? Where's your hands?
My hands are up here.
Oh, so you got a higher grade.
Yeah.
Okay.
Because I pulled it out, and I had it up here.
Where's the muzzle pointing?
It's more so pointing sideways. So I have it, so I have it in my hand like this.
All right, so it's not pointing at him, but it's kind of like ready if he has to pull. All right. And then you close the door back and tell him to stay in the car. At this point, he reaches out, correct? And he reaches out with his right hand. So you know there's nothing, no weapon or nothing in his right hand, correct?
Correct, well, yes.
Because you didn't see no weapon or nothing in his right.
I didn't see anything in his, but he didn't have anything in his hand.
Okay.
This hand is still down.
The left hand, which was the one that he was not reaching with, right?
Right.
Okay.
Right.
That's the one. He just reached to trying to open the door. Okay. And then he grabbed your shirt.
He grabbed my shirt.
With his right hand. Okay.
And that's when I'm trying to just pull away from him, and it was making me nervous because of the fact that I had the gun in my hand and I just wasn't holding it like I'm ready to shoot, so I didn't have the best grip on it. So because of it, I'm pulling away from him, and he's pulling at me.
So you're using both hands now to try to push off the car, or like explain?
It's more so just my right hand because I'm trying to, do this with him.
Okay, with the left hand.
Yeah,
Okay.
so I'm trying to do this, just trying to push him off of me. And the gun is still facing that way.
Okay.
But that's when he lifts up and he grabs it.
Lifts up.
Lifts up with this hand, his left hand.
So he lifts up with his left hand, grabs me, lifts up with his left hand, grabs the gun.
Just as he pulls away with my shirt, like almost like he's trying to pull me closer towards him. But that's when the shirt rips altogether. When that happens, when he lifts up with his right hand.
Okay.
I'm sorry, his left hand.
Okay.
And the gun is right at his door.
Okay.
And he grabs it.
Okay.
And
With his left hand.
With his left hand, yeah.
Okay. And at this time, is he still holding on to your shirt with the right hand, or?
No, his hand come off of my shirt.
All right.
So
You
now
said what?
his hand has come off of my
Okay.
shirt.
So now, left hand grabbing the gun, what is right hand doing?
Left hand was grabbing the gun. Then he immediately pulled his right hand around.
So now he got two hands on your
On
gun.
me, yes.
Okay. And at that point, how many hands do you have on your gun?
I pulled my hand under, and I was trying to pull my actual hand away.
Okay.
I couldn't actually grab the gun itself.
Because your right hand and his hands are all
On it,
okay.
right. Don't have my fingers on the trigger. I had it resting on the side of the trigger. That's when he's turning it, like he keeps turning, and it gets to almost like where my hand is on top of it, they're turning it and we're that way, and it kind of going back and forth over here, and when it was in this is when I...
At this point, is the gun more so inside of the truck or more so outside of the truck?
It's more so, we were right at the window,
Right.
but when he's turning it, it's outside.
Okay, so it's more so outside of the truck.
Mm-hmm.
That entire gun and your hands are more out of the truck.
Because, yeah, so
Okay.
it's like a back and forth thing. You know,
Okay.
like he's pulling, I'm pulling. But the only thing that was keeping
So
me
the
from...
tug of war, you was primarily winning because of the fact that your hands are outside of the truck?
It kind of was going back and forth.
Okay.
The only reason that I was able to pull fully, I couldn't because he was stronger than I was,
Okay.
to actually pull away from him. But the truck and my knee being up against the truck was kind of helping
Good
me.
leverage.
Yeah.
Gotcha.
Yeah, so that's when I was pulling. We're going back and forth. And the entire time, it was never more so in the car, out the car when we had the gun. It was more so like right there. And he's pulling, so my arm is now technically inside the vehicle.
Okay.
And he's pulling and pulling, and it got to where the gun was pointed kind of that way. And he had a hold of the trigger, and the trigger was pulled.
Okay.
It didn't go off.
Because your hand wasn't on the safety.
Right.
Right.
So that's when I'm lifting up and I'm trying to pull over.
Okay.
When I'm lifting up and I'm trying to think that I can just get above him because I have air in the truck.
Yeah.
Thinking I could just get above him and it wasn't working. So then we're back here, both hands, and I'm yelling at him, telling him, I said, just let go, let go. And he's yelling, no, just shoot me. You said you're going to, just shoot me. And I'm like, just let go. That's when his hands and my fingers were...
In the trigger guard.
They were at the trigger guard.
Okay.
And that's when my hand was underneath, so I was still pulling, and he let go with his right hand. His right hand, which is when he was reaching. And when he was reaching is when my hand went in the trigger guard, yes. And that's when he grabbed kind of like this side. It was somewhere right here.
So with his right hand, that hand still on the gun,
That hand's on the gun, yeah.
and then then he grabs you. And then,
Well, he tried to grab me, but when I pulled away is when, because he's more forward now than he was before, and more turned. I mean, he's almost fully
basically,
turned.
like, yeah.
By pulling. And I think that was more so just a matter of us kind of going back and forth with him like this. And he's pulling after he tried to pull the trigger. When it came back around is when I had my hand on the trigger. And he still was squeezing, reaching, pulling, turning.
With his left hand.
Which is when the lunge happened, like the
The
grab.
extra.
And that's when it went off.
And that went off.
How many shots were fired?
Just
One. How many does your gun hold?
it holds the magazine is now, I want to say 15 or 16.
Was it full?
No, it wasn't.
Do you know how many was in there?
11 or 12. My boyfriend noticed it for me after he bought me new bullets. So
How did you get the gun?
like originally purchased it, you mean?
Yeah, like, was it gifted or did you go buy
I
it?
went and bought it.
Okay, where did you buy it from?
Gun, safe, and armory. In
Okay.
Forest Park. Something like
Yeah.
it.
Okay, how long you had that gun?
Not long enough. Maybe a couple weeks.
A couple of weeks. Did you take any training classes with the gun or did it jump at you?
It wasn't, I didn't take any scheduled training.
Professional, like,
Professional,
okay.
yeah.
Okay.
I mean, I've been to the range. I grew up shooting range. I grew up around police officers, actually. So,
I got you. Why, you brought up about the 911 call. Why did you stop?
why did I stop originally?
Yeah.
Because I could,
Why did you change? Like, why didn't you stop?
I'm not a just, it wasn't me type of person. that I was.
Hey,
almost
Ruby
involved.
Q. How are you, dear?
It threw me. So I called the police, and I was on the phone with her. I told her, I said, I'm sure they've already called, but I'm just letting you know. She goes, well, we haven't actually received any calls yet. So I thought it was weird. So that's why I pulled off. I got out. I walked over and was talking to them. And after he was getting out of his truck, the truck driver had come back. The other police officer was also there. And that's when he had come back, or he was getting out of his truck and he was stumbling and falling into traffic.
The guy?
Yeah.
So he had appeared inebriated?
Yes.
Have you been around some people before, or people using
Yes.
other drugs with a prescription or not?
Mm-hmm.
What did you think he?
I thought it was alcohol.
Did you ever smell any alcohol on him?
I never got close enough.
Even when you're at the window, like when you're having this, did you ever catch a whiff of anything, or?
I can't say that I did. Can't say that I didn't.
Okay.
Was that something that you noticed? That you
No, nothing that I didn't know.
Did you smell anything that you noticed?
No.
No?
No,
Okay.
nothing other than the outside.
Okay, yeah, no, I'm just, like, no alcohol, no pretty smells, or nothing like that.
No. But when I was standing there talking to the guy, I thought it was weird that he kept going back to the vehicle. So that's why, and he turned it on and started revving it while we were all standing in front of it.
Okay.
So that's when I had walked back across the street and I was calling my parents to tell them what happened. And I told them, let me call you right back. It's been almost 20 minutes and this guy's making me nervous.
Okay.
So I called dispatch. That was when I called the police officer. The police and the dispatch answered. And that's when I was on the phone with her when he took off.
And did the dispatcher ever tell you not to follow them?
She said, I told her, I said, I'm following him. And she said, yeah, no, so she said, she's like, we ask that you don't put yourself at risk.
Okay.
And I told her, I said, I'm just trying to get a tag number so you can have it. By the time I got a tag number, we were at the end to Ridgeville Road, and I come around that corner, and right before he came around the corner, I came around the corner, and I got in front of him, and I stopped him.
Did you ever get the tag number?
Right when I got to the end, yeah.
Alright. So did you get the tag number before you kind of cut them off?
Yes.
What made you cut them off still out to get the tag number?
I saw the police lights, and the police lights was more so than after.
So,
Again, I've been involved in the hit and run, and if the world was perfect, I could know that was his car, that tag number would go to the right person, but it wasn't just like he was just in the accident and then he just wanted to leave. He was just in the accident and he was all over the place. And that's when that's exactly what I told the dispatch. I said, he's all over the place. I said, there's no way. I said, please just get an officer here. I said, and then, I'll stop, but I said, he's going to hurt someone.
right.
Which is when I got in front of him. And assuming that was going to stop him.
We're stopping at 9:34, moving ahead. Just one more time, get into the right spot.
A link for what, Lee? What did I miss?
And I see we'll get a photographer deal. I see, we want the pictures of each.
I mean, there's a little more here, and I'm not saying actually bruises. I'm just saying, like,
Wherever you sustain injury.
I have scratches scratch here.
Okay.
I mean, I felt more scratches around here. I don't,
Yeah,
yeah, but with my hair was more, when I first, I mean, because I have it, not that it makes that much of a difference, but it was like that.
Okay.
So we're going back and forth.
Right.
So I mean, I felt one, I don't know if there's anywhere, I haven't looked.
Do you have
I have a bra.
okay.
Judge, we're stopping at 9:36:12.
Yes.
Detective Herring, would you agree, based on your investigation in this case, that this interview basically took place within a couple of hours of the shooting?
Correct.
And at the time that you conducted the interview with the defendant, had you listened to the 911 calls?
No.
Had you formally interviewed any of the other eyewitnesses?
No.
Had you watched the body cameras of any of the uniform responding officers?
No.
So when you hear the
Hey,
defendant
Boxy.
in the interview
New
saying that she
people
was
hopping
telling
in.
Mr. Herring to
Here
stay
is
in
the
car,
link to
did you hear her say that?
Yes.
the new
Were you
channel.
aware that on the
that I'm
911 calls,
starting
she's
for
saying the
crime
opposite,
and
get out of the car?
trials.
Not at that time.
Make sure to subscribe so you don't miss anything.
And do you, for the record,
Good morning,
on the
Foxy.
interview, do you hear that the defendant admits that she caused Mr. Herring to stop, that she stopped him?
Correct.
And even though she goes back and forth repeatedly, do you hear the defendant several times in your
Thank
interview
you,
with her
Lee.
acknowledge that she put her finger on the trigger?
Yes.
Based on your evidence in this case, after the interview, obviously, did you watch all the interviews and conduct the interviews and watch the media that I just talked about?
Yes.
Did you receive any evidence in this case that Mr. Herring ever got out of his vehicle in any way?
No.
And did you hear the defendant acknowledge that Mr. Herring had nothing in his hands?
Yes.
Did you ever hear her, or did she ever tell you at any time about any specific weapon she was concerned about?
No.
Did the defendant ever mention being concerned about a sheetrock knife located back in the trash or behind Mr. Herring's seat? Did she ever mention a knife to you at all?
No.
Let's talk a little bit about one second.
I'm
In order
sorry.
to be
If
a
the
police
knife would have been a
officer,
thing,
do you receive
that would have
any
been the
training
first
as
thing
it
she
relates to
said
firearms
was
and
he had a
shooting?
knife.
Yes, ma'am. Initially in basic law enforcement training and then ongoing continuous training throughout the year of your career.
And have you maintained, you said you're still working in security?
Correct.
Are you still
I'm-
around weapons,
Yes.
things like that?
I am.
And I want to go back to one thing before I forget to do it. Do you hear, you asked the defendant specifically if she'd taken any gun safety classes, and she told you no?
Correct. Professionally, yes.
You and the defendant kind of start discussing the double safety, is that correct?
Yes.
Okay, Lee.
What's already been admitted
Thank
as
you
State's
for
Exhibit
that.
number 15. I'm going to ask the witness if he can step down to show the feature of this weapon, please.
Yes.
If you would make sure, since your back is going to be to the court reporter, if you keep your voice up.
Okay.
And again, for the record, there is a zip tie. There is no ammunition. The gun is safe. If you could show the jury on State's Exhibit number 15 what that second safety is and where it is on the firearm.
It's going to be on the back side of the handle, where my finger is pointing, and you have to grasp the handle firmly to push that trigger in.
And then there's also the double trigger. So there's a safety feature on the trigger. So in order for this gun to fire, what all has to be happening at the same time?
Both the trigger on the back of the handle and also the trigger within the trigger guard have to be pulled.
So someone's hand has to be firmly on both.
Correct.
All right? If you would. And you heard on the interview that the defendant claims that the moment she was able to pull the gun, that she wrapped the slide.
Yes.
In your experience with firearms, how many hands does it take to wrap a slide?
2.
So when she has the gun out, who's wrapping the slide, she has both hands.
Correct.
Were you eventually able to obtain a video of this incident?
Yes.
And that was from Cameron Williams, is that correct?
Can't recall the name, but it was from a witness.
We approach with what's already been admitted as State's Exhibit number 22.
You may.
Thank you, Judge. I'm just going to let you look at that, and I'm going to display it. Using State's Exhibit number 22, the position that you see the defendant's hand in, with their hand all the way on the back of the grip and the finger in the trigger guard, is that the position that the hand would have to be in order to pull the trigger on that gun for it to work?
Correct.
No further questions at this time, Judge.
Thank you, Chief Assistant. Any cross-exam?
Yes, ma'am.
Attorney Tucker?
Mr. Haywood, how you doing today? You're sharp as always.
I appreciate it. Thank you.
Yes, sir. Now, you were saying that the interview you had with Miss Payne, that was a couple of hours after the incident, correct?
Correct.
Okay. And there had been a couple of interviews with her with other officers, correct?
Not to my knowledge. Maybe the initial interview with the uniform officer, but typically it's not something that more in detailed interview on the roadside is not something that's typical.
So was it typical for them to do an interview like that, or?
To my knowledge, it's not I do not recall them having a detailed interview on the side of the road with her.
Okay, but when you did your investigation, you saw when the officer put her in the back of the car, walked up with the pad, and started asking her what happened, correct?
No.
So you never went back and witnessed that video that your officer had where he was interviewing?
Yeah, so it's been a while. According to my recollection, Hannah Payne was not in the back of a car. She was out. She was standing with an officer. And then, and that's when we was informed that officer to go ahead and detain her to transport her to our headquarters for an interview.
So, according to your recollection, they got her, they detained her, put her in a car straight to the precinct.
Correct.
Okay. And she sat at the precinct for a long time, correct?
Yes, she was there for a while.
Okay. And her phone was taken away from her, correct?
Correct.
Was she ever asking to speak to her parents or call her parents to let them know that she's okay?
At one point she did ask.
Okay. And did you allow her to call her parents to say, hey, I'm okay? The last time they talked, it's kind of crazy.
At that point, I informed her that her parents was already there.
Parents were at the precinct.
Correct.
Okay.
Can we approach, please? Yes, you may.
You guys are cracking me up talking about her being a hard stepper. I feel like the prosecutor feels very solid in the job she just did with questioning him, She sat down, she took a drink of her coffee or water or whatever she's drinking, and you could tell she felt happy with how things just went. Yeah, he does have a nice suit, and the bumblebee brooch is bougie. He's a handsome fella. Handsome, handsome, handsome. Making bank, he works private personal security. There you go. She did cover all of her bases, and she drove it home with that still shot of Hannah with her finger on the trigger guard, however you want to word that. I don't really know. But yeah, yes, you guys. Hey, we'll see how this goes. I'm not feeling too solid for Hannah though. Was it the safety that her finger was on in that picture? I'm not. I was not paying 100% attention. Prosecutor was chef's kiss. Autocorrect. Jennifer. Uh-oh, I'm in trouble. She's called me. Called me by Jennifer. Yeesh. No, it was across the trigger guard.
So we're back where she'd asked to use her phone to talk to her parents, correct? To basically just say she was safe and
Correct.
okay. And then it was roughly, I counted about an hour, 22 minutes before that she sat in the room, just sitting there, kind of putting her head down. I don't think we got to see the whole thing, but it was just, just her in a room by herself, correct?
Yes.
Okay. And at that point, you and Detective Moore came in there and started asking questions. Is that fair to say?
Correct.
Okay. And in these questions, how long have you been a detective there at Clayton County?
For 3 years.
Okay. And did you have any other training as a detective before that?
Just basic law enforcement uniform.
Okay. And basically, as a detective, they teach you different strategies and techniques on how to interview people?
Correct.
And it's different than they would a law enforcement that's on the street, correct?
Not necessarily, no, sir.
Did you take any different classes to assist you in the ability to interview?
No, I did not take an additional interview and interrogation courses.
Okay. And have you ever had an occasion where you're dealing with somebody and say they cut you off or won't listen to you or try to end your sentences?
Yes, I have.
Okay, and how did that make you feel? Frustrated?
It can be frustrating.
So, and in this interview, a lot of times you're asking Ms. Payne some questions, and it appears you did not let her finish her sentence, or you're trying to finish it for her. Did you see that in the interview?
No, sir. What I did recognize is that I allowed Detective Moore to ask all the questions initially, and I was just asking follow-up questions to get more detailed information.
All right, do you recall asking her, so did the door open, or did you see the door open? She says, I didn't see the door open, but your next question said, now that the door is opening. Do you recall seeing that on the video, or do you recall saying that?
No, sir.
Okay. Why were you harping on the door?
And I was just interested in regards to the positioning of the incident, whether it took place inside of the vehicle or whether it took place outside, because but just with the initial conversation with the uniform officers, it was supposedly that there was a physical altercation with Ms. Payne inside of the vehicle striking Mr. Herring.
So you did talk to some of the officers that were on the scene, correct?
Yes, to gain initial information.
And none of them said that the officer took her in the back of the car and interviewed her?
No.
Okay. Now, as I was writing it down, it appeared she was telling about he was reaching for something to open the door or trying to open the door. She couldn't really tell, but she heard kind of grabbing at the panel on the inside. She didn't say panel, but at the door.
Correct.
Did you try to open the door when you got on the scene?
I can't recall if I tried to open the door, but I doubt it.
Okay. Did you hear that anybody could get the door open?
I can't recall, honestly speaking.
Do you recall Officer Ritchie saying that he had to go around to get into the vehicle because the door on the driver's side would not open?
Okay. I don't recall that, no.
Okay. Do you recall anybody else mentioning the door, or how about this? Do you recall how much damage was on the truck?
Oh, the vehicle had extensive damage, yes.
Okay. And could that damage cause that door to have not opened?
There's a possibility, yes. Yes, sir.
And so there's a possibility because the damage occurred prior to the encounter with Miss Payne, correct?
Right, with the accident.
So it's a possibility that door could not open.
Correct.
And you stated there, she started talking to you initially and stated that basically she was on the phone with the police or 911, and she'd been told by an officer to go get the tag. Do you recall hearing that in your interview?
Repeat that?
Do you recall hearing in your interview that her saying that she was on the phone with 911?
Mm-hmm.
Do you recall hearing that?
Yes.
Okay. Do you recall hearing her saying that there was an officer at the scene of the first accident?
Oh, yeah, off-duty officer, yes.
Okay. But she called him an officer, correct?
Yes.
Okay. And do you recall her saying the officer kind of was like, go get the tag?
Yes.
Okay. So from her side, she was telling you that's what was occurring when she went to get the tag, correct?
Okay, yes.
Okay. And then you asked the question, why didn't you stop? And she said, well, the person on the phone was kind of like, be safe. So do you remember her saying that she didn't recall them saying, don't chase, but you need to be safe?
No.
Okay. So you don't remember her saying that the individual on the phone from 911 said that she needed to be safe?
I recalled she said that she was on the phone with 911, and I don't recall the fact that the person said, just be safe. No.
You need to be safe. We want to make sure you're safe. Something
Okay.
along that
Right,
lines.
right.
Okay. I know it's been a while.
Yes.
But we just heard it, and I know you got other things going on. So, let's see. Do you recall her stating that she just was walking up to the door, had the phone to show that she had 911 on the call, to talk to the gentleman to tell him to go back to the accident, correct?
Correct.
Okay. So it sounds like she's just walking up with the phone trying to say, hey, you need to go back to the accident. She's not walking up there to get aggressive. She's walking up there to tell him to go back to the accident, correct?
That's not what she said to me in regards to like just that she was just telling me to go back to the accident in the interview. That's not what I recall from the interview, no.
Okay, at the beginning of the interview, she did the quick explanation of what's going on.
Right.
You don't recall her saying that I was on the phone with 911 and I walked up the phone to show that I was on the phone with the police or 911 and was telling him he needed to go back to the accident.
Not to hope you go back to the accident. No, I don't recall that part of the interview.
Okay. But you do recall hearing her say that as they were struggling and going back and forth for the gun, that she heard him pull the trigger and it clicked. And that's when they started talking about the safety mechanisms on the gun, correct?
I'm sorry?
When she was testifying or telling you in this interview,
Okay.
she was talking about
That's cool.
the
Thanks for
position of
sharing
her
that,
hands.
Twiggy. I appreciate that.
A lot of times she would say trigger guard. A lot of times she'd say trigger. A lot of times she'd say hand. Do you recall hearing that?
Those terms, yes.
Okay. And a couple of times she said trigger, but she came back and corrected herself to say trigger guard. Do you
Correct.
recall? Okay. And do you recall her saying that as they're pulling for this, that his hand got into the trigger and pulled it and it clicked?
No.
You don't recall that?
I heard trigger guard.
Okay, you didn't hear on that video where it just said, I heard the gun click. He had his finger in the trigger guard.
No.
Okay, hold on. I would hate to have to play it all back, Your Honor, but I believe it was in between. She said 9. I got right on 9. Oh, yeah. Oh, it's, okay. I can use that. This one, anything? Both of them in here. Oh, it's it. All right. I will.
Twiggy, if you're still here, I just put
Yeah.
a link to the new channel
As I
in
look
the
at this,
chat.
I'll keep
That's
trying to
where
move
I'm
forward.
going to
Now, you recall her saying
move,
that
trial things
she
away
saw
from
that
the
the car
craft
was
channel
stopped, so
to
she
the
pulled in front of the car
Crime-y
or the
channel.
truck.
No, sir.
Thank you. Thank you, thank you.
Do you recall her saying, I honestly don't know if the door opened or not, but I could hear him grabbing at the door handle. Do you recall hearing that?
Yes.
Okay. And do you recall her saying, not once, but a couple of times, that she had no intention of ever trying to use her gun?
I don't recall her saying that directly, but she did speak towards that, yes.
Yeah. So I'm gonna, if I may approach, Your Honor.
Yes, you may.
I'm gonna refresh your memory. These have been transcripts of the interview that we just heard.
What exhibit is that?
It states, exhibit 41. I don't believe they tendered it. They just used it for refreshing.
Okay.
And I'll just do the same. Do you see in there where it says she had no intention of using it being the gun?
Yes, I see that.
All right. Does that refresh your memory a little bit better? If I may approach you.
Yes, you may. And what page are you referencing?
Number 9. So, you refresh your memory, so you do recall her saying she had no intention of using the gun, correct?
Yes, but she was prepared.
Okay. And in that page 2, it kept saying that he kept pulling and pulling, and do you recall Detective Moore on that same page asking, so you pulled around and you stopped in front of him? What happens? So it wasn't like she blocked him in, she stopped in front of him, correct? Do you recall hearing that in there?
Yes.
Okay. All right. And a lot of times she kept saying that when she got up there, that the victim, the deceased there was asking, who are you? You're nobody. Do you recall hearing that from the testimony?
Yes, sir, correct.
Okay, and she kept saying that he was telling her he had something for you and leaning back, correct?
Yes, that's what Ms. Payne said.
Okay. Now, did you get a chance to look at the contents of that truck?
Yes.
Okay. And was there any kind of items within that truck that could have been used to cause bodily harm to Ms. Payne?
Again, this has been a while. To my record, I would have to probably see like the evidence list, but yes, it was like syringes in there. I do believe like there was a sharp tool that we did submit to evidence just because she stated that that she did see him reaching for something. So I don't think a lot of documents. There was a lot of things in that truck.
Okay, so as a detective and hearing what she had said in her interview, wouldn't you go back to his vehicle and look around to see if items that could have caused bodily harm and take them in as evidence?
Yes, I believe that was done.
So the knife was taken in as evidence.
Yes, I believe that was done.
Okay, and
Our young Ben Matlock is back in there again today. He looks like a young Matlock. Is it just me? Nobody else sees that? Wait till it pans back to the gallery.
And I have defense exhibit 23, 24, 26, 30, and 30.
I'm telling you, if he indeed have
I think it goes up to 36, correct?
the health conditions that
26,
he
30 and 36. And I plan to show them. So,
has supposedly
you
had.
look at those photos right there. Is that, to your knowledge, and I know it's been a while, is that a fair and accurate representation of what you saw in the vehicle?
Correct.
Okay. And as you look at those, do you see anything of interest that would probably be collected or used to investigate to find out what really was going on?
If something had to be of concern, it would be Exhibit 23, the cutting tool.
Okay. And nothing else in those pictures are of any interest to try to explain what was going on or somebody's behavior?
The syringe caps? Is that what you? But no, sir.
There's nothing else in those pictures that were any interest or any value?
No, sir.
This is the third time he's asked this question. The witness has answered it. I would ask that the council move on.
Remember, I asked one time, he talked about a saw. I asked again, he just answered with the caps, and that's it. I haven't asked a third.
Okay,
So-
so I am going to sustain the objection. He has answered with what he thought might be used as a cutting tool was his response.
Correct.
He has answered.
And then he also answered that there were caps to a syringe, and then he said that was it. And I haven't asked another question since then. I
Okay,
just.
so he has answered, so if you move on, Attorney Tucker.
All right, you're on.
I do have a question though. Has
What he was identifying.
he ever had like any objections be overruled? Like, has she had any objections against him overruled? Or has he had any objections towards her
Okay.
sustained?
And this was the picture
You know what I'm saying?
that
Like,
you stated that there was a saw in, correct?
Correct.
I'm just
cutting
wondering.
Okay, cutting tool. And you reviewed all of these,
because each
Pictures.
time that the judge
correct?
decides,
Tool. Correct.
he is always so, you could tell he's like very upset.
And upon reviewing all of these, it was your testimony that there wasn't anything besides the cutting tool and possibly the caps that were of any value.
Correct.
Now, there was a picture shown. Yeah, there was a picture shown to you. I mean, that okay. Now, hearing the interview and hearing how there was pulling and tussling and a shirt being ripped, the way that arm is pulled out, the way it is depicted in that picture, would that be possibly because the hand was being held and it finally got loose?
Judge, that requests this witness to speculate. Your response?
He is a detective, an investigator. He investigated this scene. He heard the testimony. I think he can give his opinion of the position of that picture, and from what all he learned in this investigation, he should be able to explain a theory or what he felt was depicting.
So I'm going to sustain the objection. It does call for speculation.
All right. Now, when Detective Moore was talking with Hannah Payne, a couple of times, she said she had put her finger and then she stopped. She said, "I put my hand on, I don't know what it's called, the trigger," and Detective Moore said, "The trigger guard, correct? The circular thing." And she said, "Yes." Do you recall that?
No.
You don't, if I may refresh your memory? Page number 24.
Picture was from a video. The picture is a still shot from a video that a witness had recorded on his cell phone. Somebody
Correct.
that was there during the
So,
altercation.
a lot of times, as she's nervous in this interview, when she's stating certain things, a lot of times it needs to be corrected or clarified, correct?
Yes.
Okay. And you could tell she was scared, kind of nervous.
Correct.
And that whole time she was sitting there in the room waiting to be interviewed. Did anybody offer up her any water or bathroom or anything?
Yes, I believe Detective Milanes did when he initially sat her in the interview room.
Okay. And you kept asking and trying to get clarity that how the positioning or the handling was on the gun, correct?
Correct. Just how what everybody's hands were doing.
Okay. And if I may, I'll use this just to evidence, if that's okay. And once again, this is just an exhibit. It's not a real gun. It's a toy plastic gun. It has nothing, even though it has the abilities, it has nothing in it. Okay, if I may approach her.
You may.
All right, according to what you heard Ms. Payne saying in the position of what everything was going on, could you show me the way she said she had the gun in her hand?
The way she said she had the gun in her hand?
Okay? And she said that the individual in the vehicle had grabbed her wrist. Is it fair to say with his left hand grabbed her wrist?
Yep. Grab the gun with the left hand?
Or gun over wrist?
Wrist.
Gun.
Okay.
Is that fair to say?
Yes.
So if he's got it like this, and he's got her shirt
Hi, folks,
here,
popping in.
did she
Hope
say at one
everybody's
time
having
you
an
let go and
amazing
Katie grabbed the
Tuesday.
gun with both
Welcome,
her hands?
welcome.
Yes.
Okay, and as they grab, what is right there at the trigger of the trigger guard?
Fingers?
Okay, so not just one, but a couple, correct?
Correct.
And it's fair to say hers is on the other side, she said underneath, correct?
Correct.
Okay. So, she's giving the description, and you're clarifying it and asking and going into details of what really happened. And as I initially asked about her stating that as he was pulling on the gun and going back and forth, that the trigger was pulled. Do you recall her saying that?
Yes.
Okay. And it was not pulled by her. Do you recall her saying that he had the gun, a better grip on the gun because she didn't have a good grip on the gun?
No.
Okay, and I'll refresh your memory. All right, but you do recall her saying that he had a hold of the trigger and the trigger was pulled. Do you recall that?
In the interview?
Yes.
No, sir.
Okay. I'm going to refresh your memory. It's on page 47. Okay. Want me to approach?
You may.
Talks about pulling on the trigger and all that.
Yes, she expressed that he had hold of the trigger and the trigger was pulled.
Okay. And earlier I asked also that, do you recall her saying that, that there was a click, like the trigger being pulled?
No, I don't recall the click.
If I may approach?
You may.
I can refresh your memory here. And I know it's been a while, so I'll be helping them.
What page are you referencing, Attorney Tucker? What page are you referencing?
23.
Okay.
Yes.
Okay, so it was stated in an interview that she said the trigger was pulled and that she heard a click.
She stated that when it first had turned, I heard it click, like the trigger was pulled.
Okay. So, and then at that point, she's saying that the gun is being tried to be pointed back at her, correct?
Correct.
Okay. So in a scenario like that, with your experience and knowledge and training, if somebody's pointing a gun back at somebody and pulls a trigger and you hear it click, would that not be aggravated assault or possibly attempted murder?
Your objection.
Obviously, this witness can't speculate to that. It's calls for a legal conclusion and is inconsistent with the evidence that's been presented, and we would ask this question.
Your
Your Honor,
response.
I'm talking to him about his interview he had with Ms. Payne. I'm asking from his experiences, training, and being a detective, that if a situation as described in this interview and somebody's pointing a gun and it clicks, what charge could be put on the individual? And I think he's well within the scope of his employment, well within the scope of his knowledge to answer that.
Your response,
And
Chief Assistant.
Judge, I think it's assuming it's not a question based on the facts, because the facts are that the defendant had the gun. So asking what happens when someone else is using her gun against her, the gun is in her hand. So I think it's asking a speculation that Mr. Herring would have ever been charged with anything in this case. So I think it's an inappropriate question and it's misleading to the jury.
And I'm asking from his interview that he had with Ms. Payne, where he could ask any question he wants. He heard all of this information. I'm asking from this interview what he did. He conducted. If that occurred, what in his training and knowledge and experience he believes that that could be charged or that would have been classified as.
So the question, as you posted, does call for a legal conclusion, and so I am going to sustain the objection.
Okay. Now, you stated that that as you sat there and discussed with Miss Payne, and after this interview, you had heard her parents were outside, correct? After the interview, correct?
Correct.
Okay. And at that point, you saw me coming into the precinct explaining I was her attorney and that I would like to speak with her, correct?
Correct.
Okay. And you left the room and you allowed us time to speak, correct?
Correct.
Okay. At any point, did anybody listen to what we were saying in that room? I know there was a lot of officers, a lot of detectives around there.
There's an objection,
And
Attorney.
we need to approach for this one.
Holy cow, they're starting to get into the angry, arguments, and I can just feel like the prosecutor is just like, "Ee, ee, 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 ee." You know what I mean? So here we have Hannah's family and friends side. Um, that guy right there with the beard is her boyfriend. That's her mom and her dad. Hey Twiggy, by the way, was the person that told you about us? Um, was he there yesterday and had like a green mohawk? Would love to know if he's the one that told you about us. That would be super cool. Oh, there is Kenneth Herring's little sister that came in. I think she was the first one that was on the stand on day one. His little sister. Said he was working audio. Oh, okay. Well, I misread that. Twiggy said, can't remember the mohawk. I'll need to ask my sister. Okay. Was it a family friend that was there, or was it someone that like worked in the courtroom? I don't know. Either way. Now he's stretching, trying to find something. He says, Lee says, with this whole, did anyone hear her with her
All right.
lawyer?
So we won't go any further on me showing up. Did you ever tell Miss Payne during that whole period of time? Let me rephrase. When did you find out that the individual shot had become deceased?
Maybe prior to the interview, because I think that's where Detective Moore responded when I responded to the incident location.
Okay. And did you ever tell Miss Payne that the individual had passed away?
No, not to my recollection, no.
All right. And did you see and recall in your interview when you and Detective Moore are talking to Miss Payne, a lot of times you interrupted her or didn't let her finish her sentence?
There were moments that I did ask questions, direct questions, and she was giving me additional information. I was just trying to make sure I gained clarity.
But when you were asking the question, was she still talking at that time?
Yes.
Okay. And generally, when two people are talking at the same time, it's not fair to say that they heard the whole question or heard the whole conversation.
Correct.
Okay. So, and it was you and Detective Moore asking questions simultaneously, or sometimes she'd start it and you'd catch on and come behind it, but there were questions coming rather quickly, correct?
No, sir.
No?
No, sir.
Okay. You don't recall just seeing in that interview where you're talking about the door, just specifically the door, and Detective Moore asked a question and you ask a question and she's trying to explain it. You don't recall seeing that just a few minutes ago?
The concern was the quickly, as if it was like rapid fire questioning. But we were asking questions in the interview, allowing Ms. Payne a chance to respond. Also, was asking follow-up questions and giving everybody an opportunity to ask and to respond.
Okay. Now, you did ask that when she pulled in front of Mr. Herring, that you asked, was it like his foot came off the gas or came off the brake and that's why the car moved forward? And she stated that no, it revved up before it took off. Do you recall hearing that?
I do recall her speaking that the vehicle revved.
Okay. And do you recall seeing where the vehicle had made contact with the Jeep?
Yes.
And you did hear her state that it was moving with her, but it stopped when it got to the Jeep?
Yes.
Okay. And you heard her at one point say that she didn't have a good grip on the gun, that he may have had a better grip on the gun?
I do recall her stating that she did not have a good grip.
Okay. And now you stated that there's only one way to load a chamber when it's been holstered, a gun. Do you recall saying that?
Yes.
Okay. Have you seen those holsters now that you just pull it down a pop and it's loaded it?
I'm not familiar with that holster, no.
Okay. You haven't seen those? I've seen them on TV, the commercials that are promoting that it's kind of a pow loaded and go. You haven't seen those commercials or seen a holster that has that?
No, sir.
Okay. But you did hear that this particular gun had kind of a two safety mechanism, correct?
Correct.
And that would be based for safety, right?
Yes.
Okay. And I heard that you said when you were asked, she didn't have any training, gun training, and you said professional. You meant professional training or professional gun training, or what did you mean when you said that?
Yeah, she expressed it like during the interview. It was like when I said professional, like actually like attending a gunfire safety course. That's what I was asking in regards to like professionally.
All right. So would that be a state certified, or would it be something you would pay that makes it professional, or
Both.
Okay. And so when you go to these gun ranges and they sit you down and you watch a video and then they tell you a little bit about the gun, that would not be considered gun safety class?
Probably gun safety class for that particular location for the firing range.
But they talk about the safety of the gun, how to hold it.
Yes.
Okay. And throughout this interview, you did hear her say that she had some scratches and some marks on her person.
Yes, sir.
Okay. And were they consistent to the story that she was telling you about what happened?
Yes, in regards to a grabbing of the shirt.
And of the wrist?
In the wrist, yes.
Okay. And pictures were not taken until after the interview, after it was brought to their attention that she had some marks. Do you recall when Detective Moore decided to take pictures?
Yes.
When did she decide to take pictures?
I think we requested the photographer after our interview.
Okay. And you asked a specific question of, why would you go after this car? Why would you follow this car to get a tag? And she said that she's a people person and she was just trying to help out. Do you recall that?
Yes.
Is that a bad thing?
No, sir.
Okay. Now, when she was stating that he had something for her, that she was nobody and was leaning back, did that kind of spark your curiosity of what could have been happening inside that truck?
Yes.
Okay. And upon looking at the pictures and everything else, there wasn't really anything that stuck out to you besides that saw. Did you ever see the knife that was in the truck?
No, sir.
Am I approach her?
Yes.
Yeah, I don't know. I feel like he's just stretches, and he's like, "Let me. This isn't working. Let me go back to the. Let me go back to the knife thing, or let me go back to this part, or let me go back to that part." Trying to drive things home, but they're not going.
I'm trying to find the exhibit that I think, of the night, and then maybe it's in her. Right. She was nice enough to put this and then that, which helped out.
Well, and Foxy, I mean, I wish that he could, but she's been stacked against, and he's just, I don't know. I don't know.
Thank you. Take care. All right.
Don't know.
If I can bring to your attention offense exhibit number 25.
Okay, here's the knife.
You stated that looking through the truck, the content, that you never saw that die.
Yes.
Yes, you did see it, or yes, you didn't see it.
In regards, yes, I did not see this in the photos that you presented, but yes, I think that's the cutting tool that we submitted to evidence.
Okay. And they would get tested for any fingerprints or DNA.
Not to my recollection, I'm not sure.
All right. And did the trigger of the gun ever get submitted for DNA or fingerprinting?
I'm not sure if that did happen for DNA.
And based on the testimony of whose finger was on the trigger or not, did you feel that was necessary to ask to have them do a DNA analysis or fingerprint analysis?
Not necessarily.
So it wasn't any concern of yours to find out whose finger or whose DNA was on the trigger?
There's a possibility that both hands could have been on the firearm, or it could have been just one.
But wouldn't you want to know the answer of that?
Yes, but at that particular time, I'm not sure if that's what was requested during the investigation, and if it was not requested, because I didn't think it was probably a determining factor.
And I'm not trying to put you on the hook for somebody else. Did you request a fingerprint or DNA?
To my I cannot recall specifically, no.
I think he probably just asked her, is there anything else? Is there anything else?
Now, numerous times in her interview, she kept relaying that she was telling him to stop, correct?
Correct.
Okay. And she stated that that basically, they both were kind of scuffling back and forth. He was hitting her, she was trying to hit him. Do you recall if there were any visible bruises or any kind of cuts on Mr. Herring's face, body, arms?
No, sir. I not to my recollection, I don't even think I even viewed Mr. Herring because he was already at the hospital.
Okay. Did you ever get a chance to review the pictures of Mr. Herring?
No, sir, not to my recollection.
Did you ever get to review the autopsy?
No, sir.
Side note,
Now,
there's a
as you
woman
were
right
standing
there with the long
at
brown
the
hair
site,
sitting in front of the guy with the green hoodie.
I
She
noticed
just
at one
crossed her
point you
arms.
look up and you look
She
at the
looks like,
camera.
well, she did until she did that.
Do you recall
She
that?
reminds me of Anna
Like,
Devane
you know, the roads
from
have
General
cameras
Hospital.
all up and
Or is it
down
all General Hospital?
No,
or
sir, I
Army
don't recall
Children?
looking up.
Anyway,
looking
I
at
have a
camera.
thing with like
Okay.
people remind me of
Cameras
celebrities.
around that area?
I'm always looking.
Maybe traffic cameras on the traffic lights, but they're not for recordings.
Hey, Chance, you popped in. I know Joanna Bueller.
Okay, so, defense exhibit number 4. As you look at all those poles and everything around that roadside, does that appear to be cameras?
No, sir, not to me.
Okay. I may have a better picture for you here. All right,
That's okay, Tucker. I hate to interrupt you at this time, but I am going to have to give you yours, I believe. And so it's,
I just have one more question, I was gonna sit down, but it's up to the court.
all right, go ahead with
Okay.
one more question, and
All
then
right.
I'm going to give them a break.
Is this a better picture where you can see an extension of something that is coming out? And from your experience of being on the road and seeing, you know, the cameras and the flock cameras they use on the road, is that fair to say that that appears to be a camera?
No, sir.
If I may. And the extensions off these right here, those poles, here, and here. You're saying that those are not cameras, but you can't
That comment
decide
made
from
me
that
laugh.
photo that those are cameras.
To me, they do not appear to be cameras.
And then you're familiar with that road?
Yes, sir, Riverdale Road?
That was, Forest Parkway.
Okay.
And have you ever seen any cameras on that road before?
No, sir, not. to
It'll
the
be
beginning of my
52
recollection.
years later.
Okay.
52 years later.
I'm going to give a backing brief. It is now 11:40. I just asked you to be back at 12, and you'll resume at that time.
My goodness, guys. My goodness. I was just scrolling through these comments trying to get caught up. He did at one time, yeah. Jenny, did you see where I said it was a merge? No, I didn't see that, Lee. Stop it, Joanna. Oh, Lord. I missed that, Lee. I missed that comment. Oh, hey, Kath. I see you popped in. I don't see the comment, Lee. But I'm on StreamYard, so I may miss some random comments. Scroll back to the picture. Okay, hold on. Scroll back to the picture. I will if my mouse will behave.
And extensions off these right here, those poles, here,
Oh, Lee.
and here. You're saying that those are not cameras, that you can't,
Sorry.
aside from that photo,
I'm
that those are
yeah.
cameras.
To me, they do not look
I
like
gotcha.
appear to be cameras.
And then you're familiar
I
with
understand
that
what you
road?
mean.
Yes, sir. Riverdale Road.
That was, I mean, Forest
Dumpster
Park Road.
fire. Yeah.
And
yeah.
have you ever seen any cameras on that road before?
No, sir. Not to any of my recollection.
No further questions?
Okay.
Yeah, it looks like an
At this
off-ramp.
time, I am going to give the vacuum brief. It is now 11:40. I just asked you to be back at 12.
It looks like a off-ramp to me. Yep. There's so many details that I miss. Because I'm like watching the chat, keeping up with that, you know, that kind of stuff. So, um, hey, Kel, I didn't see you pop in. Miss Thang, how are you? He looked like he was merging onto the road and she cut him off. Yeah. Yeah. Yeah, I noticed that. I was looking back at some of it yesterday, some of the things that I had missed. I kind of scooched through the live yesterday, and yeah, that's what it looked like to me. Because she had said something like he um, ran into me or something like that. But all part of yesterday's conversation. I know. I know. I know. Oh my goodness. 11:45. She said they'd be back at what, noon? So we got about 5 minutes left. People are taking potty breaks. I think I'm going to follow their lead. Um, so I will, let me put this back on live. And it's going. I need to check on that Bryce Rhodes. Let me check and see if there's any updates on that real quick. Yeah, they're saying that they could see opening statements as early as this afternoon if they get the jury situation down. So that's exciting. This has been a long time coming, I guess. This case with Bryce Rhodes happened in like 2016 or something. So, yeah. Be keeping an eye on Law and Crime Network for that stream. Let me see if I can refresh this one and see if they've got a stream started or scheduled. I don't know if they do or not. I don't see one yet. It looks like the Charlie Adelson sentencing was today too. I watched 0 of the Charlie Adelson thing. Apparently that was a hot mess, but I did not watch any of that. Did not. Joanna says he was a police officer and detective. You can't play this guy. He sees accidents every day. Road raging. I don't believe he did much investigating or made too many attempts to get his own experts or other tests done. Yeah, I don't either, because you would think that he would have done, uh, wasn't there, were there any witnesses that said anything about any DNA or fingerprints on that knife? I may have missed it if they did. I know I may have missed it if they did say something, but okay, I didn't think so. I didn't think so, but sometimes things sneak in on me. It's like almost like, I mean, the prosecutor is very like straight and to the point, right? Um, both of them are. Both of the ladies over there. Tucker though seems to like, you know, beat a dead horse. So, um, forever and ever and ever, amen. It seems like I'm on diamond painting strike. No, not one drill all day. I'm sorry. Hey, Kel. How are you, Kel? How are you? The visitor said, I did slip out because the dude was wasting time. It was crazy annoying. Oh, were you there too? Or do you mean here in the chat? Um, yeah, they are expensive, Joanna. 100%. I mean, you hear all the time. You know, they'll have experts on the stand, and they'll say, how much are you paid by the hour? And these experts are like, oh, $952 million an hour. And they're like, oh, well, how many hours have you worked on this case? All my life. You owe me all the money in the world. That's how it feels because they get paid so much money. So much money. I'm like, what in the world? What in the world? Mm. State has money to burn, right? Okay, here in the chat. I was like, oh, is there another person in the courtroom? That's two people that's been here in the chat that's been there. That's kind of cool. Slow talker, slow talker Tucker. That's what we're going to call him. Can we nickname him Slow Talker Tucker? I'm not going to lie. I mean, I've said it from the beginning. I love to listen to him talk just because I like his accent. I like to listen to him talk. But that don't mean that I like the words that are coming out of his mouth. You know what I'm saying? Ah, Kel, right, girl? Kel says, I'm struggling today, but I'm not facing years in prison, so perspective is a gift. Needed your sweet voice saying lawyer over and over. Yeah, you do. Oh, Kel. I love you, honey. Lawyer. And you're right. You are absolutely right. Not facing years in prison. And I said it earlier today, this morning in the stream. I pray for both sides of this situation. I pray for Kenneth Herring's family, that they get justice. And I pray for Hannah's family and Hannah, honestly, because it's just a sad situation all the way around. She's a young lady who made, in my opinion, some life altering, life changing mistakes. And, you know, and her family has to live with that as well, you know? Ay, ay, ay. Yeah, you do, Kel. Yeah, you do. And if they go to trial, they charge a fortune, says Joanna. Yep, they sure do. Visitor says, did you ever post the link to your other channel? I did. I have a few times, but here, I'll do it again. Just for you. Copy. And here you go. Pasting it here in the link or in the chat. So if anybody here, this channel, if you're new in this area, because of this trial that I've been streaming and following this past few days, if you're here because of that, this is a craft channel. I really streamed this trial because I was interested in it, and some of my crafty subscribers and friends were, you know, interested in stuff, so I thought I would do it. And then I've enjoyed it so much, and it's been a good time. So I decided to just make a whole separate crime related channel and see what happens. So I'm going to put this link here in the chat, and you guys run over and subscribe to it. I would appreciate it. I would love it. Love it. Love it. Uh, yeah, I plan to drink lots of coffee over there and talk true crime. Uncrafty, how long did you say you had to wait until you can use your new court channel? I'm not sure, JC. I had to apply over there. So I don't know it said 24 hours, but I don't know if I have to have so many subscribers before I can. Um, um, so yeah, I'm not positive, but I'll try to go live as soon as I can. I don't care how many people's there. If I'm able to go live, I'll go live, and we'll sit over there and chit chat. So, but I would rather do that over there, um, because this is my crafty stuff over here. And thank you, Joanna. Yeah, you won the gift of me. You're welcome. You're so welcome. Thanks, Chance. I appreciate you subscribing too. Let's see. I will, Lee. I'll be putting that in there for sure, for sure. Gail says, Jenny, have you seen how many views your videos have been getting? Yeah, I have. I know. It's crazy. Um, uh, let's see here. Gray girl, what did you say here? With Hannah's gun training and how she was positive she never touched the trigger or that she never intended to shoot, why wasn't the safety on? Well, I guess that's a good question. I guess that's a good question. No crafting while criming. Lee says, no, Joanna, I was the first subscriber, so I want it all. You guys crack me up. I love you guys. You're my fam. My fam bam. Mm. Thank you, Brenda. I appreciate it. I'm excited about it. I should have done it a long, long time ago, but I just kept putting it off. Yeah, I kept putting it off. I'm a procrastinator by nature. So, all right. Let me see. It is almost 12 o'clock. Um, and let me make sure. Yeah, we're live. All right. Free says this trial really did take a while to start. I think it happened in 2019. It did, and it did take a while. But there was a lot of delays. There was a lot of different things that happened. Yeah. Jenny is always welcome here. She has a love affair with my dog. I do love George. George is my favorite. So Joanna has these amazing, beautiful, what are they? Great Pyrenees, Joanna? They're massive and they're beautiful. Oh, hold on a minute. Let me shut the camera. Okay. Sorry, I'm back. Dale came out of the bedroom. He's waking up for the day. So let me get situated over into the bedroom where I can have better light and better, um, yeah, yeah. I'm going to run over there. So stream is still going. I'm going to mute myself, shut off my camera, and then I'll meet you back on here in just a few minutes. And we'll see what's going to happen. I can't believe they're not going to lunch just yet. I really think that they're going to come back and she's going to say, okay, Jerry, go to lunch for an hour and a half or something like that. So, all right. I'll see you back here in just a few seconds. Okay, making sure I'm not missing anything. You guys, Joanna and Brenda and Mickey and Lee, you guys, yeah, can handle the chat while I'm gone for a few minutes. You guys are awesome.
Okay, before we bring the jurors back in, I want to make everyone aware in the courtroom that it has been brought to my attention that there may have been an attempt to make contact with one of the jurors. I just want to instruct you all that it is not appropriate. I did give those instructions at the beginning of the case. And so no one is to make contact with the jurors. They're here because they're committed to fulfilling their civil duty to sit on this case.
What?
And it's not appropriate for anyone to try to make contact with them while they're sitting as jurors on this case. Anyone who tries to do that, part of what I can do is that you will forfeit your right to be in the courtroom among any other measures that the court deems appropriate. So everyone is advised. Thank you. Okay. Counsels, are we ready to proceed?
We are, Judge.
Okay.
Wow.
And Judge, while they're coming in just for timing purposes, we're not going to ask any additional questions and we'll rest.
Okay, so, okay. Thank you, Chief Assistant.
What in the world? I did switch mics. I hope you guys can hear me okay, and I'm sorry if I just blew your eardrums out. Yeah. I mean, I don't know. I don't know that they will say who, but yikes. Yeah, I wonder if it was...
Thank you. You may be seated.
Yeah, I don't know if it was...
Does the state have any redirect for this witness?
Judge, I appreciate the time to consider that. The state has no further questions of this witness, and we would ask that he be excused and be allowed to return to North Carolina.
Yes, you're excused. Yes, you're welcome. Safe travels.
And the state has no further rebuttal and rests.
Okay. Okay, so at this juncture, all the evidence is in.
I bet you they take
And
lunch.
the court, at this point, will conduct what is known as our charge conference with counsels in this case, and therefore it is an appropriate time to allow you to have your lunch break. It's now 12:05. I would instruct you to be back by 1:45 p.m. Again, the instructions that I've previously given still apply. And so you're on break at this time. Have a good lunch, and I'll see you back at 1:45. Thank you. And thank you for adhering to the time frames. Oh, before you go, before everyone goes, let me just apprise you of what's going to occur next. Of course, we will do our charge conference so that we're agreed as to what charges you will be given, and then both the state and defense counsel will be able to give you what is known as closing arguments, and then we will release the case to you at that point. So that's what you can anticipate this afternoon. Have a good lunch.
All right, so, wow. I wonder who tried to approach a juror. I wonder who it was, who it could have been. Ay. All right, you guys, do we want to ixnay the, hold on, let's see what they're gonna discuss.
Can we move into our charge conference?
Yes, Judge, I'll be handling the charge conference.
Okay.
No, one second.
Attorney Tucker, did you receive that email?
I did, Your Honor.
Okay.
I did receive the state's comments. I'm looking forward to that.
It's very
Had a,
possible, Lee. Very
An
possible.
example of a jury charge that I was going to go through and see. I think for the most part, it is in order for those charges. We wonder where to put it.
Okay.
I was going to propose to the court and to the state that from the previous cases, the previous jury charges, this is where I would suggest it goes, and it's a pure suggestion to take it or however the court can use it. I believe the state made the most. Been doing it, said there's certain highlights on certain things that, you know, I agree.
Okay, would it help to have a printed copy?
Yes, ma'am.
It would?
Yes, ma'am.
Okay, all right, let me arrange for that. How about you, Chief Assistant? Do you need a printed copy?
I don't want to waste another 50
Tree?
pages. I'm fine.
It shouldn't be 50 pages now, let's cut that.
It's 52.
So, well, they haven't done their closing arguments yet, Brenda. I suspect that'll be next.
Yes. Could you guys,
And then they'll have to take some time to read the jury instructions. And that might last a while because there's a few charges here.
and which charge was that, Attorney Tucker?
And, Your Honor, it's basically the order. And I was going to take it and go through and see if it was placed. I know that it was kind of confusing my phone and looking at her having the pattern charges up. My phone didn't have the pages numbered. So I just put little notes, and I can go to that once I've seen how it is. I saw it briefly last night, looking at it, and I think there was one or two that, and it's purely a preference. I don't think it's something that's, got abuse or anything like that. I just think it's a preference, and I was going to give that suggestion.
All right, so you can have my copy until they bring the other copy so you can be reviewing. And for those of you in the courtroom, this is all technical, legalese, so.
All right. So, like she said, this is all technical legalese. I don't understand 90% of this stuff. So, do we want to cut off and resume back at 1:45 when they're supposed to be back from lunch? Is that what you guys would prefer to do? That will work for me. So we can just come back for part 2. Okay? As far as the verdict, Brenda, probably, I would assume tomorrow sometime. I mean, depends on how long their closing arguments are going to be. And also, I mean, if they're not back till 1:45, I would say their closing arguments are going to be at least 20, 25 minutes long each, maybe. Plus the reading of the jury instructions. I don't know that they would, yeah, I'd say it'll be on verdict watch the rest of today and probably part of tomorrow. So, yeah, let's go ahead and just cut the stream. Or is it easier? I think so too, Mia. Hi and welcome. Definitely should be a quick deliberation. In my thoughts, it would be anyway. But you guys let me know. Is it easier for me to leave the stream on, but put it on put it on like lunch break resumes at 1:40 and then I'll come back at 1:45? Or is it easier so that you guys can come back to it? Or is it easier for me to like stop this one and start a new one? You know what I'm saying? What's easiest for you guys? Probably double that for Tucker, says Gail. Ay, ay, ay. That was funny. Are they timed like a specific allowance for each? They can be. Sometimes they're not, sometimes they are. It just depends. I'm not sure if for this one. Yeah, so do you guys want to stay? Do you want me to leave this stream going until and then resume it? Like I'll come back to this same stream at 1:45, or do you want me to stop it and start it back? See ya, Kath. Billy says, hello, good morning. Did I miss anything good? Mickey says, I will be back of Coyote. Like whoever said Tucker time, right, Brenda? Oh, Kel says, I think it's better to end this one and start a new one after lunch. That way, this one can upload to your channel and be available for those that missed it. Yeah, I can do that. I'm just wondering which is actually better to do because some people say they don't get that second notification, and then so I really don't know which is a better option. What I've been doing each time is stopping it and then starting it. So ay. Let me just leave this one up because I haven't done that before. So let me just leave this one up. And kind of see what happens with this one. Since all the other ones I've done, like started and stopping and done like part 2 of that. So let me just leave this one up and just have one whole day and see what's easiest for people. I'm going to rewind to watch from the beginning. I just won't be able to see everything that was said in the chat. Right. I got what you mean now. Because if you rewind it, the chat only rewinds so far. But then if I go ahead and stop it now and then it uploads. Sorry, I'm just working this through my head. But it seems like it takes the live chat forever to go with the, to be downloaded into the stream too. The chat replay, Okay. So a few of you have said that. I'll go ahead and just do that. I'll just go ahead and stop it and start it. Then Brenda says, well, that way you'll know for the new channel as well, which would work better. Okay. I'm going to leave it alone. I'm going to let it go and see. Okay. I'm leaving it. I'm going to leave it. Let me make a Kel's like, oh, I hate you. Kel's like, no. Let me make a new banner. Hold on. Let me stop that one. Create a new one. Where's this one? Let me use this one. I have to edit that. That's not the one I wanted to edit. Stop it. Stop it. Stop it. Stop it. This. Okay. Well, this will be a good exercise to kind of see if people come back, or because like I said, there's been so many people that's like, I couldn't find it. I couldn't even, like, if I looked on my channel, they couldn't find the second stream, or they didn't get a second notification. It's weird how that works. Court is on lunch break. We will resume at 1:45 p.m. Eastern Standard. All right. There we go. All right. Now, that is that. Let me go ahead and I'm just going to go ahead and push
For
play.
those of you who are here, you're certainly welcome to stay, but it is technical, so you can go for lunch and be back.
I'll let all the technical mumbo jumbo go while you guys are hanging out and waiting and watching. And then when they're done with their little shenanigans, then it'll be closer to lunchtime. Yeah, there's nobody in the courtroom. Nobody in the courtroom. All right. I'll see you guys back shortly. They've even muted their camera. Looks like. Make sure I've got my audio on. All right, you guys. I'm going to run and grab a bite to eat myself. See you in a few.
I know we had some discussion about whether it would be a prior statement or prior inconsistent statement. Are we okay with that charge?
That's no longer the pattern, but I have indicated to counsel I would not object to his request for prior inconsistent statement.
Okay, all right. So we're good with that. Thank you.
And I think it's that it was the single witness account. It's fine. In that area, it's fine. That was the only one I really saw.
The single witness corroboration?
Yes, ma'am, and it's fine where it's at.
Right.
Something a little close and done.
Okay.
And it does say bare suspicion instead of grave suspicion. But once again, that's tit for tat. I'm not going to argue that. It gets across what it's supposed to do. So.
Okay, so you're saying it should be grave?
No, it's not. I mean, like I said, I'm not going to sit there and nitpick like that.
All right, I have another copy, so you
okay.
can hold on
Alright,
to
thank you.
that. So everything, there are no objection to the charges as outlined?
Can I just look at his written version?
Yes.
I want to make sure the highlights that I'm seeing on my computer aren't visible to the jury.
Right.
I mean, on page 6, it's barely visible where it's highlighted where I changed it from his to her on the second line. So I don't
Page
think
6.
it's anything that matters. You can just see a slight gray shading. I don't think it's
Oh,
going to be.
where it's changed to her.
That's where I changed it, so that's why I'm seeing the highlight, but I don't know that that's, I'll show council and see if he has any issue with it. So
Right.
we can print that. And Mr. Tucker indicates he's fine with leaving it as is.
Okay. There's a little comma on page 25, I'm just gonna wipe it out. It's nothing.
I said the floating comma.
Yes. Under DNA, I just wiped it out.
Some towards the bottom and the last page as well.
The last page.
I think it's the page 51 has 3 floating dots.
Okay, I'll just
I
wipe
don't
it.
know why they're there, but there they are.
I took it out. And I'll just use this copy to send back with them.
Do you see anything else?
So you reviewed the printed copy and everything's okay? So there are no objection to the charges that would go back to the jury?
Not from the state.
Okay, thank you.
None for the defense.
Right, and then if we could just determine what evidence is gonna go back with them, that would be great, thank you.
So my position.
And you're gonna, I want, you can put on the record what's going back so that I'll double check before
Yes.
it goes back, so. You can,
This.
It's a motion. Motion was tempted to back.
I just, you can copy this one. Just gonna grab these and take a copy of this one. And then I just need a copy of- I'm making a copy of the indictment to go back. Yes. Yeah, the entire, yeah, I have the entire thing. Okay.
I don't know how to use that machine, so.
No.
Yes, thank you very much for all the, considering all of our edits and emails. I appreciate it.
Thank you. Very accommodating. I think
Who's here?
So we're taking out all the statements. Okay.
Well, her concern was if I usually when closing, she didn't want too far from the other.
Okay.
But I think we can still keep it
I was
separate.
just, yeah, pulling them out to put on the record.
All right.
Hold on, let me go get my evidence list and we can do that.
You got this.
What? That, yeah.
You ready?
Yeah.
Oh, what? Yeah. Yeah.
Yours is this. Yes. Yeah, put in the sections.
I'm about to put that up.
Okay, well,
Judge, after reviewing, defense counsel and I, at your request, have reviewed the evidence that has been admitted to determine what would be able to go back with the jury. I think we have an agreement, but let me put it on the record. The state's exhibit 3 and 4 are 911 calls, and those discs cannot go back. State's exhibit 6 is also a 911 call. We agree that when and if the evidence goes back, that the jury can have State's Exhibit 15, which is the firearm, but they cannot have the ammunition, which is State's Exhibit number 17, at the same time. So when and if they request to see the ammunition, then they would have to give the gun back and we could trade out.
Okay.
The State's Exhibit 19 is a video, the body-worn camera. State's Exhibit 20 is the cell phone video. State's Exhibit 39 is the recording of the defendant's interview. As it relates to defense exhibits, State's Exhibits 2, 8.
Is that state's exhibit?
I'm sorry, defense exhibit. Defense exhibit 2, 8, 9, and 38 are all written statements, and written statements are not permitted in the jury room. They are permitted to come into the courtroom to view any of them that they wish. Defense exhibit number 10 is the autopsy report, which is again also considered a written statement and is not permitted in the jury room. The only other thing that I see is the portion of the defense exhibit 40, which is the portion of the body cam that contains the defendant's statements from the back of the patrol car. That would not be allowed to go back.
that is correct, Your Honor. And,
Okay. So we'll just place on the record specifically what's going to go back. So I have what
Everything
is
but that?
I have what is not going to go back.
Okay.
So just to have it on the record.
Yes, Judge. What was
That's not too
and I believe
It's
there
not.
was one that they used to refresh
41.
Haywood, and y'all kept that back over here.
it's not admitted, so it
Right.
couldn't go back anyway.
Right.
Right.
The what we show would go back is State's Exhibit 1, which is the inline photograph. 2 and 2A, which are the maps. 5, which are the buccal swabs. 7 through 14 are photographs of the scene that would go back. 15 is the gun. 16 is the holster. 17 is the ammo.
and 18 is the shell casing. So we have just agreed that 15 and 17 can't be in the jury room at the same time, but they can have access to both of those. 21 and 22 are photographs that would go back. 23 through 29 are photographs of the vehicles during the search. There is no states 30, because that was the photograph of the medication list that was excluded. 31 is the inventory sheet. Yes, sir.
That's still written, I mean, I think to be consistent with everything else, probably not. But,
I'm fine with that, Judge. I didn't notice that, but it is technically a written statement, so we will add 31 to the ones that don't go back. It is the inventory from the victim's truck.
Okay.
So do you mind finding that? States 31. Can we pull that out?
Sure.
Just so don't have any accidents while I'm putting this on the record. And then states 32 through 35 are autopsy photos that would go back. 36 is the projectile that would go back. State did not tender 37 because it was the body-worn camera, which was used as a defense exhibit, so we did not have to use a 37.
Okay.
And then 38 is the Miranda form from the state side that would go back.
Okay.
Now, it's gonna be out of order because
But you're on your toes.
there was no real order to how this went. So, I show that defendants 4, 6, and 7 are photographs that would go back, and 5. Defense 12 is a demonstrative of the human body that we're fine going back. Defendants 14 through 22 are still shot photos that would go back. Defendants 23 through 26 are photographs of the victim's car that would go back. Defendants 27 through 35 are photographs of the defendant that would go back. 36 is a photograph of the vehicle that would go back. And 39 is the defendant's shirt that would go back.
Okay.
Sounds about right. Yes,
Okay.
ma'am.
All right. Okay, so it seems that we've taken care of what needs to be taken care of, and you can go to lunch, and we'll be back at 1:45. Okay.
And I'm gonna hopefully be doing a PowerPoint, so I'll bring the material. Hopefully we won't need IT. I think simply you plug it in. If we can plug it in from there, if not, but if so, I would request them to just get it set up.
Oh, for the IT to come
Yes.
in.
Just if necessary. I mean, he showed me the other day, and it should work the same way.
Right. Well, just out of an abundance
Right.
of caution, we'll have them here. So you want them here at 1:45?
Yes, ma'am.
Okay, all right. We'll request.
All right.
Thank you. Have a good lunch.
You too.
Hey guys, it's me again just for a quick second. I saw a comment in here a while ago that said that a feed was cut. So it looked like they had to fix an issue and that stream is back up and running. But you're more than welcome to stay here and hang out too. We love new people. Hi and welcome to anybody that's new popping in. Just an FYI, this is a crafty channel here, but I am starting a new true crime channel because that's another one of my passions, right? So I'm leaving a link in case you missed it in the pinned comment. I'm putting this brand spanking new channel. This thing is like brand spanking new. In the chat. So I would love for you guys to subscribe over there. I will be, as soon as I get the green light from YouTube to start creating live streams on that channel, all of the crime and trial content that I put up and trials that I stream will be there. So would love for you guys to subscribe over there as well. If you love crafty stuff, you're more than welcome to hang out here too. Court is on break, on lunch break until 1:45. So I will be leaving this stream up until we resume at 1:45, and I'll see you back there. Then, thanks guys for hanging out in the chat, chitter chattering. Hi Nika and welcome. Hi Roslyn and Brooke Blue. Welcome, welcome. So yeah, see you guys shortly. I'm gonna go grab a bite to eat. I was going to do that a while ago and then got busy and didn't get a chance to do so. So, crazy time of the day, right? It's 1:07 p.m. Eastern here. Lunchtime, husband's got to go to work in a few hours. Second shifter there. Got a couple of kiddos. So it can get a little bit crazy this time of the day. Anyway, hi Casey Collins. Welcome. Thanks for stopping in. Hope that Hannah and her family are having a good lunch, and I hope that Mr. Kenneth Herring's family is having a good lunch. We'll resume shortly. See you guys in a bit. Awkward. See you in a little bit. Hey, guys, back from lunch. Don't look like they're back from lunch yet, though, does it? Fix this camera. How is everyone? How is everyone? So it looks like we have a lot more people here at the moment. Hello and welcome all the new folks that have popped in. Hello, hello, hello. So, little disclaimer, you have stumbled onto a crafty channel who decided to stream a trial because I'm interested in it, and some of the other people that subscribe to my crafty stuffs wanted to watch it too. So that's what we did. And I did not expect to have this many people show their interest in it. So I started a brand spanking new channel last night dedicated to crime trial coverage only. When you start a brand new channel, YouTube lets you go live, but they like give you a time limit. So, I may be able to go live from that channel tomorrow. I have to see if they will let me. And just in case they do, you will find the trial coverage there. If you don't see it here. So let me put that link in for you guys so you can go subscribe and make sure to turn notifications on there. Let me paste that link here in the chat. The new name, or the name of the new channel, Dawn, hey Dawn, is Crime Cafe. So, let's see. Okay, that's there. I would love for you guys to subscribe over there. And then, like I said, we will plan to do the trial coverage tomorrow. I'm not thinking that they're going to have a verdict tonight. If they do, I would be shocked. So, probably tomorrow. But, I mean, we don't know, do we? We'll have to wait and see. So, thank you, Billy. I appreciate that. If for whatever reason I'm not able to go live from the Crime Cafe channel in the morning covering this trial or the new one, there's supposed to be another one starting tomorrow for, I think it's Kentucky versus Bryce Rhodes. I'm interested in that one too. So if you don't see anything over there, then it will be here. As long as you're subscribed to the other place, to the Crime Cafe channel that I linked, and it's also pinned as a comment in this live chat, then you can find it here. We are still just waiting on the feed to start back from as soon as that door swings open. We've been able to see that when that door comes open, you can see the judge coming in, and you know that things are getting ready to happen. We know after this morning, the judge likes things to be timely. Apparently this morning there was a juror that was stuck in traffic, and she was like, not having it. She was like, nope, this courtroom runs on a schedule, and that's what we will do. So I see so many comments in here. You guys are really, really sharing your thoughts and your opinions, and I like that. As long as they're respectful. Always, please. Keep your comments respectful, please, and thank you. Because this is a chat or because this is a chat or a crafty channel here that we're on currently, moderators are great, but they're not like they're not they're great for welcoming people and reminding people to hit the thumbs up and dropping links as they're needed, that kind of thing. But whenever you have, a lot of people and a lot of opinions, sometimes things can get a little bit rowdy, howdy, right? So anyway, I guess I will be on the hunt for some moderators over there. You guys know who you are. I'm already looking at you, right square in your eyeballs. Eyeballs is. Hello, Jason Harris. Welcome, Arthur Harris. Welcome, Straightforward. Dawn, so this morning they had their rebuttal arguments. There was some good. I mean, it's worth a watch, definitely. Definitely worth a watch. I would say that. Jason says she shows absolutely zero emotion on the stand with her cold, dead, soulless eyes. Aish. Aish, aish, aish. Yeesh. Thank you, Dawn. Thank you, Dawn. I appreciate you. Another CG says eyeballs is. Yes. Yes. Eyeballs is. Straightforward says she reminds me of a 12-year-old trying to lie their way out of a butt whipping. Ooh. Right? Aye, aye, aye. All right. Yeah, I don't know about the whole the entitlement thing. I don't know. I mean, I don't know her well enough to think that she has an entitlement issue, but I mean, you know. Arthur says, I wonder if she's done any community service in the 4 years that she's been out. I don't know. Do not know. Twiggy says, I'm still stuck on her saying I'm straight, but he ain't. On that 911 call. Like, what? Oh, I thought she said, I'm safe, but he ain't. Did it say straight? I thought it said safe. I'm straight, but he ain't. I'm safe, but he ain't. I don't know, Twiggy. Why did I think it? Maybe it did say straight, and I thought it said safe. Thank you, Straightforward. Thank you, thank you. She was trying to be a vigilante. Citizen's arrest doesn't really fit. She chased him down and shot him, giving vibes, Arbery vibes. Same meaning. Mickey Joe said Gomer tried to citizen's arrest Barney once. How'd that work out? How did that work out? What'd you guys have for lunch? Did you guys have lunch today? Or a late breakfast, or a second breakfast, or brunch, or maybe depending on where you're at, you might be having dinner. I have friends in Australia. It is where my girly girl is at in Australia. It is almost 2 p.m. Eastern right now. So 2, 3, 4, 5, 6. It is almost 6 a.m. It is time for her to get up. So she would be eating breakfast soon. There we go, Kath. See, Mama, it's 6 a.m. here. Oh, a big bowl of chili. That sounds yum. Arthur, question. Do you do beans? Do you do beans in your chili? Just questioning it. Sherry Jones, we love spaghetti here. Any kind of pasta. Yes. I like spaghetti. Egg rolls sounds good too. I just put lunch on for the kids. We made pizza. Yay. Straightforward said that's the name I was looking for. Hmm. Ooh, Freeze says he's full of O'Charlie's. Oh, I love O'Charlie's. But I always get O'Charlie's and O'Reilly's mixed up. When somebody says O'Charlie's, I always start singing O'Reilly's. Auto parts. Deborah says it irritated me that she tried to blame everything on Mr. Herring. I mean, how many hands did the man have? Yeah, I know. Arthur does beans in the chili. Yay! Yeah, yeah, yeah. So do we. Gotta have beans in the chili. I like beans in the chili. Now, I'm talking about like first, like what they call chili soup, right? But I'm thinking, like when you buy the canned chili for like chili dogs, my husband and I always argue. He likes the hot dog chili without beans, and I like it with beans. We always have that argument, and we've had the same argument for 20 some years. And sometimes I win, sometimes he wins. It depends on who gets the groceries first. Hold on just a minute. Got to plug myself in. All right, plugged back in. No beans for hot dogs. Ah. Dawn does beans in her chili too. Kidney beans and chili, yes, ma'am. Kidney beans. Gail's son is fixing something. Excuse me, I got strangled. I don't know what it is, but it smells good, says Gail. We have breakfast for dinner a lot. My husband's favorite food is breakfast, like sausage, eggs, biscuits, gravy, that kind of stuff. Twiggy said, I can't believe she's this late. My judge was 2 hours late yesterday. That's how I discovered her trial was next door. Oh, wow. Arthur loves brunch for lunch. Another CG says, whatever comes in the can. She is running awful late. I mean, it's almost 2. Looks like they had everything squared away as far as the charges meeting that they did before lunch, I don't know. We'll see. Straightforward likes the beans in the chili. Yeah. Ooh, Kat says bacon all day, every day. Yes. I love bacon. Deborah says, yuck, canned chili. Well, now, if we're having a pot of chili, then I prefer homemade, right? Like, put it all together. But if we're making just chili for hot dogs, we don't mind the canned chili. Straightforward's going to go reheat some beef stew. Ooh, that sounds good too. Northeast Ohio. Oh, Casey's in Northeast Ohio too. Nice. Hopefully no more jury tainting attempts, right? Yeah, I wonder if anybody looked on Twitter or X to see if there were any hints about who that was or what had happened. What had happened was somebody tried to get a hold of the jury. EUC, what's that? Casey. Kath, we're doing cabbage, noodles, and bacon tonight. Oh my God, that sounds good. I love cooked cabbage with like smoked sausage. Yes. Or, I cannot believe we always have a big, massive food chat. Like sauerkraut with smoked sausage or hot dogs. That's good stuff. But you have to have mashed potatoes. If I'm having sauerkraut with sausage or hot dogs, I gotta have some mashed potatoes with it. Fried cabbage. Yum. Come on, Judge. Come on, Judge. Wonder what the holdup is. Wonder what the holdup is. I'm gonna run real quick and look. See. If there is any updates on Twitter, I guess. See if we can find something out. Oh wow. We have, looks like, yeesh. It looks like the Bryce Roads should be starting. Yeah, we'll have to take a look at that. Mickey said y'all are starving me to death. Let me run over here to YouTube, see if I can find that on Bryce Roads while we wait for this one to start. Let's see. All right, give me a second, you guys. Law and crime. Oh, and the Charlie Adelson sentencing. Did anybody watch that? What happened? I would love to know what happened because I didn't get a chance to watch that. I didn't really watch the trial, but like I didn't really have any interest in it, but I do want to know what his sentencing was. You know? Cabbage fried in butter. Now y'all are starving me to death, and I ate. So, I don't know. All right, I'm not seeing it there. Let me go to their other channel. See what we can find. Ba-ba-bum. Ba-ba-ba-bum-bum-bum. Yeah, I don't see a stream yet, but we'll kind of wait around and see what we can find. Let's see. Ooh, the Wisconsin Visine case. That was good, Arthur. That was a really good trial. Okay, life without parole, and for 2 other charges, 30 plus for each. Thank you, Andrea. Welcome to the chat, too. Welcome, welcome, welcome. The Charlie Adelson case, Mickey, is that what the one you're talking about? That's crazy? I just didn't get into that one. I don't know. I tried. I mean, I did start, but I was like, meh, it's not. It just didn't grab me, you know? Didn't grab me. I did hear lots of stuff about his mom and how she got charged, and yeah, all kinds of family dramatics. Holy cow, Judge. Let's get the show on the road. Oh, there she is. She listened to me. Wow.
Okay, good afternoon, everyone. Before we broke for lunch, I instructed the jurors that once we got back, we'd be doing closing arguments. Is the state ready to proceed?
State's ready, Your Honor.
Attorney Tucker?
I talked to the IT guy. I couldn't pull the presentation on my computer in my office. I needed him there, not here. So I'll proceed. If someone does walk in, I told them to just hand the paper.
Ben is here.
No, and that's it. I couldn't get the power on my computer at the office. Somebody tried to drag it last night or something. So I've asked them if they get it to work to print it and bring it to me. So if they do, I just told them to give it to the lady in the back.
Okay.
It would be not on the screens.
Okay, all right. Okay, we can move the jurors back.
Right, Dawn, she heard me. She heard me. And she's like, yes, yes, we are on our way. We are on our way. Are we ready for these closing arguments? I'm ready. I'm ready. I know, Arthur, this lawyer is the king of delays. Wow. Very first day that they were in, day 1 of the trial, they walked in and she was sitting by herself. He hadn't showed up yet.
Ladies and gentlemen of the jury, before we broke for lunch, I indicated the process that would commence after lunch, and at this time, the state is going to begin its closing arguments, and the defense will have an opportunity to do so as well, and then the state will have the final closing argument. So I'm going to ask them to do that at this time. Okay. All right, Attorney Tucker.
Ladies and gentlemen, 2 weeks, finally get here. And as I stated as we began, that the judge would instruct you on the law, the judge would instruct you on the roles, and the judge would give you guidance to take all that you've heard, all that you've seen, all that you've been through this last week and a half. And I told you that I would try to get as much evidence out so you could see the full picture. Because as I said, when we're dealing with the verdict, you must honestly be seeking the truth. Wanting to hear more, wanting to see more, wanting to see the full picture of what happened. To hear what really happened, why this occurred, how this occurred, and why not. So as we began, started with the opening. Of course, I gave you a little story out there to try to keep you interested. And I think we got more to talk about than that bullseye. So I want to go through what you saw here today, because the judge is going to say everything I say, and everything the state says is not evidence. So you to disregard it. But I don't want you to disregard what I'm saying, because I'm not trying to say is evidence. I'm just trying to be a highlighter. From all the evidence we were able to get out, I just want to be able to highlight it and say, this is what I felt was important. This is what I think you would want to know is important. And then it's up to you to decide. Was it important? Was it not? Was it something that I needed to see? Was it not? So we started off fully understanding that the state has the heaviest burden in the world to prove all this evidence of what they have put in the indictment beyond a reasonable doubt. You probably heard things like probable cause, which is a very low threshold. Preponderance of the evidence of one has 51%. They win. And then reasonable doubt being the highest standard out there. And the judge is going to read to you what reasonable doubt is and what classifies something that is reasonable or not. And I'll let her go ahead and do that. And I won't try to waste your time with that, but I will start at looking at it as a heavy burden the state had to prove. And they brought up the first witness, and it was Mr. Herring's sister. And she got on the stand, and she showed a picture of her brother, God rest his soul. And she talked about how she knew he had diabetes. She knew. She's a sister. But that standard is very high, beyond a reasonable doubt. Why wouldn't a doctor come in here and say, I have been there, I've tested him, I've seen it, I've instructed him what to do, and he has diabetes, and this is what diabetes does, and this is how it affects you, and give you everything so there's no question of what diabetes does. There's no question of why there's needles in the vehicle, so many of them. There's no question on how somebody would feel if they had high blood sugar or low blood sugar. We didn't get that. And from there, jumped right into Mr. Robbins, Terry Robbins, that state official. And he comes in and he says, you know, I was there at the accident. The first accident that involved Mr. Herring and Mr. Stanley Kimball. And Mr. Kimball was not here to testify. And Mr. Robinson said, Mr. Herring was walking around his vehicle. He saw him run the red light. Saw him hit his 18-wheeler. Saw Ms. Payne there. Pull over, concerned, see what's going on. Everybody okay? And he starts talking about something's wrong. Something's wrong with him. And in the 911 tapes, you hear him going back and forth with an exchange. Doing something wrong. Did you do something wrong? Is it a crime? And him saying, sir, you just... And he stopped. He didn't say run the red light because he knew it was on the phone call with 911. He didn't want to prejudice that case in any form or fashion. But he saw what he saw. And then when he's talking to Mr. Herring and telling him, stay away from the car. That thing's about to blow up. I mean, it's smoking, radiation fluids coming out of it. It's not reasonable to think somebody could just hop in that vehicle and just drive off. But yet, his testimony was that he walked around it, made sure the tires were okay, nothing's going to stop it from moving. He got in it and revved it up. He revved it up and you hear him on 911, sir, get out of the way, move out of the way. Get the tag, get the tag. And he says he gets in his vehicle and starts driving off. There's no reason given. There's no doctor to come in and say, well, this is what occurred. It's just an individual who's a state official, who we find out later is a correctional officer, but who gives his account of what occurred. And when talking with him at the stand, what he had said at the incident location and what he had said the day it happened, it was a little bit different. He was using words like confused. Darcy wasn't really doing much, kind of just out of it. Now, he himself, even though he is working at a medical correctional facility, he doesn't have any medical training. He doesn't know what to classify, what to look for, or what to do unless somebody comes and tells him that this person has a disorder, or this person has needs, special needs, or this person needs this. But yet, he wants to give examples of confused, out of it. Whereas in his statements in the report and his interview at the precinct, he was irritated. He was walking around the vehicle. He was looking into it, trying to get into it, looking to see what's in it. Then he cranks it up, and he revs it up, and he drives off. So that's how it all begins. And in the meantime, he's on the phone with 911. Miss Payne's on the phone with 911. And they're talking to them both. And the one thing both of them wanted, and the one thing 911 wanted, was that tag information, the tag number. Now, you heard testimony that he'd already caused one accident, and she was looking out for the safety. Now, smartest thing in the world to do, to get behind a car from somebody who's being erratic, somebody who's leaving the scene when you got an officer telling you not to. It's not the smartest thing. But when you have good intention in your heart and you're trying to help somebody, and you don't think that she's never been in an environment or a situation to ever think somebody's gonna grab her and say, I got something for you, bitch. She would never contemplate that. So she gets behind and tells 911, hey, I didn't get it, but I'm gonna go get it. And you meet Mr. Robbins. Good, go, go, go. But yet he wanted to say, I told her not to go. I told her she shouldn't chase. But you heard the 911 tape. You never once heard him say that. But it was a little bit different, a little bit more biased. And maybe media played a part, maybe memory played a part. But you can decide that yourself. You heard his testimony. And pretty much, besides coming to the scene later on, that's about all he can tell. That's all he can add to this story. And he added a little of his own flavor in it to say, I did this and did not. But as we talked when we were choosing the jury, and I said the mannerisms and what you see from an individual on the stand, y'all know if they're telling the truth or not. Y'all know if somebody is not being as truthful as they can or trying to hide something. So they get Mr. Robinson down, and then you hear Miss Something. And she's the 911. Custodian, operator. I'm not sure it really claimed out what it was, but she works at the 911 call center. And she's there, and she says, hey, we take calls. We record them. We hand them to our upper people, and they make sure nothing alters them. They make sure nothing changes. And that's about all she can say. And she says, hey, this 911 sounds to be in the same shape, form that we received. But she never received that 911 call. She was not the operator. So we have to just take her word for it. Because there's nothing really to contradict. So she comes in here and gives an explanation of the 911. And we hear it. And you hear exactly what we were hoping you to hear. That very calm voice of Miss Payne. Man, there's been an accident. I don't know if I'm supposed to call you. I don't know if somebody else has called you, but I just want to let you know there's an accident, and this is the location. And later on, as he's walking around, being irritated, grabbing, looking at his car, not answering questions, trying to find out if he's done something wrong or not, then you hear her say, "Man, it's taking forever. What's going on here?" And of course, you heard testimony that traffic was bad and that it was difficult to maneuver to where you needed to. I'm not trying to throw anybody under the bus. I'm just telling what evidence was presented. So this traffic jam and this delay of the law enforcement to come out there and write a report to find out what's going on. In this delay, there was an opportunity, a gap. And in this gap, Mr. Herring decides he's going to go. She's going to leave. And she said, "Man, I'm safe. I'm in my car. I'm just going to follow him and get that tag number for you." And you did hear her say, "Man, we don't want you to chase. We just want you to be safe." The second time it was said, they're talking at the same time. So how one heard the other, I'm not sure, but they were talking at the same time. And they were calm. And they were speaking calm and saying, "Hey," and then there's radio silence. Nobody's saying, "Stop, you need to stop right now. Don't follow. It's dangerous. You got to stop." No, nothing. Radio silence. So you think, okay. In their training, they're taught to say, "Hey, y'all don't need to chase, but we get that tag. We got to do this so that things don't happen to us. So don't chase. It's our policy, but hey, get that tag." So she's following this car, not knowing, not understanding what could happen, because she's never been in it. She's 21 years old, never been in a situation like that. In her mind, she's a young individual trying to help out. She hasn't seen the bad sides. Heard the old phrase, "No good deed goes unpunished." So she's trying to assist, and in doing so, she's hanging back enough to get the tag number. And she does, and she reports it to him. In the meantime, we heard that Mr. Kimball had already got that tag number and given it to Robinson, who gave it to 911. So in this time, excuse me, Miss Payne is following. Why didn't somebody say, "Hey, we already got the tag, stop"? No one did. Amongst the confusion, it's still, you're safe, you're behind them, just attack. And then she says, "You need to come back to the location. And you need to stop." She goes, "Man, I'm not gonna follow me. He's already caused one accident. We're the police. I'll just hang back here till the police gets." Now, if the traffic is as bad as they said, what's you gonna do? Pull off? Where you gonna go? You got traffic. The traffic wasn't as bad as it was perceived. Because later on you hear Mr. Williams, as he's cruising by the whole thing, puts his hand out there with the phone, takes it on. It looked like he was concerned about traffic or anything. When you see the pictures of where the car finally ended up, you see there's a big gap that somebody could have gone around to the right. Mr. Williams is actually going to the left. Just videotape. So you try to take everything you hear and try to visually picture it. And you've heard up to now that he got diabetes, or whatever that's worth. Then you heard, well, it was irritable, he was walking around crazy, he wasn't listening to me, he sure as hell wasn't listening to me. But, he's confused, kind of out. How that changes, we don't know. How those stories change. But you, the decider of fact, can take what you've heard and take what you listened to and saw, and you can decide that for yourself. And that's what I wanted. I wanted all the evidence out here so y'all could decide. So after something comes up there with the 911, then they bring McCraney in. And she sits down. she's got a good story. She's telling it. She's wound up. She's talking about, yeah, I saw it. It was crazy. She jumped in the window. Now, literally, we don't know. There's no way she could have jumped in the window. But you try to extract from what they say. As we said, every time there's a story, there's a little bit of truth in it. A little bit of truth. So maybe the part that she was in the window is when she's being pulled in the window. Maybe the part that she jumps when she's pulling back and getting pulled in. We don't know. But you heard the testimony the same I did. And you'll get to decide out of that, was it really believable that she came up and said the vehicle stopped like an inch away from it. Vehicle stopped like an inch away from a vehicle. It appears they hit, but it was like an inch, so give or take. And then she said she pulled up like a foot, but she was behind the Jeep at that time, and she couldn't see what was going on, but she heard a gunshot. So we got a person jumping in the window, somehow, some way, or whatever, and a gunshot. So we know there's a gunshot. And a lot of people congregate and start going back and forth on who did what, how they did what, and that ends up being the testimony from the friend. Then you hear a detective Roland come in and say, hey, I just did my job. I went to the jail, I swabbed her, I'm out of here. Short and sweet. How you going to dispute something like that? If it was done properly, let's get them on the stand and get them out. So they swabbed. They got DNA. And then you have Ashley Hoss. She comes in and she says, you know what? I do fingerprinting. I do that job that everybody always wants to hear. You hear in these shows and movies. I think it does. I get the fingerprints. We take the laminate. We look at the genes, the alleles. We look at everything we can. Then we compare. And we compare. The one thing they didn't compare is any kind of fingerprints or any kind of DNA on the trigger of the gun. That seems to be what it was at dispute. The trigger. Who pulled the trigger? What happened with the trigger? But nobody tested it. But they did test the gun for DNA. And they came in and said, there's DNA. There's a dominant DNA, and there's a minor DNA. And we all sit here and we learn something new about DNA as we're listening. And they said the dominant's going to be more of one person's DNA than the other. And probably no surprise to you, there's more DNA from Miss Payne on her gun than there is from somebody else. So, but they did say two males' DNA on this gun. And it was on the slide, the top of the gun, where the bullet would eject, or the shell would eject once it's been discharged. There's male DNA on it. There's two men. So as you hear, as we go further, you hear that there was a hand in the struggle between Mr. Herring and Miss Payne. And his hand got on top of that slide. And they were fighting back and forth. She had a good grip sometimes. She didn't have a good grip sometimes. But there was male DNA. So you can look at it, and as they talk about circumstantial evidence, you conclude that it was Mr. Herring. But who's this other male DNA? Where'd this other male come from? And you heard her say she took the gun off, handed it to Officer Ritchie, who had no gloves on. He was hanging on that gun for a while. He had to, until he could go put it in evidence. So there's your other male. So we're slowly building up to see evidence that may be helpful, that might not be helpful. And as we continue, then you hear from Emily Curran. And she's talking about how she looks at the fingerprints, the palm prints, evidence collected, DNA, all that stuff collected. She takes it. She works with the lab. She gets things going. And she starts talking about the cartridge and the container, and as I jumped in there and finally said, we're just talking about a magazine. I mean, we're talking about a clip and bullets, right? I mean, you know, sometimes when we're dealing with doctors in the GBI and everybody else, they're a little smarter than us, they talk a little bit higher than us. But I wanted to make sure we knew what she was talking about. And that was the clip and the bullets in it. And she kind of said there was some that would be enough to test, and there was some of the stuff that wouldn't be enough to test. But why would you want to test the bullets and the clip? It's her gun. Who else is putting bullets and clip in her gun? But they never once mentioned about testing the trigger. We got DNA on the slide, that's good. But we don't know what's on the trigger. And maybe it was because they didn't get a big enough sample, or somebody didn't do their job right and get a sufficient sample for them to test. But we do know one thing. It wasn't tested. So we don't know who's the dominant, who's the minor, or who's is on the trigger. And from there, the witness, Miss Rosser. And Miss Rosser got up and she started talking about what she perceived happened. And I believe I showed her where everybody else was using this map to show where the roads are, where it all happened. And I'm not sure, maybe it was her parents. I mean, some people don't, recognize markers or where they were. But she started saying something was going on up here. Everybody else saying it's going on up here. But she says it's going on up top. And she says that she was in a car by herself. She was looking at the scene. But she saw Miss Payne run to the car and try to conceal herself. Put a hoodie on. A bright pink hoodie. If somebody's trying to conceal themselves, they're not going to put a bright hoodie on. But she never once mentioned that her shirt was ripped and exposing herself. But she saw it all. She saw what happened, and she could testify. And her statement was, a white male came out of a vehicle that drove up behind him and then drove off once he saw the gun. If somebody's going to interject themselves in a situation like that, I don't think they'd wait for somebody to turn around. And I think they would have stopped it, or grabbing it, or stopping it, or somehow thwarting what was going on. But once again, I wasn't there. I can only go off what they're saying. And she said, you know what? This white guy walked in, he had somebody else in the car. He saw what was going on. She turned around, never pointed the gun at him, never got aggressive to him. But he said, enough for me. I'm out of here. This ain't worth it. So I asked her about the traffic. And she said, oh, it was clear. She said, I was in the turning lane up here. I could see everything clear. You're in a turning lane on a busy highway. 2, that traffic is miserable, but she could see clear. So really, how bad was that traffic? Now, I know that the officer said he was there stopping people from going down 285, and everybody here knows how irritating it is when you need to get on the highway and they're stopping. You got to reroute you. So maybe there was some traffic there, but not enough to block her vision, where she said she was right there, kind of side to side, looking at it. I think she said 10 yards. 10 yards. I don't know. I usually like to hear feet, but everybody has their preference. 10 yards from it. And she saw her gun out, holding at gunpoint, and blow. She didn't see it. She heard it. But notice, blow. So did it happen in the car? Did it happen out of the car? From her testimony, I don't think you really understand, or I don't think you get a good impression of what happened and where it happened. But that's for y'all to decide. That's for y'all to take her testimony and compare it to the other witnesses. Because remember, they've had 4 years to get these witnesses together. And I asked the witnesses, did y'all talk to the media? I mean, why the difference in the story? Did you talk to somebody else? Did you talk to the media? You talked to the detectives? No. Yeah, I talked to the media. Yes, I talked to the detectives. And yes, I talked to Bob. And they're here giving testimony that's different from what they initially gave. And you, as the decider of facts, has got to decipher from the story that you heard from the first account, the story you heard from the second account. My opinion is, when you go back and you talk about what you heard, they're not going to measure. It's not going to be something that you can see or put together or say, yeah, this is kind of close, it's kind of not close. So, I think we took a break there and we went on to day number 2. And day number 2, I believe it was the forensic examiner. And she was here. She's a tough cookie. She turned to you when it was asked questions from the state. She turned to you and was talking. Friendly. Explaining everything. And I kept asking her. Your report said the bullet went right to left. There's a slight downward angle. Right to left. That means if he was in the car and the gun was outside the car, it'd have gone left to right. Well, it depends on what the position of the driver was. When she wrote that report, there was a position in her head that she had that driver sitting at when she said it was right to left. And I asked as many times as I could before I was stopped to try to get an answer out of what position was that driver in. I don't think we ever heard it, but we all know that when she wrote that report, there was a position he was in that she came to the conclusion the bullet went right to left, a slight slope down. I asked her to draw me a picture of it. Show me if it goes in the body, because in her reports it talks about organs that it hit. She didn't want to run it. She didn't want to draw a line. She said, there's a dot here, there's a dot there. That's all I'm doing. So, usually you're dealing with forensic examiners. They're going to tell you everything that's going on. And she said, well, we can't really talk about diabetes because the body, when it begins, to rigor mortis begins and the process goes and the disease is there, it's going to eat up that sugar immediately. So we can't say one way or the other. But what really is it wrong? I mean, no one's coming here to testify what diabetes does or how it would affect you. It's all speculation. And she goes and says, no. And then I ask about the drug test. And she says, well, it's comprehensive. I understand comprehensive. Y'all understand comprehensive. But there were 5 specific drugs that were singled out. And in the report, it says, out of those 5 drugs, and it says specifically those 5 drugs, it was negative. Cocaine, opiates, benzoin, nothing about amphetamines, nothing about other, as she said, common addictive drugs. But it's a comprehensive test. And we didn't get into that report about, was it a hair follicle? Was it blood? Was it urine? What was tested? How was it tested? We never got into it. So, as we say, it's comprehensive. That should be enough. That should be enough for y'all to believe there was no drugs in the system. The test was done 2 days after. So, she quickly gets off the stand and she goes. And then we have Cameron Williams, Cameron Williams. Nice guy, seemed personable. He gets up here and he talks about how, hey man, I videotaped it. And I'm watching it. and I see a struggle. And as they're struggling, all of a sudden I hear the, and it's a gunshot. And this gunshot goes off, and he goes, oh, hell no. So he's got a video. He gets out, he gets it right beside Miss Payne, and on the 911 tape, you hear her say, sir, did you see what happened? Can you stay here to tell what happened? And he didn't really respond. But you see him talking to the officers. I got to go. I don't want to be involved. I got to go. They said, you got a video. Can you get it to me? Yeah, give me your email address. You ain't getting it off my phone. I wouldn't want anybody to have my phone number either, so I'm not condemning for that, but I did notice that he wasn't going to send it to him from his phone. It was going to have to be me. And you heard that his dad is law enforcement. And we don't know what his dad said to him. It would have been hearsay. But we don't know when the video was given. But we do know the state brought out that he had contacted her, mentioned he had a DUI, and wanted to know what she did. And she did the most professional thing you could do in her position. Ooh, I don't do misdemeanors. I can't help you on this. I don't want anything to taint this case. But it's never said when the video was turned over. And he's up here testifying. And then he gets up and he goes with the investigators to refresh his memory on the video. Because there's a interview with him that it's been a while. Then he goes off to refresh his memory. He comes back and pretty much says what he sees on the video, and you've seen it. I know a lot of people say, I've got to see it to believe it. I don't want to hear it, I want to see it. So you see it on the video. And he gives what he saw, and what he saw was there. A struggle, going back and forth, fighting over the gun, punching from both sides, struggling, going back and forth. I didn't see the gunshot, I didn't see where the gun was. There was a gunshot. Oh, by the way, she jumped out and grabbed the shell. She jumped out and grabbed the bullet shell. What is it, sniper? I mean, nobody stands out there and picks up a bullet shell. Unless you're in the movies. Unless you're doing something wrong. So why is that twisted in there? Why would it even be brought up? I showed him the picture of the phone, of her picking up the phone, a still shot. That shell must have been behind it. Must have been behind it. I don't know why that twist was put on there. But his testimony was pretty good. It was almost the same as what you saw in the video. Except for that one little biased twist of her picking up a shell. And we'd heard the examiners had come in between when he was stepped out to refresh his memory. And we got LaVoy that talks about the process it takes to get a palm print, to get DNA, and taking it and checking it against layman prints, and what the prints can tell you, and the alleles, and the finger, and the DNA, and how it all meshes together to say, hey, I'm positive this is that DNA and this is that DNA. But there wasn't a sufficient palm print taken, or wasn't sufficient evidence brought in for her to conclusively say, I know whose DNA or I know whose fingerprints were here and there. But never tested the trigger. Never tested the trigger. Once again, they have their procedures and they have their orders. Never tested the trigger. If you want to prove something beyond reasonable doubt, you test that trigger. But it was never tested. And then you have Cynthia Squin, I believe was her name. She talks about the forensic biology. And she's the one that comes in and says, hey, I got something for you that's relevant. I got something that's important. There's DNA on that slide. There's DNA on that slide. Male DNA. And there's female DNA all around the gun. But there's DNA on the slide. And the key part there is later on when Officer Ritchie comes in and says that spent shell was stuck in the chambers. Was stuck in the chambers. It never came out. The shell never came out. Why? logic would say that something was obstructing it. Something that when it pulled back, left DNA on it. But the shell never came out. So when he said that, I picked up the shell, and she picked up the shell, there's no way she picked up the shell, it was never discharged. So you have to take that story with a grain of salt. And then we continued to go through a bunch of pictures of what happened and where the cars were. And Detective Moore gets up there and says, hey, I was there. I interviewed, I talked to her. Yeah, I took pictures. And these pictures were taken at the very end. The interview at the very end. Didn't really want to take pictures unless somebody said, hey, I need pictures taken, because she said she was scratched. She was grabbed. She was hit. She was bruised. And every account saying that she's pounding Herring. Not a bruise, a scratch on, well, a pin top bruise on the left shoulder. That's all they could say. They never said any bruises, scratches, or anything else. But you saw the pictures of Miss Payne. Scratched on her head, on her arm, her wrist, swollen, her eye, swollen. Pictures may not have given the best representation, but we all know those bruises don't come until after a day or so. And Detective Moore says, okay, I took those pictures, and here they are. And I took out a ruler, and I measured those pictures, so that we can have an accurate representation of what size and what scratches, and all these are just little breaks or whatever, if it was a deep or cut or long. So that's all her testimony. And then you have Officer Ritchie. He shows up, the one that was there, the one that was doing the most. He shows up, he takes the gun from Miss Payne with no glove. He puts the gun down, he tries to assist. He can't get into that door on the driver's side. The door that Hayward kept saying, was it open, was it closed? Did you open it, did you close it? How could it be open? Were you trying to keep it shut? That door wasn't working. And Richie could not get into that door. And when I asked him was because of the accident or whatever, I'm not going to speak, I'm just going to tell you I couldn't get in the door. So he goes around, and he gets in there, and they're talking with Mr. Herring. Keep here, hang on. And they're getting the EMTs, getting him in the EMTs. And he's leaving, and he says, you know what? They're optimistic. They're in the EMTs, I've done my job. Kind of looks in the truck a little bit. Sees all this stuff in the truck, and then y'all saw it in the pictures, and you heard testimony. There's a knife. There's a little saw. There's a cooler. And asked Detective Moore, what's in the cooler? Because if there was insulin in that vehicle, it must be cool. It must be kept at a cold temperature, and it would have been in that cooler. They didn't want to go and look into that cooler. They didn't want to completely say, beyond a reasonable doubt, he was a diabetic because all these needles and there's insulin. But they couldn't say that. It was not in the cooler. If it was, they'd been sitting there waiting, guess what we found? But there's nothing. And what they took as evidence from the vehicle to help in their investigation, what did they take? Nothing? It didn't appear like they wanted to find anything of use. They just looked it over, took pictures. And he sits there and he testifies to what he thought might be important, what he thought he would collect, what he thought he might collect it for. And he said, but I didn't do it. There were other people who were doing it. He rounded off how many officers? 4 or 5? 4 or 5. Do we ever hear from those 4 or 5? No. No. We finished with that. We looked at his body cam. We see how everybody is standing around Miss Payne, talking to all the bystanders. You shot him. She shot him. You shot him. You shot him. She's standing there, no, my finger was not on the trigger. And they're having a conversation. They're not getting aggressive with each other. They're not jumping on them and beating them because they think somebody shot somebody. They're having a conversation. trying to figure out what's going on. That's civilized. That's what you're supposed to do. You're not supposed to take a side and just get aggressive or do something. But yet, say, here he is. The motive for tracking down, chasing down, and shooting Mr. Herring is he's a bad driver. That trivial? A bad driver? If somebody had that kind of anger or something like that built inside them, they had issues on, they would have anger management, they had problems, that would have been documented. Nothing's documented on this thing. She's not got a ticket, she's not in trouble anymore. So, you take all of these evidence, and that's the evidence. And then Miss Payne says, you know what, I want them to hear what happened. And I want them to hear it from my mindset, because everything you heard, it just didn't it didn't sound, it wasn't meshing together. It wasn't, some of it wasn't possible. Some of it wasn't logical. Some of it was just common. But I don't want to take it away from them, but I try to be vigilant, because everyone can perceive something totally different than what really happened. We talked about that at the beginning. You can see the same thing happen, two people have two opinions of it. But you have 4 years. 4 years. Take all these witnesses. Take everybody that talked to you, everybody that saw it. And when you kind of put a few together that make sense or that are close to being exactly what happened, or close, but you didn't hear it. Did not hear it in the testimony of any of those witnesses. Miss Payne gets up there, and she's telling them what's going in her mind. Yes, I heard them say, don't chase. And I heard them say, be safe. The second time I think I was talking, I didn't hear it. But you heard it 4 times. I didn't hear it 4 times. They told me to come back. They didn't say, don't chase. They said, come back. You need to, both of y'all need to come back. And that's what she did. She pulled over, she had her phone out, and she said, I got the police on the phone, and let them see 911 on her phone. You know how the phones on the screens, they had who you're talking to. And she walks up and she's like, I got the police. You need to come back. They want you to come back. Whack. That phone's gone. That's on the ground. But it's still got 911 on it. She's thinking, somebody's got to hear this. And grab. And then all of a sudden, you see her shirt. And you saw in the pictures. And you'll see in the pictures when you go back there. Her shirt is being pulled in. And her testimony is, I didn't pull the gun in. I don't know what people say. She walked up with the gun on her. Now, a couple of them said it wasn't until the car hit her Jeep that the gun was pulled out. But she said, I didn't pull the gun out then. I'm sitting here trying to get away. I'm trying to move back. He caught me by surprise. Never been in a situation like that. It's up to God she'll never be in a situation like that again. Because no good deed goes unpunished. And she knows that now. But before then, she's a people person. She's trying to help somebody out. We're going to help them out in Clayton County, the place she grew up in. A place that we've heard stories. We've seen incidents. We've seen the news. She graduated high school. She went straight to work. And she's been working the best she can at these apartment complex. Obviously, they've given her some quick responsibility because she's going up picking up tills and showing properties by herself. And that's pretty scary for a 21-year-old. It's pretty scary for anybody. So she keeps that gun with her for protection. And she says, when I pulled it out, I thought it'd be a turn. I told her, hey buddy, I got a gun. Let go of me, let go of me, let go of me. Stop, stop, get the fuck out of this car. You can't drive this car anymore because it's gonna blow up, it's smoking. And if you're out of that car, you can't cause any more problems. You can't hurt anybody, you can't cause another accident. How'd that work out for her? She's being dragged into that vehicle. She's being dragged down the road, whether it be like an inch, or whether it be the size of this table, or what. When you're grabbed, if you're pulled into a hole and you don't know what the world's going on because he's getting, I got something for you. I got something for you. And he's leaning back. She didn't try to say she saw something. She didn't try to say there was something in there that could hurt me. She told the truth. I don't know what was in there. I just know he was grabbing me. In my mind, I said, holy cow, what is going on? But I got the police on the phone. How's that gonna help? How's that gonna help? In theory, you would hope they're close by. You're gonna be safe. In reality, it's not that safe. So he's grabbing her, he's pulling her, he's ripping her shirt, scratching her. She says, I got a gun and I will shoot you. Is that enough deterrent? No. So she pulls it out and she sits there and eventually gets pushed up on the car, and her testimony was her hands like this on the car. And she's trying to push back. And you look in the pictures and the video, she's on her tippy toes. And you got dirt on her knees where she's pulling back, trying to get away. And you see a still shot that the state entered that has her pulled back like this. But you can use common sense, and you can use, after hearing what happened, what would cause a hand to come back that quick? If it's being held and you finally get it away. And she said that's all she wanted to do was get away. That's all she wanted to do. And when she pulled that gun, as she learned in training, when you pull it, if you mean to do harm, put your finger on that trigger. If you don't, you leave it up top. She didn't want to do any of that. She didn't get a chance to even think about it. She's trying to push off the car, and he grabs her. And you heard her just grabs her right wrist and is trying to pull it back. And you see the swelling all over her wrist. And you saw the demonstrations I did with that gun. The way it was explained, the way it was told, the way the DNA showed that that top slide had DNA on it and a shell didn't eject. There's only one possibility on that. That hand was there just, obstructing that shell from being shot and shot out. And when you go and you put your hand on the top, the way he had her wrist, and you put your hand on the top, how many of my fingers went right into that trigger area? One time it was 2. When I asked Detective Hayward, how many fingers were there? 3. 3 fingers, 3 opportunities to pull that trigger. And when I asked Detective Hayward, in your interview with her, right after it happened, 2 hours, she sat there, 2 hours. And you sat there. And she said, he turned, pulled the trigger, and I heard a click. I heard a click. Turned and pulled the trigger. Now, he's a detective. He knows what the hell's going on when somebody pulls a trigger, pointing a gun at you. We didn't want him to speculate, but if a gun's pointed at somebody, and the trigger is pulled and it clicks, that's an aggravated assault. That's attempted murder. That's something right there to put your life in jeopardy. Nobody wants their life in jeopardy. Nobody wanted to be in that situation. But by God, now it's increased even more because she's thinking, oh my God, he's going to kill me. And you hear her say, I had a grip on it, I didn't have a grip on it. I was trying to get it back there. My hand was under the trigger. No, it's a trigger guard. And they went back and corrected a couple of times. Sometimes she said my hand was on the trigger. My finger was on the trigger guard. My finger was on the trigger. In that kind of chaos, her hand is trying to push off. It's only natural to think your finger is going to stay with that gun as you're being twisted. If you're being twisted like this and it's on the trigger, you're not going to have those bruises on your arm. And how could it be if the hand's on top of it, turning at the angle it is? And remember the angle it is. He's sitting there in the truck. And it's being twisted right into his chest. It may have been at the angle at her, but in order to get to her, he's got to turn it around past him. And as he's doing that, he's got his fingers on the top, and they're going back and forth. The state's got one theory, one option, that that finger of Payne was on the trigger. As you heard and saw the demonstration, the man is grabbing that gun, twisting it, possibly has 2, possibly has 3 fingers. In the trigger guard, on the trigger. That was never tested. So as you go back and you look at it and you listen, You review all the pictures, and you hear all the evidence, and you hear the judge say, the state's burden never changes. It's a heavy burden to prove, beyond a reasonable doubt, okay? And she starts off with the presumption of innocence. So you got old lady justice here, and she's got the scales, and you've got the presumption of innocence. You're here. It takes a minute to get up here. There's got to be some good evidence to get you even close to being even. And then you got to prove beyond a reasonable doubt that one theory, that her finger was on that trigger and shot her, is the only theory you can come up with. And they proved it beyond proved it. They proved that he had diabetes, and I don't know where that's going, but by the sister saying he had it, they proved it. By saying that detectives twisted her story up, but then kept coming back and correcting it, that she had a finger on the trigger the whole time. When you heard the struggle, you saw the position, there's no way it occurred. And you've got to believe that. That one theory is the only plausible theory that occurred. But you saw in the demonstration, there's 3, possibly 2, hell, possibly 4 other theories that when he grabbed that gun, how that trigger went off. And that trigger went off while this young lady is sitting there, scared out of her mind. Never been in a situation before. Here's somebody, I got something for you. Leaning back, getting the trigger, and pow, click. He pulled the trigger. You heard the click. And they didn't seem that was important. That basically, when it comes down to trials, as I said, verdict is an individual honestly seeking the truth of what happened. And I stated that to the prosecution. Verdict means seeking a conviction. Seeking a conviction. So they come in here with boxes. And they got these boxes. And they only want you to see what's in this box. Because if you see only what's in that box, you may see it the same way they did. My job was to get as much evidence out as I could. And I tried, you saw I fought a little harder than I should sometimes, but I wanted to make sure you saw everything. And I believe that you have enough knowledge, intelligence to see, brother, what's going on. And I told you that no matter what happened, I want to get all this evidence out there, so when you make your decision, you can look the state in the eyes, and you can look Miss Payne in the eyes. You can look at it and say, you know what? I hate to say it, Steve, but you didn't prove this beyond a reasonable doubt. The judge told me, when I look at it, I need to look at these factors, follow this law, and they must prove it beyond a reasonable doubt. And they didn't. They didn't put up enough evidence. They didn't show beyond a reasonable doubt that certain things happened and that certain things, there's no other theory. But with the evidence we were able to squeeze out, we gave you those theories. We gave you as much evidence to see the whole picture. And when you see the whole picture and you go back and you go through all the pictures and you go through your recollection of what the witness said, what the theories are, you're going to come back. And you're going to come back and say, you know what? I'm not supposed to listen to that attorney, but it made a good point. The state didn't carry the burden. And I don't think I can sit there and look one person, one side, in the eye, and say that it was fair and I did it from the evidence given there. But you've heard it, you've seen it. I don't want to take more of your time. I know that's after lunch, y'all are about to fall asleep. But I hope that you look at this carefully and come to the same conclusion that we've been saying for 4 years. If you hear all the evidence, if you see it all, this is not some killer. This is not some murder. This is a young girl that got caught up in the wrong situation with a good heart and good intention. And when she did it, her mind was not to confront, not to get in arguments, not to pull a gun, but to get the man just to go back. We don't know why he didn't go back. She didn't know why he didn't go back, but she sure as heck didn't think it was going to end that way. So, as you go back there, look at all the evidence, I feel comfortable you've seen enough. You've got enough information, enough understanding, enough experience to see really what happened. And the audacity of the state to say that you're going to find her guilty from the information they gave, I think different. I greatly appreciate your time. And I know it was a lot of time in the week, and I know y'all didn't expect that, but I appreciate it because I've seen you be attentive, I've seen you be listening, and I've seen those eyes wanting to seek the truth. And I hope you've sought enough truth so that you understand it didn't happen that way. It didn't happen, and even with the theory they have, there's still three other plausible theories of what happened. It comes down to they just didn't present a case that's beyond a reasonable doubt to convince you that Miss Payne is a murderer. Somebody just called you because she didn't like the bad driving. He's a bad driver. You heard the one girl up the voice. She said she didn't crazy bitch. She would not change her mind. But not Miss Payne. You never once heard her say, ooh, this guy's crazy. I think he's inebriated, but that's it. So I leave it to you, and I implore you to go back, look at the evidence, and do the right thing. And I appreciate your time, and I appreciate your attentiveness. And I appreciate when you come back and find her not guilty of all 8 of these charges, these heinous charges they put against her. Thank you so much.
Thank you, Attorney Tucker. At this time, before the state makes its closing arguments, I'm just going to give the jurors a 5-minute break. It's now 3:05. I'm going to give you till 3:10, and you'll come back in and the state can make its closing arguments.
I think that was a different judge, Amelia. It wasn't the same one, I don't think. Hold on just a second. Okay, yeah. Arthur, I can't believe I said what. It sounded like he literally said, it looks like some of y'all are about to fall asleep. Because I don't want to keep you. Looks like some of y'all are about to fall asleep. So it looked like he said, sound like he said. Let's see. Yeah, this is a new judge. Oh, it's a Timu lawyer. Oh my goodness. Yay, a comfort break. I love comfort breaks. She was super snarky yesterday on the stand. Not a good look for a defendant at CB, Kansas. I'm not sure who we're talking about. Yeah, he's finished. You think he did say that? I think he did say that. Thank you, Rosalind. Thank you. Hey, Elizabeth, that's not good for him if they were about to fall asleep. They've already made up their minds. I know, right? He's like the Energizer Bunny. You know, he just keeps on going and going and going. I get feels like he's got to, say every little thing that he's got to say for her defense. But man. Paul Hill, hi and welcome. Says, Lord, thank God he's done. Hi, Cosmic Kitten. Not a subscriber, just found this channel and filling it out. Looks fun. Well, Cosmic, this is my crafty channel. I have decided to stream this trial just to try it on for size, just because I thought about starting a true crime channel, trial coverage, commentary channel, and I'm like, let me try it over here. See if my folks like it. And some of my folks like it, but then I had a lot of new people, and I'm like, holy cow. So let's just start a new place, because, yeah. So, the new channel. I'll be streaming over there soon, hopefully tomorrow. About the rest of this trial, or at least maybe verdict watch. Let's see what else we can come up with. But yeah, if you would like to subscribe to the new one, here is the link. And for anybody else that would like to subscribe, I appreciate it. A big, big bunch. So I think everybody's on the fence, on the same side of the fence. Not on the fence, on the same side of the fence. Mary Lou, I hope I said hi to you, hun. Hi, Janice Linton. Hi, everybody. There's so many new people in here today. Crazy, crazy. Not used to this kind of traffic. But I hope that you guys are having a good Tuesday. A good Tuesday. I hope that you've enjoyed it over here, and I hope that you come back. It looks like the Bryce Rhodes trial is starting. If you're not familiar with that, it is a case that apparently has been, it was a triple murder case that occurred back in 2016, the state of Kentucky. So yeah, thinking about starting that, depending on what you guys think. This Bryce Rhodes looks like a character for sure. Thank you, Woods Lisa. Or Lisa, is it Woods Lisa or Lisa Woods? Nice to meet you either way. Let's see. Kel says, the prostitution? Kel. Oh, but you're so cute, Kel. I love you so much. Closing statements will be so interesting. I'm sure they will be more to the point than Mr. Tucker. I know, right? I expect it to be super short. Like, they get to the point real fast, right quick, and in a hurry, right? They get there really quick. So we'll see how that goes. And then I don't know how long the jury instructions are going to take. It's 3:15. I would say they'll probably get to the jury instructions today. Lisa, the Frankie case, the Frankie trial. Wow. That one is crazy. There are so many good ones that are coming up that I'm super interested in. There's one that I'm really invested in, and that one's coming up early next year. I think in March, May. I think it's March. I have to double check and see. But it's the Lisa Snyder from Berks County, Pennsylvania. It's going to be a hard one because it's a couple of kids. This mother, Lisa Snyder, I call her mother. I don't know. In my opinion, she doesn't deserve that title. But Lisa Snyder, yeah, she had, it's hard to talk about that one. But she supposedly found her kids hung in their basement. And she said her young son, Connor, did that to his sister and himself. But that's not the case. And she's supposed to be going to trial pretty soon. it's either March or April, I think. But they keep putting things off with that one, and I'm just waiting for it to come to trial. Kel says, "Dang voice to text." Yeah, you did, Kel. You did it. Lisa said, "I find it so upsetting how many children are killed or harmed." I know. It's disgusting. Robert, hi, Robert. He says, "Here in the UK, we get one case like this about every 20 years. Oh, well, no wonder. No wonder we have a lot of, I always see a lot of, across the pond, across the world peeps in these true crime chats and the different trials and stuff because, they're interesting. So, um, Rosalind says, "You're welcome. I'm watching this channel because I don't want to pay for the subscription at Law and Crime." Oh my goodness. Twiggy said, "You're covering this well. Never would have known it's the first." It is the first, but I've done live streams for a long time. Just crafty related, but I've watched a lot of true crime. I've watched a lot of trials and yeah. The only thing he did good at was giving her more time to be free. Lisa says, "Can anyone tell me why these cases are so long going to trial? Some are years old. I'm Canadian." And Twiggy says COVID, Lisa, is one of the reasons. Yeah. I think that's probably, it makes sense why that would be one. I mean, we could blame it on COVID for like congesting the courtrooms because whenever that happened, there were so many things that were all stopped, like dead in their tracks, And then everything kind of went through online. Things got pushed back, on and on and on. So, let's see if I missed anybody up here. Looks like Kent Kramer thinks that she's innocent. All right, all right. Let's see. Is JC still here? Hanging around? Deborah says, "I know next to Zip about guns, but if she has the gun, he grabs it. His hand is on top, yet he's able to turn his finger to pull the trigger." Isn't it crazy how so many things, so many details, in such a short time frame? Like literally so many, there are just so many different details that pop into just the few minutes, not even minutes. I mean, the whole thing literally lasted less than a minute and a half, my guess, from the time that she got out of her Jeep and went to the door of his truck. It couldn't have been very long. I know it probably seemed like it lasted an eternity for her and him, but, that's a lot of details. CB Kansas says, "Did you tell detectives you had your finger on the trigger?" Hannah, "Nope." "It's on tape." Hannah, "No, it isn't." Dawn says, didn't you and Abigail stream the Johnny Depp trial? We did. Well, we didn't actually stream it, but we did a lot of recaps on it. Yeah. CB, Kansas again. Oh my gosh. Is this you hitting and yelling at the victim, Hannah? No, that's not me. Mm. Um, let's see. Who else? Who else? So many comments, man. You guys are awesome. Again, so many people in here. I'm not used to seeing this many comments and this many people. It's crazy pants. Crazy pants. Oh, we have a judge. We have a judge back. Let's see. Let's see. Who's the guy in the purple pullover? Back there in the back left. I don't remember seeing him before. Don't remember seeing him before. There's all of Hannah's family. I don't see Hannah's mom, though. Oh, nope. I bet that's an uncle. I bet that's an uncle right there. Hannah's dad. Friends and family. They show, I feel like they showed that side, Hannah's side more often than they do Mr. Herring's side. Like that, well, and it's probably just for privacy's sake, right? I mean, because he's the victim and, you know, I get that. Well, as I say that, boom. I mean, it's like this courtroom hears me. It's like this courtroom hears me. But yeah, I don't know who any of the family is except for his sister that was on the stand that first day. Oh, does he have a sketch pad, Lee? I missed that. I missed that part. Very cool. That's cool. Very, very cool. I know whenever they had the Lori Vallow Daybell trial going on, they had a sketch artist because they weren't allowing cameras in the courtroom for that, which is pretty cool that they're allowing cameras in the courtroom for Chad Daybell. That'll be good. I'm happy about that. I'm glad that the judge was like, yeah, let's do that. Let's do that. I don't know what they'll do for because Lori Vallow was literally just arraigned, what, 2 or 3 days? Well, would it have been Friday? Thursday or Friday? In Arizona, I believe. So, I don't know what'll happen with that one for sure. Welcome, P. P says, Hannah has hideous taste in clothing. Every outfit she's worn in court is ugly. Now, I will say she had on a cute little blue top the other day that had like polka dots on the sleeves. I did like that top, but I'm also not stylish. No, I'm a t-shirt and blue jean or leggings kind of gal myself. Foxy says also in the video from the incident that they took the still from, did you notice her pink hoodie while holding the gun? but he ripped her shirt completely off under the hoodie.
So during our bench conference, it was brought to the court's attention that certain personal information, okay, can you all hear me? Are you able to hear me? Okay. Personal information that was on one of the interviews was disseminated by the media. And as we heard earlier this week, once the personal information is put out, then there are people that make calls that are, aggravating, annoying, not positive. And so I would just kindly ask the media at this time not to republish any information that's personal to the defendant or to any other witnesses in this case, so as to avoid calls being made that are not wanted. Okay, is the state ready to proceed with its closing?
State's ready, Your Honor.
Okay. Bailiff Ennis, please bring the jurors in.
Okay, first of all, I think we should all be grown up enough to know better than to be going and calling and texting people, right? Come on, folks. Second of all, they ought to keep that stuff privated. Hold on, guys. Gotta mute and camera stop.
You may be seated. Thank you. The state will now give its closing argument.
I mean, not that it has anything to do with it, but my entire life until I was 18 and my grandfather passed away, I was going to be a police officer. And on May 7, 2019, she got her opportunity. And as a result, 62-year-old Kenneth Herring, who was unarmed and minding his own business, was chased down, detained, shot, and murdered by this defendant. And how do we know she shot him? Because we watched Officer Rich's body cam. And when he asked, who shot Mr. Herring? She said, I did. And you don't get the death penalty for committing a traffic infraction. And you know how much entitlement you have to chase somebody down, detain them, jump out your car, and run toward a stranger. He didn't know her. He didn't know why she was approaching his car, and demand that they do anything. He didn't have to listen to her. He didn't have to do anything she said. As he continued to ask her, who are you? And the audacity to come here and take that stand and blame everybody else. Now, before I jump into all the facts and all the evidence that you heard today, I want to talk a little bit about what your duties are. You're to be a fair and impartial juror, honestly seeking the truth. And the purpose of the jury trial system is to seek the truth. Not to seek doubt, it's to seek the truth. You have a duty to follow the law, and you are bound by the instructions and the law given to you by the judge. Now, you shouldn't consider anything that's outside this circle. Passion, public opinion, dislike of the police, any sentiment, sentencing, prejudice, penalty and punishment, conjecture, whether you disagree with the law or if you have any sympathy for the defendant. The only thing you should consider is the law, the elements of the crime that I'm going to discuss with you, any testimony that you heard during this trial, any expert testimony, and you will determine the credibility of the witnesses, any photos, any audio, any videos that you saw, the physical evidence, and your common sense. We don't ask that you leave your common sense at the door, and any corroboration. Now, you do have a duty to deliberate. And if a juror refuses to deliberate or discuss with the other jurors the evidence or the law, you may bring this to the attention of the judge. Now, let's talk about some legal principles. Now, you heard a lot about the presumption of innocence. Now, the presumption only exists until it is overcome by the evidence. So once you believe the defendant committed the offenses as alleged in the indictment beyond a reasonable doubt, the presumption is gone. Now, the state does have the burden to prove every material allegation in the indictment beyond a reasonable doubt. And we take that burden very seriously. Now, let's talk about reasonable doubt. Reasonable doubt is not proof to a mathematical certainty, or proof beyond all doubt or absolute certainty. There's no number. It is beyond the doubt of a fair-minded, impartial juror honestly seeking the truth. And it is based on common sense and reason. Now, there are two types of evidence. You have direct evidence and circumstantial evidence. Direct evidence points immediately to the question at issue. So, for example, any witnesses that testified based on things they saw, things they heard, things they smelled, tasted, anything of that nature. That's direct evidence. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. For example, the DNA information that was presented to you when you learned that the major contributor on that firearm was a female and it was identified as the defendant. Now, the law does not favor one type of evidence over the other, so it is up to you how you weigh that evidence. Now, you may consider the personal credibility of any witness that took the stand. And it may have been shown in your presence, in their presence and by the evidence. So this applies to the defendant as well. What was their demeanor? Did they have any reason to lie? Did the facts they testified to match the evidence? Was there any corroboration? And is what they say believable? Now, we presented several eyewitnesses. That Attorney Tucker discussed. And you heard direct evidence based on things they saw and what they observed on May 7, 2019. Now, even though Attorney Tucker tried to twist their words, misquote their statements, they all stood firm in what they saw. And what was consistent between Ms. McCraney, Ms. Rosser, Ms. Jackson, and Mr. Williams was that there was only one aggressor on May 7, 2019. And that was the defendant. Now, you heard testimony from the defendant yesterday. And, you know, she stated that she never heard 911 tell her to not chase. And then when I went through her testimony and the transcript of the 911 call, they told her 4 different times, either twice, to go back to the incident location. And they told her not to follow him. But she said based on her perception and what she believed they meant was that she should follow him as long as she remained safe. Now, it is for you to decide whether there is a reasonable explanation for any inconsistency in the witness's pretrial statements and testimony when compared to the same witness's trial testimony. You are to consider all the facts and circumstances of any prior statements. You, the jury, must apply your common sense and your reason to decide what testimony you believe or do not believe. Now, it's not a memory contest. These events happened nearly 4 years ago. And the witnesses got on the stand and they testified to what they remembered that happened on May 7, 2019. And for the most part, they gave you everything. Now you can imagine, if you went to a wedding and, you went to the wedding, you told your mother, the bride's dress was beautiful, the food was good, and you told your dad, they had a great open bar. The DJ was real nice. And you told your friend, the invitations that we received, they were just beautiful. Now, you may not have told each one of them all the details, specific details of what happened at the wedding, but what was consistent amongst the story is that I went to a wedding. And all of the witnesses were very consistent. That on May 7, 2019, Tiana McCraney advised you that she observed the defendant travel around Mr. Herring's vehicle and block him in. She stated that the traffic on that day was very congested on Riverdale Road. It wasn't moving. And when I asked her, was there any way after she blocked his vehicle in and detained him, could he get around her? Could he move in any way? And she said no. And what she also observed was the defendant jump out of her vehicle, irate and aggressive, and immediately run toward Mr. Herring's vehicle, screaming and yelling for him to get out of the car and cursing at him. Now, when you watch the defendant's interview, she never mentions to the detectives at any point in time that she yelled at him, that she screamed at him, and that she demanded that he get out of the vehicle. Her characterization was, I walked up to the car, I held the phone, and I said, I have 911 on the phone, and they want you to go back to the scene. And that all of a sudden, the victim just became very irate, grabbing her and pulling her into the car. And that's not what any of the witnesses saw. And you also heard from Ms. Rosser, who advised that she saw the defendant outside of Mr. Herring's vehicle punching him, being very aggressive, screaming and yelling. And you also heard from Ms. Jackson, who notified you that as she was leaving work and she made a left onto Forest Parkway, that she noticed the defendant's Jeep come flying down Forest Parkway, almost running her off the road, and other vehicles off the road, swerving in and out of traffic, which is ironic because she stated the only reason she was trying to get Mr. Herring pulled over because he was going to harm other drivers on the road. She wanted other people to be safe. And then when she caught up to Riverdale Road, Miss Jackson got up to Riverdale Road, she noticed that the defendant here, had caused an accident. She didn't know that she had cut Mr. Herring off and pulled in front of him. But what she did know was that she just observed her driving very irately. And so she pulled over because she was interested in seeing what happened. And what she saw was the defendant very aggressively banging on what she thought was Mr. Herring's window. But then what she realized was that she was actually punching him inside of the vehicle. And what Ms. Rosser and Ms. Jackson remember was her pulling that firearm. And when she pulled the firearm, she pointed the firearm in the vehicle. And what they recall is that she immediately shot. Now, the testimony of a single witness, if believed, is sufficient to establish a fact. So if you believe Tiana McCraney and you believe that she observed the defendant pull around Mr. Herring's vehicle and block him in, detaining him, then that's sufficient to establish that fact. Now, the law provides that criminal action shall be tried in the county where the crime was committed. And we did submit to you that this occurred on Riverdale Road and Forest Parkway, which is located in Clayton County, Georgia. Now let's talk about the charges. And this is where we will get into details about the facts and the evidence that was presented to you. The defendant is charged in count 1 with malice murder, count 2, felony murder, count 3, aggravated assault, count 4, felony murder, count 5, false imprisonment, and count 6 through 8, possession of a firearm during the commission of a felony. Now, I know there was only one death in this case, and we charged 3 counts of murder. Now, the state of Georgia allows us to charge murder in various ways, and you don't have to pick one. If you believe that the state has presented sufficient evidence to prove that she committed counts 1, count 2, and count 4 beyond a reasonable doubt, you can enter a verdict on all of those counts. You don't have to choose one. Now let's talk about malice murder. Malice murder is when a person with malice aforethought unlawfully causes the death of another human being. Now, what is malice? Malice is the unlawful intention to kill without justification, excuse, or mitigation. Its malicious intent can be formed in a moment, so it doesn't require premeditation. It can be formed in a moment, and it does not require ill will or hatred towards another. An intent may be shown in many ways. It can be inferred from the proven circumstances or by acts and conduct, or it may be inferred when it is the natural and necessary consequence of the act. So if you pull out a gun and point it at somebody, then you fire that firearm, then the natural and necessary consequence is that they may die. Now, we believe we submitted to you that the defendant acted with malice when she chased Mr. Herring's vehicle in her Jeep. She cut off Mr. Herring's vehicle with her Jeep on Riverdale Road, cornering him in, blocking his ability to move, detaining him. When she jumped out of her Jeep in an aggressive manner, immediately runs up to Mr. Herring's driver's side door, screaming, cursing, and demanding him to get out the car, motherfucker. She tells Mr. Herring that she will shoot him. She draws her firearm from her waist. She racks the slide with 2 hands, and she shoots him. And you heard on the 911 call, you heard her say, "You hit my car." And she says that right before she shoots. Now, she's also charged with felony murder. Now, when a person, while committing a felony, causes the death of another human being, irrespective of malice, so aggravated assault, which is a felony, plus a death caused during the aggravated assault equals felony murder. So there's no intent to kill. Intent to kill for this count is irrelevant. It's not required. So a person commits an aggravated assault when she assaults another person with a deadly weapon. And no injury is required for you to find the defendant guilty on this count. And what is an assault? An assault is when a person attempts to cause a violent injury to the victim or intentionally commits an act that places the victim in a reasonable fear of immediately receiving a violent injury. And a deadly weapon, a firearm, when used the way a firearm is ordinarily used, is a deadly weapon, and that's as a matter of law. Now, the evidence that we submitted to you for the felony murder charge for aggravated assault is the defendant pointing a firearm at Mr. Herring, placing him in reasonable fear of receiving a violent injury. And as a result, shooting Mr. Herring, causing a gunshot wound to his abdomen, which the medical examiner told you caused his death. So in the commission of committing an aggravated assault, Mr. Herring died. Felony murder. Intent not required. And we know the defendant committed an aggravated assault because you watched the video. And you watched her in this video shoot Mr. Herring. Now, when the defendant pulls a firearm and she pointed it at Mr. Herring, then he reasonably believed in that moment that he would receive a serious injury. And therefore, the aggravated assault was complete. In count 4, she's charged with felony murder for the crime and felony of false imprisonment. Once again, intent to kill for this count is irrelevant. And a person commits false imprisonment when she, in violation of the personal liberty of another, unlawfully detains another without legal authority. And false imprisonment is a felony. Now, if you recall, when the defendant was on the stand yesterday, she did not want to state that she blocked Mr. Herring's vehicle in. But this is what you see in this photo. And that's what you heard on her interview when she said, I found an opportunity and I pulled in front of him and I stopped him. So once she blocked his vehicle in and blocked his access, blocked his movement, the false imprisonment was complete. She had no legal authority to do this. She's not post-certified, she's not a police officer, she has no arrest powers. Nobody legally told her to stop Mr. Herring's vehicle. And you heard a lot of talk from the defense attorney that he could have jumped up the curb and drove down the sidewalk. There was no duty for Mr. Herring to retreat. And as you heard Ms. Jackson say, who drives on sidewalks? So the felony murder in count 4 was complete when the defendant cornered him, restricted his movement, detained him without any legal authority. And during that false imprisonment, he was shot by the defendant, again causing a gunshot wound to his abdomen, which caused his death. False imprisonment was complete. Felony murder. Now, count 6 through 8, in possession of a firearm in the commission of a felony, is when a person unlawfully has on his person a firearm while committing a felony. And we submit to you that in the commission of the false imprisonment, in the commission of the aggravated assault, and in the commission of the malice murder, the defendant was in possession with the firearm. And you saw that in the photo. Murder is a felony, aggravated assault is a felony, and false imprisonment is a felony. Now, this is one of the most important parts to remember as you deliberate. A person is justified in using deadly force, force which is intended or likely to cause death or great bodily harm, only if she reasonably believes that such force is necessary to prevent death or great bodily injury to herself or a third person, or to prevent the commission of a forcible felony. Reasonable belief doesn't just mean whether the defendant believed it. The question is whether it was reasonable for her to believe it. Would a reasonable person believe it under the circumstances that you've heard in this case? Was it necessary? To be entitled to self-defense, the defendant must have needed to use this force to protect herself from an imminent threat of death or serious bodily injury or a forcible felony. The problem here is that a person is not justified in using force in self-defense if she is the initial aggressor. The defendant was the initial aggressor and therefore is not entitled to self-defense. So, whatever Mr. Herring did, once the defendant cornered him, aggressively approached his vehicle, and pulled out that firearm, doesn't matter. He was within every right he had to do whatever he did to defend himself. Because there was only one person on May 7, 2019 that was entitled to defend themselves, and it wasn't the defendant. Once again, the defendant is not justified in threatening or using force if she provokes the threat or use of force against him or herself, intending to use that threat or force as an excuse to harm the other person, is committing a felony. False imprisonment is a felony. So, once the false imprisonment was complete, when she blocked his vehicle and blocked his access, she was committing a felony. And if you are committing a felony, you are not entitled to self-defense. And once again, if you are the initial aggressor, unless she withdraws from the encounter and clearly communicates to the other person her intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. To allow an armed aggressor who confronts an unarmed, non-threatening victim to claim self-defense when the victim struggles to disarm the aggressor is contrary to common sense and contrary to law. On May 7, 2019, you heard testimony from Terry Robinson. There was an initial accident that occurred on Park Howell. You heard testimony that that accident did not involve this defendant. She had made no contact with the defendant. There was no argument with her and the defendant. Her vehicle was not struck. That accident had nothing to do with her. She didn't get close enough, she stated, to smell any alcohol or the odor of alcohol in his breath. She just interjected herself in a situation that had nothing to do with her. Now, what she wants you to believe is that when Terry Robinson was speaking in the background and he said, go, 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 that meant for her to jump in her car, chase down Mr. Herring, block his car off, apprehend him, and detain him. And we know that's simply not true. Because what you hear on the 911 call with Mr. Robinson, the only thing he says, and the only thing he said was, take a picture of the tag. Now, if we are to believe that take a picture of the tag means this, and you also heard from Terry Robinson that the defendant was already in her vehicle. She was already in motion. She was already prepared to do what she felt she was supposed to do in this situation. And then you hear the 911 call. And you hear the 911 operator tell her, once they realize she's chasing Mr. Herring, ma'am, we advise that you do not chase or follow. And she said she understood 100%. But yet she still continued. And you heard testimony from Ashley Jackson that she was speeding down Forest Parkway so fast, weaving in and out of traffic. I mean, she is chasing Mr. Herring, almost causing accidents, almost running other people off the road. And you heard the defendant say, and when I finally caught up to him, I had an opportunity. Because in her mind, she was going to stop that vehicle by any means necessary. And she did. And it's unfortunate for Mr. Herring. And you also heard testimony of the rage she had, how angry she was, how aggressive she was. But when she stood on the stand, when she got on the stand yesterday, everything was so calm. And when her attorney is asking her questions, she has every answer detailed, laid out, how she was just a people person. She was just trying to do things to help. She wanted to help all the other drivers on the road. And when I was asking her questions, she became very combative and aggressive. And it was always my perspective, what I thought. No, the 911 officer, our dispatcher did not tell me to not follow, not chase. Because she knows best. And at the end of that 911 call, after she shot Mr. Herring, her whole attitude, I'm safe, but he ain't. But she wants you to believe that she was concerned and she wanted an ambulance and she wanted to assist and she wanted to help and make sure he was okay. She didn't care about Mr. Herring. The defendant had multiple opportunities to do something else, to go back to the incident location, to go back home, not pursue. This had nothing to do with her. And the idea that she could command somebody to do anything. The only person that introduced a deadly weapon in this situation was the defendant. And but for her introducing that firearm, Mr. Herring would still be here today. You can't poke a bear and then when the bear turns around and attack you, want to claim self-defense. It doesn't work that way. She should have minded her own business. Now, this is the real reason we're here today. Now, the law doesn't allow us to talk about Mr. Herring's background and history and go into details about that. But there is no reason, absolutely no reason Mr. Herring shouldn't still be alive today, preparing to spend the holidays with his family and friends. There's absolutely no reason. And but for the defendant's actions on May 7, 2019, he would be. You saw and heard the evidence. And all of the evidence points to one conclusion, that the defendant is guilty. Now, you won't be able to take back the videos and the audios of the 911 calls as you deliberate, but if you want to be able to listen to those again, to see them, just let the bailiff know, and we'll let you do that. But this isn't a complex case. The defendant had no right to do what she did. None. And so I'm going to ask that as you deliberate, that you find her guilty on each and every count in the indictment.
At this time, I'm going to charge you with respect to the law that you must apply to the facts of this case. It involves quite a bit of reading, so I ask for your attention while I read. Of course, you will also get a copy of the charges to take back with you. You are considering the case of the state of Georgia versus Hannah Renea Payne, who is charged with malice murder, felony murder, aggravated assault, false imprisonment, and possession of a firearm during the commission of a felony in violation of certain laws of the state of Georgia. The indictment you are now considering in substance reads as follows. Count 1. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of malice murder in violation of OCGA 1651A for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did unlawfully with malice aforethought cause the death of Kenneth Herring, a human being, by shooting him with a firearm. Count 2. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of felony murder in violation of OCGA 1651C for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 while in the commission of the offense of aggravated assault as alleged in count 3, a felony, did cause the death of Kenneth Herring, a human being. Count 3. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of aggravated assault in violation of OCGA 16521 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did make an assault upon the person of Kenneth Herring with a firearm, a deadly weapon. Count 4. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of felony murder in violation of OCGA 1651C for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 while in the commission of the offense of false imprisonment as alleged in count 5, a felony, did cause the death of Kenneth Herring, a human being. Count 5. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of false imprisonment in violation of OCGA 16541 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 in violation of the personal liberty of Kenneth Herring did unlawfully detain Kenneth Herring without legal authority. Count 6. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of possession of firearm during commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm, a firearm, during the commission of the crime of malice murder as alleged in count 1, a felony, a crime involving the person of Kenneth Herring. Count 7. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renee Payne with the offense of possession of firearm during commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm, a firearm, during the commission of the crime of felony murder as alleged in count 2, a felony, a crime involving the person of Kenneth Herring. Count 8. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renee Payne with the offense of possession of firearm during commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm, a firearm, during the commission of the crime of felony murder as alleged in count 4, a felony, a crime involving the person of Kenneth Herring, contrary to the laws of said state, the good order, peace, and dignity thereof. Tracy Graham Lawson, District Attorney, Clayton Superior Court, August 2019. Issue and plea of not guilty. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Presumption of innocence, burden of proof, reasonable doubt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to find the defendant guilty. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to find the defendant not guilty. Bare suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Jury, judges of law, and facts. Members of the jury, it is my duty and my responsibility to determine the law that applies to this case and to instruct you on the law, which is what I'm doing. You're bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in the charges to the facts as you find them to be. Evidence generally. Your oath requires that you will decide this case based on the evidence. Evidence is a means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct and circumstantial evidence. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is a proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. To warrant a conviction on circumstantial evidence, the proven facts must not only be consistent with the theory of guilt, but must exclude every other reasonable theory other than the guilt of the accused. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Give me 1 second, I need a water break. Credibility of witnesses. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Expert witness. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You're not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. Witness impeached. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Prior statements. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Prior inconsistent statement, substantive evidence. Should you find that any witness prior to that witness's testimony in this case from the witness stand has made any statement inconsistent with that witness's testimony from the stand in this case, and that such prior inconsistent statement is material to the case and the witness testimony, then you are authorized to consider that prior statement not only for the purposes of impeachment, but also as substantive evidence in the case. Single witness corroboration. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Immunity or leniency granted witness. In assessing the credibility of a witness, you may consider any possible motive in testifying if shown. In that regard, you are authorized to consider any possible pending prosecution, negotiated pleas, grants of immunity or leniency or similar matters. You alone shall decide the believability of the witness. Statement of the defendant. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of her constitutional rights. Voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent defendant was informed of his or her rights, as discussed below if applicable. Burden of proof as to voluntariness. The burden of proof is upon the state to establish that the statement was voluntary, that is freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. Constitutional rights. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. The defendant had a right to remain silent. If the defendant chose not to remain silent, anything she said could be used as evidence against the defendant in court. The defendant had a right to consult a lawyer before any questioning and to always have the lawyer present with her during any questions, and if the defendant did not have money for a lawyer would have been provided for her to represent her any questioning and to be present with her during any questioning. Burden of proof as to rights. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given by the defendant. Conditions precedent consideration of statement. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict except for purposes of attacking the credibility of the witness or impeachment. DNA. Evidence related to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence related to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Definition of a crime. The defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of the state in which there is a joint operation of an act and intention. Intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it did exist from the facts before you. Intent may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is a natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by law. Accident. No person shall be found guilty of any crime committed by misfortune or accident in which there was no criminal scheme, undertaken, or intention, or criminal negligence. An accident is an event that takes place without one's foresight or expectation, that takes place or begins to exist without design. If you find from the evidence in this case that the incident that is the subject matter of this case occurred as a result of misfortune or accident and not as a result of a criminal undertaking or criminal negligence, then it would be your duty to acquit the defendant. When the issue of accident is raised, the burden is on the state to negate or disprove it beyond a reasonable doubt. Any evidence as to misfortune or accident should be considered by you in connection with all of the other evidence in this case. If in doing so, you should entertain a reasonable doubt as to the guilt of the accused, it would be your duty to acquit. On the other hand, should you believe from the evidence as a whole that the defendant is guilty beyond a reasonable doubt, you may convict. No presumption of criminal intent. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Presumption and inferences. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within your discretion. Venue. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Clayton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense is. Venue must be proved by direct or circumstantial evidence or both. Malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as a term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Motive. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault and false imprisonment are felonies, which I will define for you shortly. Causation in felony murder. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault or false imprisonment, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Aggravated assault. Thank you for your attention so far. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. Firearm as a deadly weapon. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. False imprisonment. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, she detains such person without legal authority. Excuse me, another water break. Thank you. Firearm during the commission of crime, possession of. A person commits the offense of possession of a firearm during commission of a crime when the person has on her person a firearm during the commission of or any attempts to commit a felony, which is any crime against or involving the person of another. The offenses of malice, murder, aggravated assault, false imprisonment, as alleged in these counts, are felonies under the laws of the state, as previously stated. Justification and the use of force in defense of self or others. Sometimes a defendant's threat or use of force is legally justified and so is not a crime. A defendant is justified in threatening or using force against another when she reasonably believes that the threat or use of force is necessary to defend herself against the other person's imminent use of unlawful force. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when she reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to herself, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if she provokes the threat or use of force against herself, intending to use that threat or force as an excuse to harm the other person. Is committing a felony. False imprisonment is a felony, which I have previously defined. Is the initial aggressor unless she withdraws from the encounter and clearly communicates to the other person her intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. Reasonable beliefs explained. For the defendant's threat or use of force to be justified, the defendant must believe that her threat or use of force is necessary. That belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary, and the defendant's reasonable belief must be what prompts her to threaten or use force. No duty to retreat. A person who is not the aggressor is not required to retreat before being justified in using force she reasonably believes to be necessary. Threats justifying a homicide. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger, the defendant is in imminent danger of serious bodily injury, or a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force, excessive force. A defendant is not justified in using excessive force while acting in self-defense. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. Revenge. A defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for the purpose of avenging a past wrong and not for the purpose of preventing an imminent death, serious bodily injury, or commission of a forcible felony, then you would be authorized to convict the defendant. The court has no interest in case, by no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in the charges. You're not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. Responsibility for sentencing. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. Deliberations. One of your first duties in the jury room will be to select one of you to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it is wrong. However, you should never surrender an honest conviction or an opinion just to be congenial or just to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You're also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Unanimous verdict. Whatever your verdict is, as I said, it must be unanimous. That is, agreed to by all of you. The verdict must be in writing and signed by one of your members as foreperson, dated and returned and published, that is, read in open court. Ladies and gentlemen, to assist you in reaching a verdict, the court is going to provide you with a jury verdict form. The form in substance includes a paragraph for each offense for which the defendant is charged, and there is a place for you to check not guilty or guilty for each count. Then there is a space for the foreperson to print their name and sign and date the form. Please fill out the form in blue ink so that we're able to distinguish the original form from any photocopies. I'm going to allow you now to retire to the jury room to begin your deliberations. but do not begin the deliberations rather until you receive the indictment, the verdict form, and any evidence that has been admitted in the case that the law says you can have in the deliberation room. Numbers 13 and 14, you will be sequestered from the jurors deliberating in this case. Do not discuss the case with anyone, including the bailiffs. Should one of the jurors not be able to continue, you will then enter the jury room and become the 12th juror in the order that you were selected. Thank you all. It is now 4:35. I can give you a break, a short break, and then ask you to begin the deliberations at 4:45. So I'm going to recess at this time, allow you to leave. You can take a bathroom break, and then I will ask you to begin the deliberations at 4:45. And again, do not begin until we give you the verdict form, the indictment, and all the evidence that you're allowed to have. Thank you so much.
Yeah, she's nervous Nelly. Oh, I ended the poll. Yeah, I figured you guys had enough time. Ah, shoot. I ended the poll already. I would have left it up, but I was actually going to stop that poll and start a new one to see if you guys thought they were going to start deliberations tonight or in the morning. And now,
Thank you. You may be seated.
yeah, I had a poll up, Joanna. The poll was, if you guys thought that that she would be found guilty of the malice murder charge. I didn't leave it up very long because I was going to.
So, counsels, we've already selected the evidence that will go back to the jurors. I'm going to include the charges, and I believe our court reporter, Ms. Brown, has the copy of the indictment. So they'll have everything they need to begin their deliberations.
And do they have the verdict form as well?
Let me. Do you have the verdict form here? There? Yes. Okay. Thank you.
Mr. Bunches. Hold on.
So yeah, what I was saying is that I stopped the poll for the malice murder. If you guys were, going to vote on that, I stopped it to start a different poll to see if you guys thought that they were going to start deliberations tonight or in the morning. With it being already 20 till 5.
Is there anything further that the court needs to address before we recess? We should have telephone numbers if there are questions that arise while they're deliberating. Then certainly the court will notify counsels. Oh, I'm talking without being on record.
Go ahead.
That was just practice.
Okay, I'll go right ahead.
Judge, we just need to note any objections to the charge. The state did not notice any errors and has no objections to the charge.
And counsel for defense.
Your Honor, we appreciate that you gave us extra time to look at it. I think any objections we had were taken care of and corrected, and the final version was fine with no objections from the defense.
Okay, thank you, counsel. Okay, as I was saying previously, we do have telephone numbers that we're able to reach counsels if there are questions that they pose to me. Definitely, I will alert you. I will bring them back in if there's a need to in terms of explanation, but I will confer with counsels before I do so. Okay, thank you. So we stand recessed for the evening. Yes. not counsels, but anybody else in the courtroom that needs to leave, we are recessed. Counsel. Right, they're going to be deliberating, but if anybody wants to leave at this time, certainly
No, they
they're
just
free to,
usually write it on
because
the
all that's going to
notepad.
happen will be.
All right. Every time I turn the mic on to say something, then then they pop back in. But yeah, I didn't get the other poll up. And Lisa, no worries on that. The
big picture in there.
Oh, what was I gonna say? I lost my train of thought. I'm good for that. I'm good for that. Yeah, I don't know what I was gonna say. I don't remember now. Mary Lou says they'll be back by midnight. LOL. Yeah, I don't know how long it's gonna take. And the judge didn't really say, or if she did, I missed it. Sometimes the judges won't let them go too late through the night. So she might let them deliberate. They might decide to deliberate for a couple hours, call it a night, come back in the morning, resume. I don't know. I don't know what they will end up doing. So, you think that they'll have? You think really that quick? Remember how quick the Murdaugh verdict was? Yeah. 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 I know. Well, how about, let me see how I should do this. Let me think about it for a minute. Because I don't want to stay live that long. Like all night, obviously, right? But I would love to watch the verdict live with you guys. Usually they'll set like a timer. And then the timer can be watched. I don't know. I think what I'll probably do is just end it here in a few, and then Nikki says you better or I'll be mad. Yeah, I don't know. Make a reminder. What do you mean, Joanna, make a reminder? Yeah, I want to watch the verdict live. Mickey says, Judge set a timer. I know you see us. Well, I mean, I'll keep, yeah, they do put up a verdict watch, right? And this stream here, once they put the verdict watch up, yeah, I guess I can watch for that and then start a new stream whenever they say that they've got a verdict. So I can keep my eyes peeled, and if any of you guys see that they've hit a verdict before the night's end, squall at me and let me know so I can jump on and start the stream quick. Or I think maybe what I could do is set up, I'm not sure. I need to think about it. I need to see what would be the smartest way to do it. I could stop this stream. 'Cause I don't know if you can even do a live stream. Like, how long can you stream for? You know what I'm saying? And this is already at almost 8 hours, so yee. I could stop this one and then start a Verdict Watch stream and let the Verdict Watch clock go. Hop in and out throughout the time, you know? So, Mickey says, someone go to the store and buy some beverages. I'm staying. Let me know thoughts in the... JC says she's staying. Lee says, LOL, Mickey Joe. Well, I don't know what to do. Let me head over to... Arthur is grilling some hot dogs and some wings. He's staying. Grill some hot dogs for me. Oh. Are you guys hearing audio? Or is that on my phone? No, I think I heard audio. Yeesh. What's Lee saying? Forget what? Go do your premiere, Joanna. No, I literally heard. I literally thought I heard. Did you guys hear? Like, very teeny tiny voices. I don't know. Let me see if they're going to start. I don't know how. Sometimes Law and Crime will start a new like Verdict Watch stream. And then sometimes they'll just continue. So let me run over on Twitter real quick and take a look. See what... latest. Ooh. They got some still shots of Hannah's face during the reading. Right? Oh, well, good. Dawn heard it, so I'm not the only one. Mickey's off the chain over there with too much coffee. Kath says Mickey's jealous the voices aren't talking to her. You guys are killing me. All right. Well, I'm going to take a break real quick. You guys can keep talking amongst yourselves. We will see if Law and Crime puts up a timer. Usually they put a timer up here somewhere, like a clock or something. We'll see if they do that, or if they cut this feed and start a new feed. It just depends on what they're going to do. So, but I'll be right back. I will be right back and we'll make a decision. I could, hold on, let me go over here and we will see what's going on in this other case. Let's see what's going on over here with this Bryce Rhodes. We'll do that and then start it over from scratch maybe tomorrow. Let me mute.
I can't remember the exact number of cases from that one.
Okay.
You were unable to find any other leads the next day, the next week, week after?
Yes, sir.
All right, so this is the Bryce Rhodes case. Kentucky versus Bryce Rhodes.
Family reasons, sir.
Let me just pause it real quick. So this is the Kentucky versus Bryce Rhodes. His trial started today. This is the one that I was talking about earlier today. And they had their jury selection, and now they are in opening, or they started with opening statements, but it looks like they're already into I'm not sure, one of the witnesses. I don't know who this guy is, but JC says they have some heathens. Who has heathens? Who has heathens? Oh, Lisa, that's amazing. That's amazing. I love that. Oh, and I hear Poppy scratching at the door. But I love that. I love it. So this Bryce Rhodes, I'm gonna start it back from the beginning, the opening statements, and we will kind of just let that play for a little bit while I figure out what I'm going to do with this verdict watch, okay? So I will make a decision on that here momentarily. We'll see. But until then, enjoy watching this. This story is Crazy Pants. And it looks like they have a nice view of the carpet and one of the seats. I see who's heathens. I see what you mean, JC, and you're right. You are right. Heathens. Oh, okay. These look like jury feet to me. Is this normal? Are these jury feet? These are jury feet. Wow. Those people, I don't know if they're jurors or not, but they came in house shoes. Please, cameraman, do not get the jury. If that's who it was. Okay, and the bald-headed guy is the Bryce Rhodes.
And Deputy Mills, if you want to come up to the jury box and get phones, so you all can sit down. While we're in the courtroom, your phones will go somewhere where you cannot access them. And when we go on breaks, you'll get them back.
You saw at least one pair of jury shoes, huh? Hilarious. Oh my God. There he is.
Thank you all for passing down. I appreciate that.
I saw on Twitter earlier he came into the courtroom eating snacks. Really? Wow.
All right, now, ladies and gentlemen, as I was saying earlier, we are ready to proceed with the trial of this case. You have been sworn in as jurors in the case of Commonwealth versus Bryce Jamar Rhodes.
Okay, she looks too young to be a judge.
3 counts of murder, 1 count of tampering with physical evidence, and 1 count of abuse of a corpse. I'm going to read the indictment to you. Under count 1, the allegation is that on or about the 4th day of May, 2016, in
Mercy
Jefferson County,
sakes.
Kentucky, Bryce Jamar Rhodes, acting alone or in complicity with another or others, committed the offense of murder by intentionally or under circumstances manifesting extreme indifference to human life, wantonly caused the death of Christopher Jones. Count 2, that on or about the 22nd day of May, 2016, in Jefferson County, Kentucky, Bryce Jamar Rhodes, acting alone or in complicity with another or others, committed the offense of murder by intentionally or under circumstances manifesting extreme indifference to human life, wantonly caused the death of Maurice Gordon. Count 3, that on or about the 22nd day of May 2016 in Jefferson County, Kentucky, Bryce Jamar Rhodes, acting alone or in complicity with another or others, committed the offense of murder by intentionally or under circumstances manifesting extreme indifference to human life, wantonly caused the death of Larry Ordway.
He acts like a loose cannon, Arthur. Okay, I'll be right back.
In Jefferson County, Kentucky, Bryce Jamar Rhodes, acting alone or in complicity with another or others, committed the offense of tampering with physical evidence when, believing that an official proceeding may be pending or instituted against him, he destroyed, mutilated, concealed, removed, or altered the physical evidence which he believed was about to be produced or used in such official proceeding, with the intent to impair its verity or availability in the official proceeding. Count 5, that on or about the 22nd day of May 2016 in Jefferson County, Kentucky, Bryce Jamar Rhodes, acting alone or in complicity with another or others, committed the offense of abuse of corpse when, not authorized by law, he intentionally treated a human corpse in a way that would outrage reasonable family sensibilities. And count 6, that on or about the 22nd day of May 2016 in Jefferson County, Kentucky, Bryce Jamar Rhodes, acting alone or in complicity with another or others, committed the offense of abuse of corpse when, not authorized by law, he intentionally treated a human corpse in a way that would outrage reasonable family sensibilities. I'd like to briefly tell you how we'll proceed. In this case, just like any criminal case, the Commonwealth will make an opening statement. The defense then will have an opportunity to make an opening statement if they wish to do so. Opening statements are not evidence. But they are an opportunity for the attorneys to advise you up front of what they think the evidence will be and what will be important to pay attention to. After opening statements, then evidence begins being presented. The Commonwealth will present evidence in the form of sworn testimony by witnesses or by exhibits. At the conclusion of the Commonwealth's evidence, the defense may present evidence, but they are not required to do so. At the conclusion of all of the evidence, I will instruct you on the law that you must apply to this case, and I will read instructions to you, which you will also get a copy of. After I have instructed you on the law of the case, the attorneys will have a chance to make closing arguments to you, which again are not evidence, but are an opportunity for them to sum up what they believe the evidence did show and perhaps how you should find. Now, I've talked to you a lot about the admonitions in this case, but I'm going to go through it one more time, and will remind you upon leaving that you must follow the admonition as well. You must decide this case based solely on the evidence presented here within the four walls of this courtroom. During this trial, you may not use internet search engines, websites, blogs, or use any other electronic tools to conduct any research about this case, to post information about this case, or to help you deliberate on this case. During the course of the trial, you are not to communicate online with anyone connected to the trial, including witnesses, lawyers, other jurors, experts. Do not record or photograph any part of these court proceedings because that is prohibited by law. If you accidentally encounter information about the case from any source outside of these four walls, it is your duty to bring it immediately to the attention of the court. All right, Mr. Cunningham, are you ready for opening?
The Commonwealth is ready now.
Thank you. Go ahead.
Opposing counsel. Ladies and gentlemen of the jury. Callous and casual was the first murder. The two that followed were calculating and cruel. In May of 2016, Bryce Rhodes snuffed out the life of Christopher Jones, Larry Ordway, and Maurice Gordon. The evidence is going to show that these acts occurred basically as two acts. And so if this were a play, these would be the characters that are involved in the first act. We have Maurice Gordon and Larry Ordway. Despite having different last names, these two are brothers that live together. They went to school at Olmsted. They liked playing basketball. They enjoyed rapping. They were always hanging out together. They had a home, they had a family, but from time to time, they would be out of the house for a few days. That wouldn't be anything unusual for them. They were born 2 years apart and a day, so they almost had the same birthday. And unfortunately, they both died on the same day, which we'll get to a little bit later. So these two brothers that were always hanging out together, 16 years old and 14-year-old, were friends with several people, one of which was Ja'Cory Taylor. Now, Ja'Cory, you're going to hear testimony from him. He's going to testify. He had a rough go of it. He had lost his job at White Castles. He was in and out of people's houses. He would stay in the stairwell at his girlfriend's house. He was just kind of on the boundary of things. And he was friends with both Larry and Maurice. And Jacory goes by Corey also sometimes. And Maurice Gordon also goes by Maurice. And they were mutual friends.
I see you, Steph.
with
I
Bryce
see you.
Rhodes, the defendant here, who went by Rambo. Rambo, Bryce Rhodes, was 25 years old at the time in 2016 when he's hanging out with 14-year-olds and 16-year-olds. Jacory was 17 years old. And there's one more person in this friend group. Antoine Carter, right here. And he goes by Buddha. And he was just a friend of theirs that would hang out. So, as they were hanging out, an idea came about. This is a picture of Larry and Maurice, Mr. Rhodes, the defendant. It's a picture of Antoine.
What in the world happened? What happened? I don't know why they say it's unavailable. Let me see. Hold on a minute, you guys. Hold on a second. Looks like they've either privated the video, maybe they took it down momentarily. Hold on, hold a phone. See if I can figure it out. Yeah, it looks like they probably privated it. So maybe more than likely what's happened is, well, I mean, a lot of times what will happen is, whenever the day is over, sometimes they'll like private the stream and then go through and make any edits or redact anything that they want out of it. Any sort of edits they need to make. So, and then they'll put it back up. That's usually what happens. So we'll see if they do that. My plan was to actually stream that tomorrow because I didn't think, oh, did he start acting cray-cray, JC? Maybe. I don't know. I don't know. Yeah, I'm looking, just to kind of see. But I'm not seeing anything right now. Let me run over here. Twitter is usually like your best friend for like up to date info. Let's see what we find. Okay, they're saying court is adjourned until tomorrow morning for the Bryce Rhodes trial. So, yeah. We'll have to go back and see tomorrow, probably. State's first witness is Officer Thomas Franklin. He is the one that responded to the scene of the Christopher Jones shooting. So, and apparently the judge's white noise that she turns on during the sidebar sounds like a toilet flushing. So that's fun. Anyway, let's go back over here and see what is going on. It doesn't really look like anything's going on here either in the Hannah Payne. I figured they would have put the verdict watch clock up already. I saw the moderator over there said she was going to. She hasn't done that yet, but she's probably swinging all these different trials and trying to keep things straight over there. I can imagine that's a train wreck and a half, right? So, you never know. He could have started acting cuckoo cuckoo pants, right? I don't know. I haven't watched him long enough to know. I haven't like really watched a lot of the previous videos other than just what I showed you guys yesterday. So, let me see if I can reload. Day one for his trial. Nope, it still says unavailable. It says it's privated. And I think what I'll do is just go ahead and keep the stream up for the verdict watch on Hannah's case or trial, and then keep an eye on it randomly popping in. And if something happens, then I'll turn the camera on and we'll watch it together. I'd say what we'll end up seeing shortly will be the judge telling them to go home for the evening, but you never know what will happen. Let me close out this tab here and It's loading, loading, loading. Come on. Work with me. Work with me, YouTube. I just don't see him being close this early on. I could be wrong. I mean, stranger things have happened, but I mean, my luck, I would turn the stream off and then poof, they plop out a verdict, you know? But with that many charges that they have to, you know, go over, I don't see it happening tonight at all. I really think it's going to be tomorrow, like midday. But that would be my guess. And goodness knows, I'm wrong more than I'm right. So, in this stream, it's being a big patootie. I keep getting the loading. Maybe if I stop it and refresh the feed, let me do that, because that might be what it needs. That judge, though, in this Bryce Rhodes case, she looks really familiar to me. I don't know why, but she does. Tammy, we are still live. They're on verdict watch for Hannah Payne. They're on verdict watch, but I'm just trying to get the stream to refresh. All of a sudden, it decided to go slow mode on me, and trying to get it to act right, act like it's got some sense, but it's not listening to me. See how it's like, yeah, my internet's being poopy pants. Oh, JC said, in one case, we did come back with a verdict in an hour, but that was only one. The man had 3 charges. What case was that? What case was that? Sorry, I'm just fiddle farting around, trying to get this to work. Jurors have been deliberating for 50 minutes. I don't know why this stream is being so slow. It is not wanting to work. Oh, JC says, yes, girl, it was a case with 70 and 80-year-old people in it, involved sex, so I was mad. Oh my God, I can't. Oh my God, I can't. No. What were the names involved in that one? I may have watched that. I don't know. I don't know. There was one recently with an older gentleman, or maybe a couple that I've seen lately. There was the one, I can't remember their names now. Shoot. But the woman had been found in the ditch. Like this trial just ended a couple weeks ago, maybe. The one I'm thinking of. I think the like hashtag that the networks were using was like dead in a ditch or something like that. Mm. And it kills me whenever when the verdicts are being read and they're standing there and they're listening to the judge or whoever is reading the verdict and they say guilty, that their face don't even flinch. You know, I'm like, if I was innocent, I would be like, yeah, why? You know, there's no way I would be able to just stand there unless I was guilty, you know? Girl, I don't remember. It was in Oklahoma. It was funny. Oh, 70 and 80-year-old people having sex. Yeah. I don't know about that. Mm-mm-mm-mm-mm. So, okay. This is live now again. Again. See if I can get it to go bigger. Yeah, it's like, I don't know. Not wanting to work with me here. See, loading again. You guys, maybe I need to. I said the other night that my computer needed to take a good healthy dump. I think that's what I need to do is dump a bunch of stuff on it. That is what I need to do. But yeah, it's loading, loading, loading. But it says it's live. So I'll go ahead and continue to just fiddle around with this and make sure that it's streaming. We'll watch for a verdict clock to pop up on the screen. And watch for them to either come back with a verdict tonight or send them home for the evening. So I will keep an eye on it. And you guys just continue to chitter chatter in the chat, and we'll see you back in just a little bit.
request from the jurors. Oh, Ms. Brown. Mr. Smith can get them.
Huh?
All right, who's betting they're going home for the evening? Who's betting?
All right. So there's a request to see Cameron Williams' video.
They're wanting to see that witness's video. So they only get to see it one time. Like, I think they should have,
Okay, so while we have them here, they've also requested to see Officer Ryan Rich's body cam video and then Miss Payne's second 911 call.
Who's 911?
Pardon me?
I didn't hear who.
Miss Payne's second 911 call. Just let me know when you think you have it situated, A.D. Hunter.
You need the video? Oh, you have the video.
One time and then take it back. Once that, once with the 911, and once with the body cam.
Right. I mean, that's the request.
Okay.
And then I'll sort of gauge what time we break this evening.
I've seen him ask for things too, but I don't know. I just feel like I don't like the idea of him saying, they can see it one time and then they have to go back. Like, nah, sometimes you need to see things over and over and over and over and over to get it. to understand, or, I don't know. Like, I've seen them, sorry if I just made a bunch of racket with these headphones. I've seen them, go back with like zip drives and discs and thumb drives and all that kind of stuff before, I don't know. There's a lot of like video and audio evidence that you think that they would be able to see whenever they needed to, and not being like made to watch it closely because this is all you get, and then you have to go back. Hi, Courtney Taylor. Welcome to the chat. Very possible, JC. I swear I heard him during the closing say something about almost being done. It looks like some of you guys are about to fall asleep. Oh, goodness. Yeah, I'm getting shaky, hangry. I'm going to go grab something quick. And I will be right back.
Here we go.
Move the chairs. Stand over. I'll stand, for the short ones, I'll stand there, and then I can move back and sit down.
Okay.
So it's time to stop it.
All right, so we're ready to bring them in?
Yes.
Okay. Bailiff Innes, could you bring the jurors in, please?
The jurors are coming in, and I have not a healthy snack. It's Mike sells cheesy puff corn. It was the quickest thing I could grab till actual dinner happens. And JC, I need a piece of that cake. Can you imagine the long days for these lawyers and the judge? Those are such long days, especially the days like this. Oh, here they come. Here they come.
You may be seated. So I see there's a request to see the Cameron Williams video, so we're going to go ahead and play that for you now. Yes, sir.
Is it possible to, yes.
Is it possible to slow the video down? And we don't have IT at this time, so, we'll just play it the way that we can.
I just want to make sure the record's clear. Jurors requesting to play it again. Is that okay?
That's any objection?
I would refer to the rules of the court and how they address that. I'm not a judge, so I don't know, but I think the rules state whether they can or cannot.
I'm going to allow it to be played again. Is that what you wanted to see? Yes? Okay, so there's a request to see it one more time, so please go ahead.
Either way, pause it right there.
Oh, not fast enough. Sorry, I did it. Sorry, not fast enough.
Pause. Proceed. Pause.
Okay, that's good.
Is it?
Is that sufficient? Okay. We also asked to see Officer Ryan Rich's body cam video. Okay. Do we have that?
This guy said they just got a 41 right there, and the lady pulled out a 69 and shot at the other guy. sir. Stay with me, okay? Just keep breathing. Hey, what's your name? Just keep breathing, man, okay? I know it hurts. Keep breathing. Come on, like you look like. Hey, the hell, before it comes down, when you talk about something, come on, stay with me, man. Keep breathing, okay? He's probably got a wallet in his pocket. He's phone below you? Yeah. I'm assuming so. Stay with me, man. Hang tight. Come on, sir. Just keep breathing, okay? Keep breathing. Keep strong breathing. We got you now. We got you now. That's them coming up right now. Did I pulse somewhat? Yes. Yes. It's going to be the belly button. Abdominal area. Come on, man. Keep breathing, okay? Just focus on me right now. Keep breathing. That's all you got to do. Hey. 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 Keep your eyes open. Let me see you breathe. Breathe for it. You breathing, man. Stay with us. Hey, come on. Stay with me. Hey, we got
And then you also requested that you wanted Ms. Payne's second 911 call.
Clayton County 911 was the location. Yes, ma'am. I'm on Clark Howell and Forest Parkway, the intersection. I actually called about 20 minutes ago for an accident, and no one has shown up yet. But I am under the impression that the guy that caused the accident, who ran the red light, is drunk. And he's gotten back in his car, and he's looking like he's trying to drive away. Okay, can you get his tag number? Hold on, he's driving away. It's a red Dodge Dakota. Hold on. Okay, so he is going west, down Clark Howell, no, sorry, down Forest Parkway. Okay, so you couldn't get a tag number? No, but I'm catching up to him right now. Okay, ma'am, we actually do not want you to chase him. We just want you to be safe. I understand. I understand 100%. I'm just gonna get the tag number, if nothing else. But I am going west down Forest Parkway. And we almost up to him. I mean, his radiator is busted and everything. Quite honestly, I have no idea how he's driving this truck the way that it is. Okay. It is a Georgia Tag. License plate is RHA as in apple, 4859.
Okay. So if you can go back to that location where the incident happened, it's because someone is actually on the way to you guys now.
Okay, well, there's a police officer there, but he is drunk. I'm sorry, but I'm here to tell you I'm not going to follow him. Because he is going to cause another accident. So I'm going to stay behind him until an officer can get to us. But until then, I'm not moving.
Yeah, no, that's what I want. I want you guys to go back to the location where it happened, and an officer will be out there momentarily, okay? Ma'am. Ma'am.
And now he needs paramedics. I'll stay, but he ain't. Can you stay? You say what happened? Okay, ma'am, where are you guys located now? Ma'am. I don't know. I don't know. I did. No, I don't. Okay, ma'am. There's a police officer here now. Okay. Speak with them. All right.
Okay, so those were the requests for the videos and the 911 call. It's now 6:15. I can adjourn for the evening and ask that you come back tomorrow at 9 to deliberate. Are you willing to stay? Okay, all right. I'll give you some more time. So you may go back to the jury room to deliberate.
Wow, they're not ready to go home. They may have their minds made up and they may have said, we just need to see one thing and that's going to make what we need to determine what we need. They may be ready. They may be ready tonight, you guys. Yeah. If they know they're not going to come up with a verdict tonight, then why stay tonight? It's 15 after 6.
My understanding where we say that any evidence that's brought back out must be played the exact same way it was, with no commentary, the way it was presented in court, and to allow it to play 3 or 4 times to slow it down is improper in my humble opinion. It's not supposed to be that way based on the rules that say when they come out and ask to see something, it must be seen the same way they saw it. And that was slowed down, that was repeated, and that's not the way it should have been.
Okay, and your response from the state?
Judge, I think what's in evidence is in evidence. They can view it the way that they choose to view it. It was not slowed down. It was played at the same speed.
It was paused.
That's what the jurors requested. They have 15 still shots of where the video was paused. So they already have pictures of it paused that are in evidence. So that's their request as to how to view the video evidence. I don't see anything inappropriate.
Like I said, I'm going by what my opinion of the rules are, and it says that they're supposed to be presented to them with no commentary in the exact same way it was done in court.
Okay. So I note the objection for the record. What the court saw was that it was not slowed down. There were times where they asked that it be paused, and that was paused, and it's a replication of what occurred before, except for the pauses, but that was their request for them. And in terms of seeking the truth, that's part of what we instructed them to do, which is to seek the truth, and they asked to see the video. So the court granted their request to see. Okay, so I'm giving them some more time to deliberate because that is their request. They're prepared to spend some more time. And so at an appropriate time when I feel that I should adjourn for the evening, I will. If there are other questions that they present to the court, then I will let you know. Thank you.
You guys, this might be really quick. What do you think? What do you think? What do you think? Sorry. Kiddo wanted the bag of Mike sells puff corn. Um, Twiggy said, I think so. Most jurors are ready to go home by now. That's what I'm thinking. I really feel like if they weren't close, they would have just said, "Yeah, we'll come back tomorrow." But the fact that they are like, "No, we want to go on back." Yeah, I would be very worried if I were her. You guys, who knows? Maybe they're like, "Nah." I mean, maybe they're in favor of her. I don't think so. But yeah. So yeah. Well, I'm gonna go see about real food now, and instead of snacks, I'll keep this up. We will keep on verdict watch. I have my phone in there on the charger because it's was like almost dead. So I've got my phone on the charger and I've got the feed up with the volume all the way up. So I will knock off the nonsense. I'm not just saying. I'm gonna go my only issue is I hope that they're not rushing to a verdict so they can go home. I know, Lee, I know what you mean, but I would be scared if I were her too, Don. I honestly don't think that they're in favor of her at all. I really don't. But you never know. I also didn't think they were in favor of Casey Anthony, but they were, so you know what I'm saying? You never know. Never know. To be a fly on the wall, right? All right. The dog and the kid are fighting over a bag of snacks. So I'm going to go get food, and I will be right back as soon as they decide to go home or decide to spill the verdict tea. All right. I'll see you in a few. It's true. It's true. They reached a verdict. Hold on a minute. Let me move this big thing in my face. Let me move it real quick if I can. Yay. Hold on. How do I make it do something different? I'm trying to see if I can make a... Yeah, okay. There we go. So yeah, verdict reached. They have to, like, get a hold of the family and the lawyers, and they're like, da, 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 da. Like, the judge don't you want them to go very far, so they should probably still either be in the courthouse or very close by. So I'm going to start a new poll. Let me go over there. See what we have, what we have, what we have. Okay. I have to start this one and then let the page load so I can get the poll started. Hold on so you guys don't have to see me struggle bussing. Yeah, too early for a hung jury. No, I don't think so. Lacey, that's a good point, she says. Sorry, I'm watching older parts of the video to catch up, but bringing up that there was a knife in his truck doesn't help her. If he would have stabbed her, he would have been within his right to do so. I mean, I agree with that. If you've got a gun in my face, you know? Okay. Let me mute this. Okay, so I have a poll up. It's in the live chat. It should be a box that says guilty or not guilty, and there's 3 different options to choose from. I can't remember. What did I put? Guilty on all charges, not guilty, or guilty on some, I think. Oh, what say you? Twiggy says if she's guilty, I'm sure lawyer will ask that she remain out on bond until sentencing. Hi, Becky Cover. She says guilty on all charges. Tammy thinks it was an accident, the gun going off. And just show the verdict. Hmm.
Stay of the sheriff's department at this time.
Oh, wait, whoa, 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 whoa! What happened? Oh, Lord, hold on. They are putting handcuffs on her. Hold on. Wait. I'm sitting here muted. Now I'm mad. I'm mad.
Okay, the court has been informed that the jury has arrived at a verdict, and so I'm going to bring them in at this time. Bailiff Innes, please.
Yeah, I'm angry. Big angry. How could it have been 40 minutes ago? They literally... I don't see how that happened. When was it, Twiggy?
So in the case State versus Hannah Renee Payne, case number 2019 CR 01737, court has been informed that you have reached a verdict. Is that correct?
Yes, ma'am, we have.
Okay, and are you the foreperson?
Yes, ma'am, I am.
Okay, if you kindly stand. Was your verdict unanimous?
Yes, ma'am.
Has the verdict form been filled in, signed, and dated by you?
Yes, ma'am.
If you would have the bailiff bring the verdict form to me, please. Mr. Foreperson, if you would go ahead and read the verdict.
With regard to count one, as to the offense of malice murder, we, the jury, find the defendant guilty. With regard to count two, as to the offense of felony murder, we, the jury, find the defendant guilty. With regard to count three, as to the offense of aggravated assault, we, the jury, find the defendant guilty. With regard to count four, as the offense of felony murder, we, the jury, find the defendant guilty. With regard to count five, as the offense of false imprisonment, we, the jury, find the defendant guilty. With regard to count six, as to the offense of possession of firearm during commission of a felony, we, the jury, find the defendant guilty. With regard to count seven, as to the offense of possession of firearm during commission of a felony, we, the jury, find the defendant guilty. With regard to count eight, as to the offense of possession of firearm during commission of a felony, we, the jury, find the defendant guilty. Respectfully submitted, the 12th day of December 2023.
Counsels, is there anything further required of this jury before I dismiss them?
If the court should hold the jury.
Okay. I will hold the jury. And so I'm just going to go sequentially and ask you a number of questions to which you will respond. Foreperson, was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Next person. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Was that your verdict in the jury room? Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Okay. Next. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Was that your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Okay. I have polled the jurors. Ladies and gentlemen, you have now concluded your service on this jury. You're no longer subject to or bound by the instructions that I've previously given to you about not talking to anyone about this case. You're now free to talk to anyone you like about the case and the decision that your jury has reached. By the same token, you're not required to speak with anyone about this case. That is your decision. However, sometimes the attorneys like to talk with you to ascertain your views about the evidence and input from how they could improve. But again, you're not required to speak to anyone about the case. That is purely your decision. Again, thank you for your service and your commitment to your jury duty this week. You are free to go.
Hanging out over here, they might just get
Right, you'll be outside the
over
courtroom?
near the steps.
Okay.
Over the elevator.
Wow, yeah, justice, justice, justice. Hi, the Honey 85. Hi, Isaiah and Lacey Henry. Hello and welcome back. Yes, justice for Mr. Herring.
You may be seated. Ms. Payne, I'm going to remand you into the custody of the Sheriff's Department at this time.
Thank you, Natalie. Natalie, by the way, hold on just a second before you skedaddle. Hold on. Before you go. That's what I thought, Twiggy. I was like, wow, her boyfriend is just like.
Counsel, what I do want to do at this time is set a date for the sentencing. My proposed date
Here,
is
Natalie.
December,
I'll be moving December 20th. Is that what she said?
which is next Wednesday.
Wow.
Yes.
All of the trial stuffs and true crime stuffs will move from here over to the new channel that I just created this morning or last night.
Okay.
So I'd love, though, for you, Natalie, and anybody else
Let you know.
to subscribe over there before you leave.
On Friday, I know you're already having court, and I'm already in court. The family's in from out of town,
Okay.
and they have traveled, and we are putting them up, and
Okay.
supposed to be here. Just for their convenience, we would request that this is to be on the 15th.
Okay. I believe I can accommodate that.
I have both county is 9 in the morning. I have
Awesome to hear, Natalie. Thank you. I appreciate that. I am so mad that I missed
Okay.
how that, I don't know what happened. I don't know if my feed froze, but I was literally watching it live on my phone. I don't know what happened. I don't know. Something happened.
We have 9 o'clock on Friday, correct? We could do it after. We could do it after. I could consider 10 o'clock on Friday morning. Okay. All right.
You were there,
Thank
Twiggy,
you.
yesterday.
Stands adjourned at this time.
Ah. What were you wearing? So we can find you from yesterday. Well, I hope that the Herring family, you know, feel like they got some justice, you know. It's not going to bring him back. That never does, but,
Okay. And those. The shovel. Yeah, go in the office. I'm just packing up.
Everybody's packing up and leaving. There goes her family. The kids are ruckusing and rockusing.
You want to take all of it?
Would you stop thumping and jumping through the house, little girl? Little girl.
Exhibit 1. Exhibit 1 is not listed unless I'm getting record. Oh, no, those were just, I didn't, when I...
The dad isn't leaving.
Okay, thank you.
I didn't see that. I didn't see him. Is he still sitting there? Have they not taken her out of the courtroom yet? Oh, yep, there's her dad. God love his heart. I'm sorry, y'all. I feel bad for him. I feel bad for the dad. Oh, he's just sitting there. Has she been taken out yet? Or is she still like in there waiting to go? Hannah was removed. Okay. Man, poor dad. Oh. Quit, Jolie. Yeah. I feel bad because on the first day, Dad was sitting there dozing off and falling asleep in the courtroom. And I was like, oh, look at Dad, sleepy deepy, blah, blah, blah. And then I felt bad because someone had brought to our attention that, you know, he hasn't been sleeping well, right? And, you know, he's got to be exhausted physically, emotionally, mentally, drained. And I just felt bad. Yeah, he was, but I didn't know if they were waiting on, I mean, she was, but I didn't know if they were waiting on something specific. He could have been. There he goes. Wow. All right, Georgia, Clayton County. It was good spending a few days with you. All right. So, sometimes, but it's who is available and eligible at that time. Yes, of your peers means more than race. This jail is all, hold on, let me turn off this feed. Let's see, what does he? Twiggy says this jail is always on the news for violence and deplorable conditions. The guards are corrupt, horrible place to be right now. Oh no. That's not good. That's not good at all. The Honey 85 says, I'm sorry, I don't feel bad for her family. They will still see her in jail. Mr. Herring's family won't see him. You're right. You're absolutely right. You know, I think I have seen things with my own family, friends, and their parents when things have gone south. And it's hard for me to not feel sorry for both sides. But you're right. They get to see her, and Mr. Herring's family will never see him again, you know. I suspect this case will be used in law classes and 911 operator classes. That would be pretty beneficial. All right, you guys. So, one more time, I'm going to put this, oh my goodness, this child of mine. I'm going to put this link in the chat. This is the link to the brand new crimey, it's called Crime Cafe channel that I will be hoping to, December 20th, Mickey, that I will be hoping to stream tomorrow. And I want to start with the Bryce Rhodes case. That is the job that I want to, you know, that's the one that I want to work on. So she does want me. Yeah, she wants me. Children are everything. Love them, teach them, and love them some more. Absolutely. J-Dog lives here. Yes, yes. Absolutely. So you guys, that link that I just shared, it's also in the pinned comment. I would love for you guys to subscribe over there and turn on all of your notifications. And yeah, will you quit thumping on the floor? Can you stop that? She's playing with the dog. Anyway, I'm going to try to go live over there tomorrow morning. If for whatever reason YouTube isn't letting me because it is a new channel, then I will be live here. But prayerfully, I will be over there. Okay? So, I will see you guys later. Please thumbs up the video, all the YouTubey things, and you guys have an amazing rest of your night. Bye. Hey, Morgana.